If I don't do nothing else, I'm gonna talk that law. Let's talk about it. But before I get started, for those who don't know me, I'm a Texas trial attorney. Going on my 5th year in the game. Y'all see the law license on the wall signed by the 9 justices of the Supreme Court. I was minding my business, and I was drinking my water. And they said we got trial again today, so let's see if we can pull it up and see where we at. Somebody say it's time for court already? Yes, already. I don't even see the stream link yet. So y'all, I guess they still getting it ready. So just give it a second and let's see what we can do. Let me see. Yeah, I don't see the link for the court. Hold on right quick, y'all. Let me see what I can find out. Hold up. All right, so I guess we're waiting on the court. Let me see. Oh, no. Come on. We need it live. We can't miss a second. Hold on, y'all. We're waiting on the court to get started, so let's see what we got.
We had a productive evening last night, and I understand that the parties have a proposal with regard to at least a portion of Mr. Copeland's testimony. Sorry, I didn't have this turned on. So what I said was, I trust everybody had a productive evening, and I understand that there is a proposal with regard to at least a portion of Mr. Copeland's testimony. So I'll hear what that might be.
Good morning, Your Honor.
Morning.
Simone Hilton for the state of Georgia. Last evening, myself and Mr. Shard had a brief conversation regarding the testimony of Mr. Copeland.
Yes.
I believe the defense counsel have to speak among themselves in order to determine what portions of Mr. Copeland's testimony they are asking to be kept. And so we believe that we need a copy of the transcript.
Okay.
So that they can have that conversation. Once defense counsel has that conversation, then they'll speak with the state about their proposals and we can move forward from there, Your Honor.
All right. So I don't believe that I think we have the 7th available. I don't know that we have the 11th and 12th yet, but I think we've reached out this morning to Ms. Weaver, the court reporter, and I know she has some other people working with her as well. So we'll endeavor to get that to y'all as soon as possible. And she's been pretty fast with the turnaround. So we may even have parts of it by the end of the day. So that seems like a reasonable approach. And then I would think that the next thing we can do, to the extent y'all feel like you want to revisit evidentiary issues with regard to any of the videos, or I don't think you had gotten to the jail calls yet anyway, but with regard to the videos, we can probably do that now. Don't think? Otherwise, give me something else we can do this morning.
Let's sit there and look at each other crazy.
Yes, we can do that. If you can, we just need that. We just need to get that material very quickly to the office, to the courtroom.
All right. Send somebody to go do that, please. And I'm, has anybody thought through yet, and maybe we'll have ready soon, any kind of potential instructions for what we're going to be telling the jury about either Mr. Copeland's testimony, well, I guess generally Mr. Copeland's testimony. And then I'll entertain what we're going to, I am going to say about the fact that here I am instead of Judge Glanville. But I mean, for that, I'm thinking essentially just, I don't know, some matter has required a substitution of judges, and that's about it. I don't plan to tell them really much more than that. They'll need to know why.
Your Honor, given the conversation Ms. Hilton had with the defense last night, in that some of them may be seeking to have some portions of it kept, depending on the court's decisions regarding our respective positions, I don't think we can craft at this point. For instance, if we decided, everybody said, let's just keep it, then we would just keep it, understanding that's likely not going to be the case until we know the respective positions and the court's ruling on that. I don't think we could endeavor to craft it.
Yeah, that may be true. Okay. Yes, sir.
Good morning, Your Honor.
Good morning.
Good morning to everyone. Your Honor, I wouldn't, and Mr. Adams can opt out of this if he believes it, but I'm objecting to anything except the unvarnished truth about Judge Glanville. I would like the court to tell the jurors the truth, that he has been found to be disqualified, removed from this case for his conduct. And that's my instruction that I worked on. That's what I'd like you to do.
All right, well, I'll consider everything once I've got everybody's proposed instruction, to the extent anybody wants to provide one for me to think about.
Thank you.
And Your Honor, I believe that the statute, if I'm not mistaken, regarding recusal specifically, speaks to the fact that that is not to be made a portion of the case in chief, of the main case. I'll get the exact language that I'm speaking of.
All right, great. Thank you. I appreciate that.
Put it in your motion.
Okay. Anything else?
Yes, Your Honor. We also briefly discussed yesterday the exhibit list, talking about how we can resolve working through the exhibit list. And my understanding from Mr. Shard, and I'm not sure if Mr. Kokomo was finished yet, but Mr. Kokomo, who's his legal assistant, and another legal assistant, we're actually working through the same thing that our legal assistant is working through. And our hope is, hopefully the court will be okay with this. By next Wednesday, our legal assistant would have gone through every video to assure we have all of the correct exhibits. But it's taking time because she's literally watching every single time.
I'm not okay with waiting until next Wednesday. I mean, I'm hoping, and it may be a false hope, but I'm hoping that we'll have a jury back with us by next Wednesday. So that needs to accelerate.
Okay, we will work on accelerating that list to get it to the court. But I believe that they're working on it as well.
Well, they need to accelerate as well if their thought was next Wednesday. I mean, like, I'm thinking this Friday, okay? Which is the day after tomorrow. All right, with regard to And you're talking about the videos of his testimony, right? Or are you talking about?
No, I'm sorry, I should have been clear. To confirm what exhibits have been admitted and not admitted. That's what we've been working on. No, that's
We can do that by Friday.
the giant list of exhibits.
Yeah, that's fine. That can be next Wednesday. That's not that urgent. As long as we've got that correct by the end of the trial, that's all that really matters.
Yes, Your Honor.
I thought you meant Mr. Copeland's testimony.
No,
Okay,
Your Honor,
all right. My misunderstanding then. Okay. All right. So with regard to the video interviews of Mr. Copeland, I suspect there are parts of those that the state knows they intend to be using or suspects very strongly they probably need to be using. So can we either come to some form of an agreement about evidentiary rulings that were already made, and or let's figure out what I need to do again?
Yes, Your Honor. I believe after we had the initial arguments regarding some of the redactions, some of the redactions we did concede on. So once I get that list, I can let the
Well, I've already seen those with regard to a couple of things, but I haven't gone through. I mean, I was looking at, for the transcripts I had, the arguments that y'all had already presented, and I saw that there were maybe like a couple, I don't know which, can't remember right offhand which dates I've already looked at, but there didn't seem to be that many that y'all just conceded. Seemed like y'all argued and needed a ruling for most things. But what I'm saying is, having argued it once and having gotten a ruling from a judge who knows what he's doing, whether y'all like him right now or not, do I need to re-listen to each argument and make my own determination, or can y'all agree that, hey, you know, the law, regardless of us arguing our various sides, the law probably is this, and we're okay with that ruling?
We believe out of them, we believe, and I'm sorry, Your Honor.
Go ahead.
Out of them, we believe that there might only be two that we think may need to be re-argued.
Okay.
We don't think there's any, at least from the state's perspective.
All right, that's good.
Your Honor, I'm speaking for myself. Yesterday, we received a transcript that was a transcript of an ex parte meeting that occurred on Friday.
Right, this is the
before
one.
Monday.
Sorry, sorry, just so that we're clear for the record purposes. This is the transcript I gave y'all at the end of yesterday that reflects Ms. Love had said, oh, yeah, we had, and in court on the record, but ex parte discussion that led to the Monday, June 10th ex parte. So that's what you're talking about?
Let me be more artful, yes.
Okay.
We were made aware, leading to the recusal of Judge Glanville, that there was an ex parte meeting that occurred on June 10th, Monday, June 10th. We were not told by the state, we're not told by the judge that had occurred. We found out about it, luckily, and by happenstance. We then demanded a transcript. We complained about said ex parte, inappropriate ex parte meeting. At no point, when the court finally acknowledged that there was an ex parte meeting that occurred on Monday, June 10th, at no point did the court or the state at that point acknowledge, oh, by the way, there was another ex parte meeting that occurred on June 7th.
Oh, wow.
We sat there after finding out about one ex parte meeting and having to drag the truth out. We sat there, and the state and their co-conspirator, the trial court, were silent about the first ex parte meeting that happened on June 7th. What happened in that meeting on June 7th? The state went in and disparaged defense counsel. The state, with no one else there, trashed a fellow member of the bar, Mr. Melnick, trashed another fellow member of the bar, Kayla Bumpus, presumed the guilt of all these individuals, including my client, Shannon Stillwell, and all but accused myself and Mr. Steele of being co-conspirators in this YSL enterprise. And the judge agreed. And the judge said in this ex parte meeting, yes, I've observed these things. The judge presumed the guilt of all the defendants. The judge presumed the guilt of myself and co-counsel, Mr. Steele. And all this, people have been saying to me throughout this whole trial, why does Judge Glanville have it out for you? And it never made sense. And I don't assume bad motives of anyone. Why did Judge Glanville, when you did nothing wrong, try to throw you in jail? Accuse you of cussing him out in open court when you didn't do anything? Why does he always tell you, yell at you, tell you to sit down and be quiet? Why does he cut you off at every opportunity? Why did he try to throw Brian Steele in jail for 20 days for doing what was right? And I didn't have an answer. And then yesterday I received, and I appreciate that, Judge. I appreciate someone finally being open about what's going on here. And I received a transcript. And in that transcript, the trial judge, who's not only assuming the guilt of my client, but is assuming the guilt of me and my friend, Mr. Steele. This is gross. This is disgusting. But it's all starting to make sense. It clicked when I read that transcript last night. This is not okay. Nothing about this is okay. These gentlemen have a right to a fair and impartial judge. And I appreciate the fact that you are going to be a fair and impartial judge. But the reality, Judge, is that they don't have a right to a fair and impartial judge starting on witness 76 of a trial after 9 months or whatever it is. They have the right to a fair and impartial judge from the beginning. And this is absolutely gross and disgusting. And the bottom line is there's a lot more discussions that need to be had about this. But the bottom line is, if you ask me, do we need to revisit the rulings of the judge who sits in chambers secretly and talks to the other side and says, yes, I've been observing this. I've been observing this about what's going on in the trial. The judge that says, not only I'm going to meet with you on Friday and on Monday, but if we need to talk during the weekend, yeah, we can do that. The judge that suggests handing Mr. Copeland a list of questions. Do we need to revisit those rulings?
Let them finish, Judge.
Absolutely, we need to revisit those rulings. We need to revisit everything. This is broken, and it's not okay. It's not okay. It's offensive, and it's not your fault, Judge. You didn't do this. I'm not trying to raise my voice at you. I'm heated right now.
I can tell.
My head, steam's been coming off my bald head all night.
I don't want that transcript.
Nothing about this is okay. Yes, we need to revisit everything. That's my stance.
Okay, thank you. And I think that I understand you being upset, and I understand why you and probably some of your fellow defense counsel on this side of the room are upset. I do not think that everything you said is a fair characterization of what that June 7th transcript reflects. But once we have the official copy, that'll be made a part of the record, and that will show what actually happened, what actually was said. As to any kind of legal error that may have been made with regard to rulings prior to Mr. Copeland's testimony, assuming this case goes forward and assuming there is any kind of conviction, I then assumed that there will be a motion for new trial phase, which at that point I can appropriately revisit things, and then potentially an appeal, at which point those things can be raised. I am considering and reading what y'all gave me yesterday to make a ruling on the substantive matters of that ex parte, and I can consider the June 7th ex parte as well, because I suspect y'all will ask me to do that. And if I determine that that is such, that there was coercion, that is unconstitutional or structural error, then I will grant a mistrial. If not, then the case will move forward and we can consider again all of the evidentiary rulings with regard to the videos and audios that might be used with Mr. Copeland, because that's the witness that we are on the stand with right now. I would, and I know this is hard to do, but I would like for everybody to try to take some deep breaths and move forward professionally. A lot of what y'all are talking about doesn't make it any easier, but it happened a month ago. I know tempers flared all around, but we need to move forward with this in whatever way it's going to move forward in a calm and professional manner, okay? So then with regard to what we need to do evidentially, I guess I will need to hear from the state as to what y'all think it's very likely for you to be using while you're examining Mr. Copeland, and then I will entertain evidentiary objections, responses, and we'll consider what's coming in.
Thank you, Your Honor. And we're getting that ready as we speak to present to the court. And I'd also like to thank Your Honor for the reminder regarding professionalism. I was going to ask that the court require that we all adhere to that. Being called co-conspirators is not something that I would expect to have heard, no more than I would expect to level an assertion that Mr. Sharp is a defendant. So I'd ask that that all sides be required to adhere to the court's admonition.
Well, again, the transcript will reflect what was actually said in there, and there are some allegations that if I were an attorney and it were leveled against me, I mean, I am an attorney, but you know what I mean, practicing in a case, I would be a little hot under the collar as well. Y'all had potentially legitimate concerns. I don't honestly at this point right now need to rehash all of that. But the reminder is to everybody, okay? And I mean, I've said it, so let's act accordingly.
Ron,
Yes, sir.
if I can address the court briefly. I filed a supplement to the Mr. Kendrick's motion for a mistrial this morning. I just want to make sure the court's aware of it.
I am aware of it. I have not yet had a chance to look at it, but that's got it.
Thank you, Your Honor. Mostly I want to make sure I bring it to the court's attention because again, and I've followed the request of the court to not argue what's already in the papers, but I just want to make sure that the court understands that based on this additional information that we learned about the July 7th meeting, that my client has been consistently denied his right to a fair tribunal. It's been a due process violation. I, like Mr. Sharp, am extremely upset having read that transcript.
Wow.
Myself and my fellow outside agitators over here, I assume that they are upset as well. And
I don't think, honestly, I don't think that that reference was to anybody who is a member of the bar. I think that there have been times in this case where members of the public are in the courtroom, which they are, of course, entitled to be, but communicating in ways that are not appropriate.
well, you know, the problem, Your Honor, is that since this was an ex parte meeting that should probably have never taken place, you were not there, I was not there, my fellow outside agitators weren't there, we don't have a video of it, so I have no idea specifically if that was not referred to us. And we don't know, do we? We don't know. And what I do know is that I have been arguing with people for 18 months that Chief Judge Glanville was doing his best that he was trying to rule to the best of his ability based on the evidence and the law
Not no
before
more.
him. And now I have been made to look like an idiot. So
Well,
I do not believe that this trial should continue, Your Honor.
I understand. Thank you. I'll take your supplement under consideration. Like I say, I haven't, obviously you just filed it and I haven't had a chance to look at it yet, but I will consider that in the overall context of the motion I was already considering. And, you know, I don't know that everybody's not going to want to come up here and do their 5 minutes of how outraged they are.
Oh,
if y'all
man.
feel like you need to get it off your chest,
Yes.
come on.
Come on. Come
Now's
on,
the
Steel.
time.
Okay, I got one more thing to say there. And then I'll sit down.
Okay.
And I don't believe that this is performative outrage, Your Honor.
I mean, I don't either.
Okay.
I don't either. I already said I understand.
In July of 2023, after months of me complaining about late discovery from the state, which should have been produced in December of 2022, when another terabyte or so tranche of discovery was produced to us, I begged Chief Judge Glanville to put a hard deadline on the discovery being produced from the state. He refused to do so. And you know what Judge Glanville's response to me was when I will tell you. I will tell you what his response was. If this was a civil trial, I would keep this out. But since this is a criminal trial, it's coming in. If this was a civil trial, if it was about money, I would keep it out. But since it's only about Mr. Kendrick's life, that last part obviously wasn't in there. But if this is a civil trial, I would keep it out. I've been a civil litigator for 25 years. I agree that if it was a civil trial, it would be kept out. What I'm shocked by, and I'm new to criminal, what I'm shocked by is that the standard would not be higher in a criminal trial. But what did I say to people? Chief Judge Glanville is doing his best. He is doing his best. And now, again, I don't even know what to say to my client, Your Honor.
All right. Well, you know.
What?
What do I say?
I don't know. Obviously, I don't know what to say right now either. But I think that.
Wow.
Well, again, I understand frustration. You know, let's be careful about disparaging
Oh,
a respected judge.
By who?
I do think that he has, and I haven't looked at every transcript yet because they haven't all been produced yet, but I don't think you're wrong that he has been trying his best and doing his best. And, you know, we all as lawyers know that everybody talks about lawyers trying to herd cats, and that's not inaccurate. This is a big case. There are a lot of good litigators on this case, but with a lot of good litigators probably comes a lot of egos as well. And I think sometimes it is possible to sort of get so enamored of your position and of winning a point that you are focused more on that than on backing down and taking a breath and being
I'm sick of her.
amenable to hear what the other side is saying. And hell, that's true in our whole society right now. Should have said hell, but y'all, I mean, all right.
Those were not my words. Those were Chief Judge Glanville's words. If this was a civil trial.
Well, I don't know why it was. I don't know what evidence you were talking about. I'm sure there have been evidentiary rulings that have been frustrating to both sides.
Come on here.
I will look at the two transcripts and I will make a ruling. And again, I don't think that the characterizations are exactly accurate, but I'll consider it all in context and I'll make a ruling.
Thank you.
All right.
And who next?
Anybody else, or can we move on to evidence?
Nope. Somebody else. So please, somebody else get
Mr.
up.
Steele.
There you go. They hiding another transcript, another secret meeting, and we just now finding out today.
There are 16, and good morning again.
Good morning.
Good morning, Madam Court Reporter. Ms. Winfrey, there are 16 hours approximately of the video audio you're talking about.
Okay.
And yes, we were going through to dissect objections, but I, and among others, really had an overall objection because the witness testimony, which is before the afternoon of June 12th of 2024, he agreed that he said these prior statements. So over objection, and the way I understand the law, the state shouldn't have been able to put it in at all. So I understand what you're doing. You know,
Okay.
We're going with you, but I just want you to know that we're not conceding that the way it came out, and obviously it's going to be redone after, I believe, I heard what you said yesterday. I agree that that's the law. I don't believe that it should come in at all. So before you tell us later, hey, why'd you make me do that?
No, I understand. And I think that Mr. Shard had actually put that particular objection in writing in one of your filings anyway, essentially that to the extent that Mr. Copeland said, yes, I said every one of those things to police officers, but every one of them was a lie. That is an admission that he made the statements. And the defense position, as I understand it, is as long as he acknowledges the statement, then nothing else is a prior inconsistent statement. And I'll hear from the state with regard to that, but.
I had one thing. Just another layer of that. Oh, I'm sorry.
Go ahead.
Just another layer of that is that the issue, the subject matter of these statements is largely the alleged co-conspirator statements, that our stance is that those were not in furtherance of conspiracy either. So there's like two layers of analysis.
Okay, thank you.
I'm sorry for interrupting.
Man, y'all need to go off.
You asked, I let you. But anyway, with regard to, does that make something said that is inconsistent in a prior inconsistent statement? And the state can provide me the law on that. But I think there are times when either an I don't remember or an I don't know or a, well, that was a lie, can still form the basis of making something a prior inconsistent statement. So, but
And Your Honor, I'm going to let Ms. Hilton speak specifically as to the law on factually what Mr. Copeland did say. What he said was, I don't remember anything that I told the police. I keep telling you, I don't remember anything. But if they say I said it, then I said it.
yeah, I think what they're talking about is he also at certain points said, yeah, I absolutely said that, and it was a flat out lie, and I'm paraphrasing, but that is what they're talking about, correct?
If that's what they're talking about.
Is that what y'all are talking about, Mr. Sharp, Mr. Steele? Yeah, so that's what I would like for y'all to address.
Your Honor, we believe based on two positions, OCGA 24-6-621, which be impeachment by contradiction, as well as a prior inconsistent statement that in both that statement, I said all that I said, but it was a lie, or I was trying to finesse my way out of being locked up, would lay the grounds of still allowing the prior inconsistent statement in to come in.
Okay, and the 24-6-621 is the
Impeachment
by contradiction, and 24-6-613 is essentially prior statements, right?
Yes, Your Honor.
So what I'd like is some case law that represents the proposition that you are asserting, okay?
Yes, Your Honor.
All right. And I don't want it just simply quoted out of a horn book. I would like the actual case law.
Your Honor, if you can give us a moment, just because we need to.
I mean, y'all, when I told you a week and a half ago that I wanted to be going through Mr. Copeland's evidence, y'all had 10 days or more to get ready for this. So I don't know what y'all thought we were going to be doing, but yes, I'd like to hear it. So if you need a minute to get me the law, go ahead.
Get them, Judge. Wow. So for the people popping in,
Is there, we can also do this portion after lunch and do something else right now, because I don't know that we all need to sit in court and do our research. What else could we do that's productive?
Keep talking about this secret transcript.
Yes.
I would like to make records. The Honorable Attorney John Melnick is under subpoena. He's in your courthouse, to my knowledge, or to my belief.
Okay.
I believe. If your court thinks that's good use of time, he is going to, I believe, take to task the statements of Lawyer Love.
All right. Well, tell me why that matters, because what may have been the actual truth and what Miss Love and or Miss Hilton perceived and therefore caused them to want to speak to the court ex parte don't really have to be the same thing. And I don't know that it matters whether what they thought was true was actually true.
So objectively, he will go through the emails for the court that were misrepresented by Lawyer Love. He will then, I'm making a record, God forbid there's an appeal as well as for your consideration
Lawyer
in
Love.
this case going forward about calling Judge Glanville as a witness, that he spoke with Lawyer Love. She knew that he represented Mr. Copeland. Lawyer Love said that she did not know that he had denied representing him, Mr. Copeland.
That Mr. Copeland had denied that Mr. Melnick represented him.
No, Lawyer Love stated that John Melnick had previously denied representing Mr. Copeland to Judge Glanville. And that goes to the heart of why is there a ex parte meeting in the first place? Because I don't know why there was, but Judge Krause I've objected to it. And I know you said maybe not, it's dicta, and I agree that it did not go to the holding or the ruling. And she didn't make long statements of fact or findings of fact. So I appreciate you saying, I don't know if these are findings of fact, but maybe just surplusage. But if that meeting is the way Judge Krause found, and there is a honorable Superior Court judge who made that ruling that's cemented in our case, that, I forget the line, but something like it was, maybe it should have been done in open court, but the substance may have been proper, something to that effect. If it was done in open court, I would have been able to be there to question Mr. Copeland. I would have been able to be, because the Judge Glanville said, do you want to you have questions for your lawyer, the state, or me? If I was there, I assume he would have said, or Mr. Steele. And then people were asking him questions. They were discussing his testimony. Those are things that we had a material right to be present for. So the point I'm trying to make.
Okay, well, I'm going to make a substantive ruling with regard to that. And I don't know how Mr. Melnick is going to add to that. I mean, it is clear to me from reading that June 7th transcript that the questions they had about whether Mr. Melnick represented Mr. Copeland were not, is he literally counsel for Mr. Copeland right now? I mean, they knew he was that because Ms. Hilton said when Mr. Copeland asked to talk to Ms. Hilton outside of the courtroom, and they were about to talk, Mr. Melnick either was there or appeared, and Ms. Hilton said, oh, you seem to want to talk to him, so I will let y'all talk privately, which if she didn't think Mr. Melnick were representing Mr. Copeland, wouldn't have done. I mean, there would have been no reason for her to do that. I think that it is clear in context that what they meant by we've got questions about whether he's representing Mr. Copeland is, and they said it, we have questions about whether he is representing Mr. Copeland's best interests, which as a lawyer, you are always supposed to do for your client. So I don't think they meant Literally, has he entered an appearance for Mr. Copeland, or has he represented to us and to the outside world that he is counsel for Mr. Copeland? It was, is he really acting in the best interest of Mr. Copeland? That's what they said they wanted to research and then meet with, or potentially meet with Judge Glanville about.
On the 10th, Lawyer Love said John Melnick, the Honorable John Melnick, stated that he was not representing Mr. Copeland. And Mr. Melnick said that is just a flat out misrepresentation of conversation.
Okay, well.
So I just want to get the record straight, because Georgia law, and I gave you these cases in a footnote. Georgia law right now, and I know I'm very familiar with this Honorable Court's very in-depth knowledge of the law. So right now, it's if the court finds, this court finds, or an appellate court, that Mr. Williams et al. Had a right to be present, that's at a critical stage of proceeding, it's over. The case, no one looks at prejudice. But the two cases that came out in April, one of them had been in January, but I cited them in the footnote of my motion to just educate
Okay,
the court.
well, if it's there,
I could give it to him, but yes, it's
that's
there.
fine, I'll jot it down.
But the Georgia courts are saying that is the law now, but we are interested in whether that is wrong,
Okay,
and we need to show prejudice,
okay. With regard to,
like federal.
give me the cases and what,
Step back.
okay.
But so I want to make a record of showing it was prejudicial because there were knowing misrepresentations to even have a auspices of a meeting with the judge.
Okay, well,
And I'm not agreeing.
I'm not sure if I follow you though, with regard to, I need to establish that Mr. Melnick was in fact counsel for Mr. Copeland, because even in the June 10th ex parte meeting, Ms. Bumpus was there as stand-in counsel for Mr. Melnick, because apparently Mr. Melnick had said he had a pre-scheduled vacation or something like that, which everybody knew about on Friday or before Friday. And they were saying, you know, how can he actually be representing him, i.e. the best interest, if he's off on vacation when this critically important thing for Mr. Copeland is going on. But here's his standing counsel, Ms. Bumpus. So they understood that technically, at least, Mr. Melnick was representing Mr. Copeland. So, I mean, that's, I can take judicial notice of that to the extent I need to.
I'm inarticulate then, because Mr. Melnick, I believe, is going to have testimony before your court for you to judge credibility.
Okay.
That what was said out of the mouth of the two prosecutors, Hilton, Love, are not true. There's no emails to back up what Love says. Ms. Hilton, there's not this Mr. Copeland, I need to speak with the DA. Those things have been unrebutted. They're just being said. And my point is, without that, then why are you questioning another lawyer's ethical duties? What gives you the right to say that to the judge? And then the courts need to know that's not true.
All right. Just like I said to the state essentially yesterday with regard to their motion that suggested that defense attorneys were violating bar rules in the way that they talk to the press, I am going to suggest to the defense that if the state is violating bar rule, or attorneys for the state are violating bar rules in the way that they talk about defense attorneys or in representations that they make to the court, that too is something that they may have to deal with the state bar.
I see, but I'm dealing with, my concern is Mr. Williams. So I'd like you to make findings, because I think that they go to the heart of, you're entitled to ethical prosecutors. We demand that. Ethical lawyers, ethical prosecutors, and a fair tribunal. That's constitutional as a fair tribunal. That did not happen here in my advocacy, in my viewpoint, the way I understand what happened. I wasn't there. So I can't talk about, I wasn't in the outside the courtroom when this supposed Mr. Copeland wants to talk with Ms. Hilton. I don't know. All I know is what, we do. We come in after the fact and we investigate. But I'd like to spread that on the minutes. So I raised that. I don't know, Mr. Melnick's
day-to-day or,
I don't know that.
but I'd like to call him.
I understand, and
You
I
don't
don't
care.
know that that is ultimately relevant to the determinations I have to make. Because again, whether what the prosecutors represented to Judge Glanville was true or not, maybe an issue for another type of tribunal. But in terms of whether it was then appropriate for Judge Glanville to okay the June 10th meeting to further flesh that out is what I need to figure out, right? So it doesn't really matter whether what they said was true for that purpose. It is, they told Judge Glanville what they told Judge Glanville. Was it reasonable at that point for Judge Glanville to entertain the ex parte on Monday, the 10th? Okay, so let me make that determination.
I'd like to call him if you change your ruling. Well, both of them, Judge Glanville.
You can proffer what he would testify to.
Then I need to, because he didn't see this new transcript, so I need to, he being Mr. Melnick.
Well, what's in the transcript shouldn't influence what's true. So
I would think, no, it doesn't. I would think that he can then say, or tell me and I'll tell you, and then you can hear from him if you want, that did not happen or this, I want to get it right.
all right, so you haven't talked to him yet about what? All right,
No.
well, obviously, I'll give you a chance to talk to him before you make a proffer because you need the proffer to be accurate.
Okay.
All right, so that's not something we can do right now either.
Thank you.
All right. So what can we do? And if there's nothing, then I'll just go back in chambers and I'll read all my cases that y'all gave me yesterday and I'll make some rulings so I can still be productive and y'all can be productive out here. You want to break for an hour and a half? Okay. All right, let's come back at 11.
Oh, wow. So,
Doesn't matter to me. Deputies, so if that's fine, that's fine, but I'm not going to ask them to stay here. They've got a lot of other work to do too. Okay.
all right. So, for the people that's popping in, apparently before court ended, what was it? Last night, before they left for court yesterday, it was revealed that there was another secret meeting held between the prosecutors and the judge and apparently the witness, maybe Kenneth Copeland. And whatever's on that transcript has the lawyers upset. They are upset. Whatever's in that transcript, and I know some people just popped in a little late. I just go back to Weinstein. He had a few minutes, and he pretty much was it Weinstein first or was it Matt Shard? Good morning, Tracy. Yeah, simply it's a lot. It's a lot. Let's just watch a few minutes of that while we have time.
Yesterday, we received a transcript that was a transcript of an ex parte meeting that occurred on Friday.
Right, this is the
Before the
one.
Monday.
Sorry,
And
I'm sorry, just so that we're clear for the record purposes. This is the transcript I gave y'all at the end of yesterday that reflects Ms. Love had said, oh, yeah, we had, and in court on the record, but ex parte discussion that led to the Monday, June 10th ex parte. So that's what you're talking about?
Let me be more artful. Yes.
Okay.
We were made aware, leading to the recusal of Judge Glanville, that there was an ex parte meeting that occurred on June 10th, Monday, June 10th. We were not told by the state, we're not told by the judge that had occurred. We found out about it, luckily, and by happenstance. We then demanded a transcript. We complained about said ex parte, inappropriate ex parte meeting. At no point, when the court finally acknowledged that there was an ex parte meeting that occurred on Monday, June 10th, at no point did the court or the state at that point acknowledge, oh, by the way, there was another ex parte meeting that occurred on June 7th. We sat there after finding out about one ex parte meeting and having to drag the truth out. We sat there and the state and their co-conspirator, the trial court, were silent about the first ex parte meeting that happened on June 7th. What happened in that meeting on June 7th? The state went in and disparaged defense counsel. The state, with no one else there, trashed a fellow member of the bar, Mr. Melnick, trashed another fellow member of the bar, Kayla Bumpus, presumed the guilt of all these individuals, including my client, Shannon Stillwell, and all but accused myself and Mr. Steele of being co-conspirators in this YSL enterprise. And the judge agreed. And the judge said in this ex parte meeting, yes, I've observed these things. The judge presumed the guilt of all the defendants. The judge presumed the guilt of myself and co-counsel, Mr. Steele. And all this, people have been saying to me throughout this whole trial, why does Judge Glanville have it out for you? And it never made sense. And I don't assume bad motives of anyone. Why did Judge Glanville, when you did nothing wrong, try to throw you in jail? Accuse you of cussing him out in open court when you didn't do anything? Why does he always tell you, yell at you, tell you to sit down and be quiet? Why does he cut you off at every opportunity? Why did he try to throw Brian Steele in jail for 20 days for doing what was right? And I didn't have an answer. And then yesterday I received, and I appreciate that, Judge. I appreciate someone finally being open about what's going on here. And I received a transcript. And in that transcript, the trial judge, who's not only assuming the guilt of my client, but is assuming the guilt of me and my friend, Mr. Steele. This is gross. This is disgusting. But it's all starting to make sense. It clicked when I read that transcript last night. This is not okay. Nothing about this is okay. These gentlemen have a right to a fair and impartial judge. And I appreciate the fact that you are going to be a fair and impartial judge. But the reality, Judge, is that they don't have a right to a fair and impartial judge starting on witness 76 of a trial after 9 months or whatever it is. They have the right to a fair and impartial judge from the beginning. And this is absolutely gross and disgusting. And the bottom line is there's a lot more discussions that need to be had about this. But the bottom line is, if you ask me, do we need to revisit the rulings of the judge who sits in chambers secretly and talks to the other side and says, yes, I've been observing this. I've been observing this about what's going on in the trial. The judge that says, not only I'm going to meet with you on Friday and on Monday, but if we need to talk during the weekend, yeah, we can do that. The judge that suggests handing Mr. Copeland a list of questions.
All right.
Do we need to revisit those rulings? Absolutely, we need to revisit those rulings. We need to revisit everything. This is broken, and it's not okay. It's not okay. It's offensive, and it's not your fault, Judge. You didn't do this. I'm not trying to raise my voice at you. I'm heated right now.
I can tell.
My steam's been coming off my bald head all night. Nothing about this is okay. Yes, we need to revisit everything. That's my stance.
Okay, thank you. And I think that I understand you being upset, and I understand why you and probably some of your fellow defense counsel on this side of the room are upset. I do not think that everything you said is a fair characterization of what that June 7th transcript reflects. But once we have the official copy, that'll be made a part of the record, and that will show what actually happened, what actually was said. As to any kind of legal error that may have been made with regard to rulings prior to Mr. Copeland's testimony, assuming this case goes forward and assuming there is any kind of conviction, I then assumed that there will be a motion for new trial phase, which at that point I can appropriately revisit things, and then potentially an appeal, at which point those things can be raised. I am considering and reading what y'all gave me yesterday to make a ruling on the substantive matters of that ex parte, and I can consider the June 7th ex parte as well, because I suspect y'all asked me to do that. And if I determine that that is such, that there was coercion that is unconstitutional or structural error, then I will grant a mistrial. If not, then the case will move forward and we can consider again all of the evidentiary rulings with regard to the videos and audios that might be used with Mr. Copeland, because that's the witness that we are on the stand with right now. I would, and I know this is hard to do, but I would like for everybody to try to take some deep breaths and move forward professionally. A lot of what y'all are talking about doesn't make it any easier, but it happened a month ago. I know tempers flared all around, but we need to move forward with this in whatever way it's going to move forward in a calm and professional manner, okay? So then with regard to what we need to do evidentially, I guess I will need to hear from the state as to what y'all think it's very likely for you to be using while you're examining Mr. Copeland, and then I will entertain evidentiary objections, responses, and we'll consider what's coming in.
Thank you, Your Honor. And we're getting that ready as we speak to present to the court. And I'd also like to thank Your Honor for the reminder regarding professionalism. I was going to ask that the court require that we all adhere to that. Being called co-conspirators is not something that I would expect to have heard, no more than I would expect to level a assertion that Mr. Sharp is a defendant. So I'd ask that that all sides be required to adhere to the court's admonition.
Okay, well, again, the transcript will reflect what was actually said in there, and there are some allegations that if I were an attorney and it were leveled against me, I mean, I am an attorney, but you know what I mean, practicing in a case, I would be a little hot under the collar as well. Y'all had potentially legitimate concerns. I don't honestly at this point right now need to rehash all of that. But the reminder is to everybody, okay? And I mean, I've said it, so let's act accordingly.
Ron,
Yes, sir.
if I can address the court briefly. I filed a supplement to the Mr. Kendrick's motion for a mistrial this morning. I just want to make sure the court's aware of it.
I am aware of it. I have not yet had a chance to look at it, but that's got it.
Thank you, Your Honor. Mostly I want to make sure I bring it to the court's attention because again, and I've followed the request of the court to not argue what's already in the papers, but I just want to make sure that the court understands that based on this additional information that we learned about the July 7th meeting, that my client has been consistently denied his right to a fair tribunal. It's been a due process violation. I, like Mr. Shart, am extremely upset having read that transcript. Myself and my fellow outside agitators over here, I assume that they are upset as well. And
I don't think, honestly, I don't think that that reference was to anybody who is a member of the bar. I think that there have been times in this case where members of the public are in the courtroom, which they are, of course, entitled to be, but communicating in ways that are not appropriate.
well, you know, the problem, Your Honor, is that since this was an ex parte meeting that should probably have never taken place, you were not there, I was not there, my fellow outside agitators weren't there, we don't have a video of it, so I have no idea specifically if that was not referred to us. We don't know, do we? We don't know. And what I do know is that I have been arguing with people for 18 months that Chief Judge Glanville was doing his best, that he was trying to rule to the best of his ability based on the evidence and the law before him. And now I have been made to look like an idiot. So
well,
I do not believe that this trial should continue, Your Honor.
I understand. Thank you. I'll take your supplement under consideration. Like I say, I haven't, obviously you just filed it and I haven't had a chance to look at it yet, but I will consider that in the overall context of the motion I was already considering. And, you know, I don't know that everybody's not going to want to come up here and do their 5 minutes of how outraged they are. If y'all feel like you need to get it off your chest, come on. Now's the time.
Okay, I got one more thing to say there. And then I'll sit down.
Okay.
And I don't believe that this is performative outrage, Your Honor. I
mean, I don't either.
Okay.
I don't either. I already said I understand.
In July of 2023, after months of me complaining about late discovery from the state, which should have been produced in December of 2022, when another terabyte or so tranche of discovery was produced to us, I begged Chief Judge Glanville to put a hard deadline on the discovery being produced from the state. He refused to do so. And you know what Judge Glanville's response to me was when I will tell you. I will tell you what his response was. If this was a civil trial, I would keep this out. But since this is a criminal trial, coming in. If this was a civil trial, if it was about money, I would keep it out. But since it's only about Mr. Kendrick's life, that last part obviously wasn't in there. But if this is a civil trial, I would keep it out. I've been a civil litigator for 25 years. I agree that if it was a civil trial, it would be kept out. What I'm shocked by, and I'm new to criminal, what I'm shocked by is that the standard would not be higher in a criminal trial. But what did I say to people? Chief Judge Glanville is doing his best. He is doing his best. And now, again, I don't even know what to say to my client, Your Honor.
All right. Well, you know.
What do I say?
I don't know. Obviously, I don't know what to say right now either. But I think that, while again, I understand frustration, you know, let's be careful about disparaging a respected judge.
Yeah, right.
I do think that he has, and I haven't looked at every transcript yet because they haven't all been produced yet, but I don't think you're wrong that he has been trying his best and doing his best. And, you know, we all as lawyers know that everybody talks about lawyers trying to herd cats, and that's not inaccurate. This is a big case. There are a lot of good litigators on this case, but with a lot of good litigators probably comes a lot of egos as well. And I think sometimes it is possible to sort of get so enamored of your position and of winning a point that you are focused more on that than on backing down and taking a breath and being amenable to hear what the other side is saying, and hell, that's true in our whole society right now. Should have said hell, but y'all, I mean, all right.
Those were not my words. Those were Chief Judge Glanville's words. If this was a civil trial.
Well, I don't know why it was. I don't know what evidence you were talking about. I'm sure there have been evidentiary rulings that have been frustrating to both sides. I will look at the 2 transcripts and I will make a ruling. And again, I don't think that the characterizations are exactly accurate, but I'll consider it all in context and I'll make a ruling.
Thank you.
All right. Anybody else, or can we move on to evidence? Mr. Steele.
So there are 16, and good morning again.
Good morning.
Good morning, Madam Court Reporter. Ms. Winfrey, there are 16 hours approximately of the video audio you're talking about.
Okay.
And yes, we were going through to dissect objections, but I, and among others, really had an overall objection because the witness testimony, which is before the afternoon of June 12th of 2024, he agreed that he said these prior statements. So over objection, and the way I understand the law, the state shouldn't have been able to put in at all. So I understand what you're doing. You know,
Okay.
We're going with you, but I just want you to know that we're not conceding that the way it came out, and obviously it's going to be redone after, I believe, I heard what you said yesterday, I agree, but that's the law. I don't believe that it should come in at all. So before you tell us later, why'd you make me do that?
No, I understand. And I think that Mr. Shard had actually put that particular objection in writing in one of your filings anyway, essentially that to the extent that Mr. Copeland said, yes, I said every one of those things to police officers, but every one of them was a lie. That is an admission that he made the statements. And the defense position, as I understand it, is as long as he acknowledges the statement, then nothing else is a prior inconsistent statement. And I'll hear from the state with regard to that, but.
I had one thing. Just another layer of that. Oh, I'm sorry.
Go ahead.
Just another layer of that is that the issue, the subject matter of these statements is largely the alleged co-conspirator statements, that our stance is that those were not in furtherance of conspiracy either. So there's like 2 layers of analysis.
Okay, thank you.
I'm sorry for interrupting.
You asked, I let you. But anyway, with regard to, does that make something said that is inconsistent in a prior inconsistent statement? And the state can provide me the law on that. But I think there are times when either an I don't remember or an I don't know or a, well, that was a lie, can still form the basis of making something a prior inconsistent statement. So, but
And Your Honor, I'm going to let Ms. Hilton speak specifically as to the law on factually what Mr. Copeland did say. What he said was, I don't remember anything that I told the police. I keep telling you, I don't remember anything. But if they say I said it, then I said it.
yeah, I think what they're talking about is he also at certain points said, yeah, I absolutely said that, and it was a flat out lie, and I'm paraphrasing, but that is what they're talking about, correct?
If that's what they're talking about.
Is that what y'all are talking about, Mr. Sharp, Mr. Steele? Yeah, so that's what I would like for y'all to address.
Your Honor, we believe based on 2 positions, OCGA 24-6-621, which would be impeachment by contradiction, as well as a prior inconsistent statement, both that statement, I said all that I said, but it was a lie, or I was trying to finesse my way out of being locked up, would lay the grounds of still allowing the prior inconsistent statement in to come in.
Okay, and 24, the 24-6-621 is the
Impeachment
by
by-
contradiction, and 24-6-613 is essentially prior statements, right?
Yes, Your Honor.
So what I'd like is some case.
All right, y'all. So right now we're on break. We're waiting for the court to come back. I think we got an hour. But thank you to Tia. She just sent me the second secret transcript. Do y'all want to go over it? Thank you again, Tia, for sending me that. Boy, Tia gonna be quick with it. Let's go through it and see what's in the second secret transcript, which was actually the first one. We just now finding out about it, but apparently this meeting happened before the first secret one, in the back room, in the closet with the lights off. What is going on in Fulton County? Let me pull this up, because this is, and we're going to be reading this together live, so I don't even know what's in it. Let me get out the way. Get down to the good stuff. So this is a motion that was filed by Mr. Weinstein. He's the attorney that represents DeMonte Kendrick. Oh, I wish I could. Hold on right quick, y'all. Let me see something. Let me see if I can make it a little bit easier to navigate without having to go through let's see, maybe this one will be a little easier to do it this way. How do I close this out? Okay, there we go. All right. So this was filed this morning at 7:15. He wasn't playing with him. So we got the state of Georgia versus DeMonte Kendrick. And this is a supplement motion for a mistrial. So basically a supplement is we already had reasons to kick off the judge. For the trial, but now we want the trial itself to go away. We want a mistrial completely. We got rid of the judge, the old judge. Now we want the trial to go away. It's a mistrial. It's a motion for a mistrial. And they filed an original motion, but now they have even more reasons of why the mistrial should be granted. So what they did is they added a supplement. It say comes now DeMonte Kendrick by and through his lawyers. Doug Weinstein. And he goes on to define outside agitator is a term that delegitimizes internal dissent against the status quo. So anyone who speaks up against the status quo, whatever that is by definition an outsider. And this came from Professor Dylan Pennygroff, UC Berkeley. Judge Glanville making outrageous allegations against members of the defense teams in the present case. But I think it does in some way outside agitators and everybody else who I think are trying to influence. So I believe this is maybe a quote from Glanville. Maybe we'll get to that at the bottom portion of this motion. Here we go. The third ground argued in Kendrick's motion for mistrial is that Kendrick's due process rights were violated relating to a 14th Amendment due process violation. related in part to Chief Judge Glanville wrongly coercing Copeland to testify. So we already know that in the back room, it was alleged that the judge was forcing Woody to testify. Basically, he was forcing him by threatening him with jail time. Further evidence of the state and Judge Glanville's violation of Kendrick's due process rights has just come to light. We just found out about it. We just found out about it this morning. Yesterday after court, Kendrick received a rough transcript. This is a rough draft, y'all. We don't even got the original Exhibit A of an additional secret ex parte meeting with Judge Glanville held on Friday, June 7, 2024. See, I've been telling y'all Judge Glanville was no damn good, but y'all didn't believe me. I was being too hard on him. The rough transcript was helpfully provided by this court to defense counsel. A reading of the rough transcripts highlight that which has been obvious to all observers, except for Kendrick's counsel, for the past 19 months. So what Doug is saying, Talk That Law was already saying Judge Glanville was no good. Everybody else was saying Judge Glanville was no good. Everybody except Doug Weinstein. And he said that the judge made him look like a fool because he was going around still defending Judge Glanville in his interviews on YouTube. And I was like, okay, you keep on defending him if you want to. I already know him. Judge Glanville has been willfully biased and acting as a member of the prosecution team since the inception of this case, since the very beginning. Kendrick's counsel takes no pleasure. I do. But he say Doug Weinstein takes no pleasure in alerting this honorable court to this situation. But his client's obligation requires it. Due process requires a fair trial, Glanville. It is not fair. It is not a fair trial when in the ex parte secret meeting in the back room with the lights off, Glanville, Love, and Hilton gossip. Not gossip. What is this word? Yenta? Over 13 pages of transcript about attorney Shara, Melnick, and Steele. What is this word, y'all? What is this? Hold on. Let me Google it. What is a Yentas? This is wild stuff. Okay, so it's pronounced Yenta, a woman who is a gossip or a busybody. Come on here, Weinstein. Y'all ain't saying nothing in the chat. Oh, man, he says Glanville in the back room gossiping like a woman, a busybody. What the hell going on this morning? Oh, man. It is not a fair trial when in the ex parte meeting, Glanville, Love, and Hilton assassinate the character of attorney Melnick and attack his integrity, alleging that he is not acting in the best interest of his own client, Woody. Now, that's wild when prosecutors go out of their way to say that a witness attorney is not acting in his own best interest. What they got to do with y'all? Y'all prosecutors. Let Woody worry about his own lawyers and legal problems. That ain't got nothing to do with y'all. But Judge Glanville in the back with the women gossiping like a busybody. That's what Doug Weinstein said. That's what he said. It is not a fair trial when in a secret ex parte meeting, Glanville, Love, and Hilton attack attorney Kayla Bumpus. Shout out to Kayla Bumpus for allegedly hugging Kendrick. And stating that she is incapable of representing Copeland. What? Wait a minute now. Hold on. So are they trying to say that Kayla hugged Kendrick? And since she hugged Kendrick, Kayla is not a capable attorney of representing Woody? What? Let's keep on going. Shout out to Kayla. It is not a fair trial when in the ex parte meeting, Love lied to Glanville about an email she received from Attorney Melnick. And we heard today that Attorney Melnick is present at the courthouse under subpoena because Brian still wants Attorney Melnick to call lawyer Love a liar to her face. It is not a fair trial when in a secret ex parte meeting, Judge Corrupt Glanville, Prosecutor Glanville starts talking about outside agitators, stating my comments today were predicated on there's a lot of stuff that's going on in the background, and it shouldn't have to do with, I'm thinking there's a word, do with anything with you all's case. It really shouldn't. But I think it does in some way outside agitators. So it seems that the judge is calling the attorneys, the defense attorneys, outside agitators. It is not a fair trial when in the ex parte meeting, Glanville and Love have the following outrageous conversation. What the conversation is, the court, this is Glanville. But I think it does in some way outside agitators, Miss Love, that too. Get on the court and everybody else who I think are trying to influence Miss Love. Look at her co-signing again. That is absolutely happening. And the rough transcript, pages 11 and 12. It is not a fair trial when Glanville, Love, and Hilton have this further discussion. They still back there running their mouths. Let's keep going. Miss Hilton, there's a lot going on. Miss Love, there is a presence. Yes, yes. That is all I'll say. What presence? A presence of light, truth, revealing y'all corruption. A presence of top that law. Yes, it's a lot going on. The court, but I see it from just being in the courtroom and tracking. Oh, yeah, y'all tracking all right because they said y'all were giving hand signals to each other. Let's keep going. Page 4. How many violations of the Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice? This is Doug Weinstein talking to the judge now, Judge Whitaker. He said, how many do you need, Judge Whitaker? With your bias self talking about Judge Glanville, you're not going to talk about him. He did it to himself. This case is like an old house that the present honorable judge is tasked with renovating. And I wouldn't trust her to put no nails in the new house because the house gonna fall to the ground. Every time a piece of pasted up wallpaper is removed, more rot is found hidden underneath. No, more rot. So he's saying that it is so bad that it's rot in the walls. It's rot all the way through the walls. No Herculean effort by the present court can fix the due process violation of the last judge. He's saying if you he said, I don't care how strong you are. Somebody emailing me. I'll email you back in a second. I don't care how strong you are, Judge Whitaker. I don't care if you Hercules. I don't care if you can lift up the whole courthouse. You can try as you may, try as you might. And I said this yesterday that this trial can't go forward. It's a no Hercules effort. Shout out to Hercules. I don't know that one. That's back in the day. No matter how much of strength you have, the present court can fix. Basically, you can't fix it. No amount of strength can fix the due process violation of the last judge. This house must be torn down to the ground. A mistrial should be declared and a retrial barred due to prosecutorial and judicial misconduct that has goaded Kendrick into the present motion. They say tear the whole house down. Matter of fact, tear the courthouse down. And while y'all tearing the courthouse down, go tear down that raggedy jailhouse that y'all got. Go tear down the Fulton County jail while y'all at it, because it's been said that nobody in that jail is safe. And we already know that a member of this trial was stabbed in the same jail. Not the Better Business Bureau, Rob. Come on. Let's keep going. Wherefore, Kendrick respectfully continues his request that this honorable court declare mistrial based on at least due process violations of Kendrick's constitutional rights under the federal constitution and the constitution of the state of Georgia, signed this 31st day of July, 2024. We thought the fireworks was over on the 4th of July, but we getting fireworks on the last day. Respectfully submitted and signed by Douglas S. Weinstein himself. The ABT law firm, come on, in Atlanta, Georgia. Let's look at the transcript. We got a transcript, Exhibit A. Let's go through it. Let's go. 2:45 p.m., Miss Love. Lawyer Love, Judge. The reason that I specifically wanted to talk with you is that I have a concern about the representation being made of the representation of Mr. Copeland. So we have the prosecutors worried about who's Woody lawyer. I don't care if it's Kayla. I don't care if it's Melnick. If he has a lawyer, state that ain't y'all business. As long as he has a lawyer, y'all done all y'all can do. I am concerned, and I am sort of not. I wanted to just bring it to the court's attention. Mr. Melnick has not conveyed to either Ms. Hilton, myself, or any member of the state any legitimate concern that he has regarding Woody's testifying. So let's stop right there. She's saying that Melnick doesn't have a legitimate concern about Woody testifying. Woody's lawyer don't have a legitimate concern. Well, when Woody went in the back room, Woody said, I did these crimes. Woody wanted to know the statute of limitations for murder. So I find it strange that she's saying in a motion that his lawyers did not have a legitimate concern with Woody testifying. Oh, yes, it's a legitimate concern that he could incriminate himself. See, she started off lying. She said, what we have seen is physical interactions with persons besides Mr. Copeland that would indicate that Mr. Copeland is not Mr. Melnick's primary priority. Wow. She's saying Mr. Melnick, Woody's original lawyer, he's not worried about Woody. That's not his primary concern. What we do know is that when the fact that he's willing and wanting to leave, number one. So they are talking. So a lot of this stuff is not going to be like reading a book. They're actually talking. So when people talk, you're going to have interruptions. Let's keep going. He left twice after the court ordered him to speak with his client. And it would seem his actions convey that it is not Mr. Copeland's best interest that is his priority. So now all of a sudden the state is so worried about Woody having the best representation possible in the world. Ms. Hilton was out speaking with Woody at Woody's request, so she say, at the time that I announced that Ms. Hilton was calling Woody. What I did not know is that she was trying to tell you to give us a minute because Mr. Copeland was, feverishly, and I will let her speak as to how that went down. So it looks like what I did not know is that she was trying to tell you to give us a minute. So Ms. Hilton was signaling to the judge. She was trying to tell you to give us a minute. She was giving him one of those, baseball signs, but the judge didn't catch it. So apparently when she gives the judge a sign, he's supposed to slow the trial down or take a break. But I guess the judge didn't catch it at the time. Let's keep on going. The court, what was that, Ms. Hilton? Ms. Hilton, So let me just put the order of operation. I got up because Deputy Chief Long said he wants to talk to you. Come out right now. So when I went into the room, Melnick either came in or came outside. And what Woody said, and I think that he wanted to get some autonomy. I want to talk to you. He's like, you, I've already talked to you, but I want to talk to her. And Mr. Melnick kept like blocking him being able to talk to me. So it seems like Woody is trying to talk to Hilton by himself, but Woody's lawyer was blocking it. I mean, rightfully so. Why would you want your client talking to the DA? The DAs are not your friend. They're trying to prosecute you. So eventually I was like, well, clearly you want to talk to him, so I'll step out and you can come in. Mr. Melnick spoke to him, and I think he was trying to eat up time because he knew that you were coming out. So by that time, I got back in there and he started to talk. That is when everyone said, come on, the judge is waiting, and that's why he stormed in angry. Miss Love, look at her. He being Mr. Copeland. He being Woody. Miss Hilton, because I think he was trying to convey to me some concerns he had. And so I was trying to have that conversation because Mr. Copeland, Woody, and I have been having really good conversations since Friday, like very, very good conversations. So she's talking to this man, Woody, knowing that he has a lawyer since Friday, and she said some very, very good conversations. And then obviously Woody get on the stand and act like he don't even know who Hilton is. Woody got on the stand and act like he didn't even know Hilton's name, and then he tried to insinuate that she didn't smell good. So see, y'all didn't have them very, very good conversation like you thought. But let's keep going. Just not even about the facts of the case, but just life experiences. So the DA is giving Woody life experiences, I guess, lessons. So I think I was building a rapport with him such that he thought I lied to him. So I was trying to explain to him, Miss Love, and by that she means today. Look at Miss Love trying to clarify, and by that she means today. Miss Hilton, today about what's going to happen. Miss Love, because of what someone conveyed to him. Miss Hilton, we believe that something was being conveyed. What happened is, as Woody was walking back into the courtroom, Woody's attorney, Melnick, and Julie would have to, and Miss Lent, don't give me the line, something, would have to confirm this. But he said they are going to hammer you. And that made me ask Miss Love, did you say something about hammering him? And I don't know who, Miss Love. Nobody did. Nobody did. The court. It doesn't make sense you would say that to him. Look at the court. Look at Judge Glanville. It doesn't make sense that you would say that to him. He co-signing. And then Miss Love, we never did. We never said that. The court. But anyways, okay, Miss Hilton. So whatever that communication was, that's when he stormed in and got angry. And the result I got was that he gave when we started. So at this point, I'm very concerned. And Miss Love, he's meaning Mr. Copeland stormed in and got angry. I know this is a lot, y'all, but it seems like the state's trying to talk to Woody. Woody's signaling to the state that he want to talk to them, but he's trying to do it behind his lawyer's back. And then his lawyer, Melnick, is not trying to let that happen. That's what I get from this. If anybody else gets something different, let me know. So what the state is saying, so at this point, I'm very concerned. And then here goes Miss Love. He, meaning Mr. Copeland, stormed in and got angry. So Woody stormed in and got angry. Okay, here we go. Miss Hilton. The timing of everything is very ironic. We laid it out on the record earlier about what happened, and I don't believe that Woody's best interest is being served at this moment. Given, Mr. Melnick was willing to take a vacation and let him languish in jail. And that is not, we have communicated that we never wanted Mr. Woody to go to jail. We don't want him in custody, and we don't want any of that to occur. I find it, see how the tables turn? Now it's time for Woody to come back and testify, and apparently Ms. Hilton finna go on vacation for a week. and they tried to say that Woody didn't have a good lawyer because his lawyer had went on vacation. And I mean, sometimes you have vacation that you paid thousands of dollars for and it's non-refundable. But, you know, thank you for that. If y'all don't mind liking and subscribing to the channel. But let's keep going. But now Hilton has been a hypocrite because now she got to go somewhere for a week. I don't know if it's vacation or what, but she's not going to be there. But she's trying to say that Woody's lawyer wanted him to languish in jail while he was out having a good time on vacation. And Ms. Love said, and Mr. Melnick has not spoken. He has not relayed what we did get during the break was an email from Mr. Melnick. I don't know if he had to have been blind copying someone else. The only two people I could see on the email were Ms. Hilton and myself, but he referred to me in the third person and said, these are the communications between myself and Ms. Love. So I asked Mr. Melnick, whose interests are you concerned about, your clients or Mr. Steele's and Mr. Shard's? So basically, Melnick, Woody's lawyer, are you concerned with Woody or are you concerned with Young Thug and the other co-defendants? Because prior to, and this is not the first time Woody has said, he doesn't represent me. This is not the first time Woody has, and let me be real clear, when he spoke of what was happening before him representing Woody and he told me that he didn't represent Mr. Copeland. He didn't represent Woody. So it seems like Love is trying to say Woody's lawyer himself said he didn't represent Woody. But I think Woody's lawyer is disputing that. He told me, the court, Mr. Melnick told you? Miss Love, yes. Mr. Melnick, Woody's lawyer, told me previously that he wasn't representing him. Let's keep going. The court, you would not speak to an unrepresented party. Look at the court. The court is taking up for the state. You would not speak to an unrepresented party. I mean, I know you know enough of the rules to know that if you thought or intimated that somebody was represented by counsel, you would go ahead and let them contact that lawyer. See, the judge already, I don't like the judge because he already made predeterminations. Instead of asking questions, he already automatically assumes that I know you wouldn't do that. That's not in your character. I know you know the rules. You're going to follow the rules. I've been knowing you long enough. Instead of asking, did you speak to an unrepresented or a represented person without their lawyer? So here we go, Ms. Hilton. Or Woody would have said, because I don't know as a witness, because he's not charged. If we would have to, and Ms. Love, right, Ms. Hilton, because he's not charged. The court, I don't think you have to because there's no pending charges. But if he told you I got a lawyer, I don't want to talk to you, Ms. Love, we would have left. I don't believe that. The court, because people counsel that they have under retainer or something else, or they say, hey, I got a lawyer that I use for everything and I want to talk to him. I'm not comfortable talking to you unless my lawyer is present. Ms. Hilton, we have done that with a number of our witnesses here. So this would have been no difference. Ms. Love, exactly. And we would have, I'm sorry. The issue here with the judge as well, the judge is saying, really, I don't think you have to wait to talk to Woody's lawyer because Woody doesn't have any pending charges. You can talk to Woody even though he has a lawyer. Talk to him. He's not a defendant. The issue I have with that is that even though he's not charged right now, the state can always charge him later. So the judge saying, I don't think you have to because there's no pending charges, is irrelevant because he could still be charged in the future. He needs his lawyer. So let's keep going. Ms. Hilton, oh, okay, I'm sorry with the last thing I read. Page 6. Oh, Ms. Love, I'm sorry. I don't mean to cut you off. Ms. Hilton, no, go ahead. That was it. Ms. Love, we actually communicate, especially when either they are incarcerated or subject to having their sentence revoked as a result of their testimony because they pled guilty here. We only reach out to them through their attorney because we want the attorney to speak to them and for that to be because that's the best way, in our opinion, to get a report with that elicits truthful testimony. So in this particular instance, there was not that, number one. There was not that communication made by Woody that there was ever a need for that. And two, there was not a need for us to be concerned about it because he doesn't have charges. See, she piggybacking on what the judge said because he doesn't have charges. The judge giving her what to say and she's repeating it back in the record because he doesn't have charges. All right, Ms. Hilton. Ms. Hilton explained, oh no, it's still Ms. Love. Ms. Love talking. Ms. Hilton explained to him at length that whatever happened that he did in 2015, which is all we're going to be talking to him about, the statute of limitations has run. He didn't do the murder. We know that. So that's good evidence right there. If they ever try to charge Woody for the murder, they could, this transcript, he didn't do the murder. We know that. I mean, so I don't want to get into the facts of anything. What I'm trying to get at is the fact that Woody, I believe Mr. Melnick has inserted himself in a way that jeopardizes the best interest of our witness. And so what the state is saying, Mr. Melnick is getting in our way. Mr. Melnick is getting in our way because he's representing his client. And we don't need Woody to have a lawyer right now. He's inserting himself into our business and it's jeopardizing the best interest of our witness. This is wild. I believe that in conveying to the court that Ms. Bumpus is going to stand in his stead. Ms. Bumpus has been, she had to be, she was. What is the word I'm looking for? The sheriff had to speak to her because she was in the courtroom trying to hug Jeffrey Williams. Come on here. Well, wasn't it revealed that Kayla, it was not a secret that Kayla is the godmother of Young Thug's sister's son. So Kayla is the godmother of Young Thug's nephew. So I guess it wouldn't be, strange of her to, I guess to hug Jeffrey Williams. I don't know if it's true or not. I haven't spoke to Kayla. And we don't even know. I mean, this is love talking. We don't know. Love will say anything to win. And not only that love is getting this secondhand. This is a hearsay from somebody else. The sheriff had to speak to her because she was in the courtroom trying to hug Jeffrey Williams. And look at Miss Love got it wrong. Look at Miss Hilton. No, she hugged DeMonte Kendrick. Oh, see what happened when you talking hearsay. The sheriff told Love that it was Young Thug, and then Miss Hilton had to correct Love and say no, she was not hugging Young Thug. She was hugging DeMonte Kendrick. What the hell is going on? Miss Love, I'm sorry. Yeah. Miss Hilton. In fact, she hugged DeMonte Kendrick and then hugged Mr. Williams. And that's how Captain Kendall saw her. And Captain Kendall had her taken out. Wait a minute now. I'm gonna call Kayla myself. Because I know they lying. I know they lying on her. But the strange part is Miss Love said that she hugged Young Thug. We got that. And then Miss Hilton said no, she didn't hug Young Thug. She hugged DeMonte Kendrick. And then Miss Hilton went on to say, no, you were right, Miss Love. In fact, she hugged both of them. She hugged DeMonte Kendrick and Young Thug. And then they put her out the courtroom. And for those who don't know, apparently yesterday, Kayla said that the deputy was messing with her so much about everything. He wasn't treating her with respect. I think it was a different deputy, Deputy Brown. He was lying on her, saying that she was showing people stuff on her phone. He was making a big scene. And Kayla actually revealed that one of the deputies was the original mole that leaked the first secret transcript. So so it's a lot going on. But Kayla did reveal yesterday that it was Deputy Brown of the Fulton County Sheriff's Office that actually told Brian Steele and Young Thug's team about the secret meeting that we all found out about. So let's keep on going. And like I said, I will clarify this again. We don't know if it's true or not. I have not spoke to Kayla that she was hugging anybody. Kayla might say Love and Hilton are a damn lie. So let's keep on going. Miss Love, she expressed dismay and concern in challenging her right to go interact in that manner with the defendants. So it appears that they were trying to say Kayla was upset and she was challenging her right to interact with the defendants. Is Coco still in the chat? Coco, if you're still here, see if you can get Kayla on the line. And that way I don't have to, we can keep on going. Okay, so let's keep on going. So they said Kayla was mad. She challenged her right to go interact with the defendants. And, just to keep this, clear, Kayla represents Woody. And Woody is supposedly a state's witness against Young Thug and the rest of the people out in the gallery. So that's probably why they wanted to keep everybody separate, because you obviously don't want a lawyer that your client is testifying against and you're, cool with the other side. I mean, because if Woody see that you're interacting with Young Thug or the Monte Kendrick, Woody might be like, oh man, I'm testifying against these people and she's interacting with them people. But at the same time, Woody been knowing Kayla for years. I remember Kayla, when she came on here and talked, I think she said that she's been knowing Woody a long time. She's represented him in the past. So Woody might already know that she knows Young Thug and she's comfortable with Young Thug. She's in the family. She's the godmother of Young Thug's sister's child. So Woody may not care that she's talking to Young Thug. I mean, they may all be cool, but for appearances, you got to keep up appearances in the public. It may not look good if it's true that she was trying to hug them or whatever. But anyway, let's keep going. So our concern is that it is not Woody's best interests that are being represented. And that not only is that the case with respect to Woody, who we have no interest in prosecuting, but there is a tampering of sorts going on in this person inserting himself, where Woody has been reaching out to speak to Ms. Hilton, and that communication is being blocked by someone Mr. Copeland didn't reach out to. So now it seems as if lawyer Love is trying to accuse Woody's own lawyer of tampering with a witness because he don't want his client talking to the DAs without him being present. This is some wild stuff. This is some wild stuff. They're trying to accuse a lawyer of tampering with a witness. And this is the same thing Fonnie Willis tried to do when Fonnie Willis' boyfriend, Nathan Wade, he's going through a divorce with his wife, and his wife's attorney wanted records. They're trying to get records from Fonnie Willis and Nathan Wade so they can find out where the money at. And Fonnie Willis tried to say, y'all are tampering with a criminal investigation. Y'all interfering with a criminal investigation. Basically, she's threatening them with charges. Let's keep on going. Line 21. You notice no one said Woody called me. He never said when we put on the record, when Ms. Hilton said, the way I understand it, Mr. Melnick reached out to Woody because the first time we heard an assertion like, oh, he's going to plead the fifth is when Mr. Melnick sent an email to Ms. Hilton and myself. and had copied on it Mr. Steele and Mr. Shard last night. The court, why would he have done that given Ms. Hilton? And that's the state's concern, Ms. Love. That's the point. The court. But here's the challenge. The challenge is you have privileged communications, and unless you got him being the client, disclosing to a third party that wouldn't be subject to the privilege, that is the only way you are going to, Ms. Love. I don't disagree with you with that at all. I don't disagree with that at all. But if Mr. Melnick, and the thing is not looking at Woody saying, you know, Woody, I want you to stay out of jail and I will be here with you. And if they ask you anything that touches upon something that you and I talked about, I will stand up and assert your right. He didn't do that. What he did was he looked over at two people and said, like, I did what I could, shrugged his shoulders, held up the palm of his hand like as to say, I tried. So they're trying to say that Melnick, Woody's lawyer, looked over at two people, maybe Young Thug and Brian Steele, or Brian Steele and Keith Adams, and said, I did what I could, or said like, I did what I could, shrugged his shoulders, held up the palm of his hand to say, I tried. There is no reason he would be looking to the right to counsel for the defense like I tried after Woody said he was going to testify. That doesn't make sense. The court, well, there's a lot of innuendo that they have asserted themselves. They, being some of the defense counsel, have inserted themselves in this particular process, and that's what Ms. Love, my concern is Mr. Melnick's insertion of himself. See, Ms. Love is trying to get Melnick throughout the case. My concern is Mr. Melnick's insertion of himself. The court, what are you asking me to do? What are you asking me to do? What do you think that I can do? Ms. Love, that is the exercise. That is the homework for tonight. Go find a way how we can kick Woody's lawyer off the case. She said, I wanted to let the court know that that is what we're looking into right now, because there is a remedy, because I have faith in Allah. Woman going on. Love talking about I have faith in Allah. I love this thing, and I know there's a remedy, because this can never have been the first time this happened. It has been addressed. I just have to find it. Look at Love. She want to go find something, but wasn't ready today. And now we're on an hour and a half break because she didn't have what she already supposed to have. So now she want to go find some extra. But I didn't want to be looking for something and not let the court know what I'm looking for. So you are not, so that you are caught off guard when Monday morning or Saturday night or Saturday afternoon, we find it and send it to you. So she basically telling the judge, I'm telling you what I'm trying to do. I just want you on board right now. I want to find a way to kick Melnick off the case. And the judge is like, okay, Miss Love. So thank you for allowing us to audience with the court, allegedly with her man. I just wanted to make certain that we did it properly and we had everything on the record. It is our witness. We have conveyed to him that he is shielded from prosecution for anything that he talked about on the stand and any use of that. And the thing is that we won't ask him that, but this is what he said. Y'all may not, but they may ask me about some things that I have to assert my right on. And that would be a question by question basis. What he is being influenced to do, we believe, by his attorney, Mr. Melnick, is, and it's through Mr. Melnick, because as you saw, Woody said, I will testify. Mr. Melnick, even after that, said he's asserting his fifth. I'm going to talk to him. Logically, one would think that as long as Mr. Melnick's concerns about Kenneth Copeland's freedom, Woody, legal freedom, and his exposure, as long as those were addressed, Mr. Melnick should be saying, I am here with you. If there is something that I know will put you in jeopardy, I will stand up and stop it and stop you. But right now, I would rather you stay out of jail. Instead, you got Woody, and you can see through his body language. He gets there in court, and he's smiling as if making a show of being taken into custody after this. And the man don't want to be in jail. He said it. Didn't he say he don't want to be in jail? So then she's asking Hilton to co-sign. And Ms. Hilton, that's his biggest fear. Right on cue. That's his biggest fear. Miss Love, she repeats it. That's his biggest fear. And now he's in jail after Mr. Milnick asserted himself in the process. That's his lawyer, woman. He can assert himself in the process. Woody never said to Milnick in front of the court, Milnick, you fired. When he came out there with Kayla, he said, you fired. Why did he say you fired in front of the judge, in front of Milnick's face? Obviously, Milnick was his lawyer. Let's keep going. So we have to go figure it out. I'm not just laying it in your lap saying, go fix this. I'm just bringing this to the court's attention. This is a grave concern. Ms. Hilton, she's about to lose her mind because her biggest concern is that Mr. Milnick is actively harming a human being, not actively harming a human being. And that's what she's maddest about. I'm mad because it is stopping our trial and it's wrong, and that is not how the law is supposed to work. What? So now Love. Wow. So we have two big old grave concerns that we are working to remedy right now. The court. Okay, well, like I said, I think that you brought your concerns to me. You know, without more, I don't know what else I can do in terms of that. Right, the judge cannot unilaterally step in and fire Woody's lawyer. I mean, that's some nasty work. Thank you, breaking it down with B. If y'all don't mind hitting that like button for all this reading that I'm doing. Come on, come on. Except the ones from the DA's office, if y'all watching, the ones that big mad, y'all can hit the dislike button. Give me some engagement. My comments today were predicated on there's a lot of stuff that's going on in the background, but it shouldn't have to do anything with you all's case. It really shouldn't. But I think it does in some way. Outside agitators, this is the judge talking. The judge is saying outside agitators, Miss Love, that too, the court, and everybody else who I think are trying to influence Miss Love, that is absolutely happening. Miss Hilton, there's a lot going on. Miss Love, there is a presence. Yes, yes, that is all I'll say. The court. I mean, but I see it from just being in the courtroom and tracking. But okay, if you find anything, we'll see where Monday leads us. And like I said, since we now know he's going to potentially invoke, we'll see what his pleasure is, and Miss Love cuts him off. I mean, just the idea of someone sitting in jail throughout this trial, but if that's what he's being counseled to do and that's what he does, that's just wrong. Well, the thing is, Miss Love, that's not your place. If Woody decides to sit in jail and his lawyer advised him that's in his best interest not to snitch and potentially get hurt in the street, then Love, you can't say that's just wrong. That's not your business. It's wrong because a member of the bar is, in my mind, creating that circumstance, you know? Yeah, it's all in your mind, Love. He's going to do what the person he trusts to have his best interest at heart tells him to do. And that person, he doesn't have to tell us what he's concerned about and can just sit there and when he sees a train coming, stand up and say, stop. But he's got a vacation to go on, so he can't be here. Well, if you know he got a vacation to go on, what you worried about him for? He won't be there anyway. So what are we talking about? Y'all are saying that Milnick's in Woody's way, but at the same time, y'all saying, but he's going on vacation, so he's not going to be in Woody's way. So Miss Bumpus is going to be here. Miss Bumpus hugging Mr. Kendrick, and Mr. Williams is going to be here representing the interests of Woody, who is supposed to testify against Mr. Kendrick and Mr. Williams. And that's what I had said earlier about public appearances. Even though Kayla may know Young Thug and she may know DeMonte Kendrick, in the courtroom while you're representing Woody and Woody is testifying against against those defendants, then it may not look appropriate. I'm not saying it's inappropriate. It just may not look appropriate to the public if you're, representing Woody, but then the people he's telling on, you go out there and you hug them. And I don't know if that's the case. Like I said, Kayla may say that's a damn lie, or Kayla may say, Woody, I know Young Thug. Woody is okay with me being cool with them. We all know each other from, 10 years. Woody know I wouldn't do anything behind his back to hurt him. And I would also add, not only that, Kayla was in the other transcript, Kayla was asking a lot of questions about Woody's rights. She wanted to make sure that Woody was protected. She wanted to make sure that if Woody said A, B, and C, what could happen to him? Is it statute of limitations? What is his immunity cover? So I'm not going to say that she wasn't protecting Woody. I think she was doing the best she could at that time. But let's keep going. She said, that is where we are. That doesn't pass a smell test. Come on, love. Nothing's passed a smell test with yourself. The court, all right, okay, Miss Love, thank you. And this certificate of service, wow. This is insane, y'all. And I believe we're waiting a few more minutes before the court starts back. What y'all think about all that? This is absolute insanity. I'm gonna have to drink some water, wipe my face. This is crazy. We have a few minutes. Anybody got a camera and mic want to come up? I'm gonna drop the link. If you guys got a camera and microphone, y'all got something to say about the secret transcript that was revealed today. Anybody got a comment or something that they want to say, they want to talk about? Rob for real said this is a Tyler Perry movie. This is crazy. Yeah, it's crazy, Kiki. This is absolute insanity. The judge has to let this case go. She's trying her best to hang on to it for her own, probably, political ambitions, but I don't see it. Oh, yeah, no problem, Robin. Thank you for popping in. And for those who are here for the first time, if y'all don't mind subscribing. But if y'all say, no, we don't like the way he talk about our judge, then maybe subscribing may not be a good idea for you. Because the judge, he keeps proving himself to be corrupt. And then they get mad at YouTubers or media people and people in the legal profession when we call them out on it. Oh, thank you so much, Robin. Say, subscribe. You don't got to tell me twice. Robin said, I'm with it. I'm with all that. I'm with the truth. I'm with all of it. You ain't saying nothing. And they so embarrassed that they tried to make a mockery of the defense counsel by saying that they should be gagged because they are talking to the press. The lawyers are ruining this trial because they are out talking to YouTubers. I want to know what Kayla got to say. I mean, I don't think she did nothing wrong if her client has an understanding. Now, if I have a client that I'm representing and, and I go over and talk to the other side without my client knowing, that'll be strange. If my client see me hugging somebody on the prosecution side, or one of the people that we're against, that's gonna look real strange. But if my client already knows, like, hey, I know them people, we already have an understanding that we're not against each other. We're all on the same team. We all want the same outcome. We want Woody to go home, go free, and we want Young Thug to go free. We all on the same playing field. We all have the same interests. Then I don't see a big deal. But I believe that when the cops, and when I say cops, the bailiffs in the courtroom, see her hugging the defendants and not try to put her out the courtroom, that's crazy. But the only person I'm concerned with is Woody. If Woody come out with Kayla and say, hey, I know she's cool with them. I think he already did this. I think Woody already was on her channel and was saying that he don't have no problems with Kayla. They good. Then I don't think that the prosecutor should be concerned. Somebody said Kayla sitting back chilling. They said she was drinking her what? Did somebody say Hennessy? I had read that earlier when I was reading, but it was going too fast. Where is it? And y'all, we probably got about 10 more minutes, 9 more minutes before the court starts. I thought somebody said Hennessy in the comments. Am I tripping? Thank y'all, chat, for supporting. Chat say hit the like button. No, I didn't know they were raising money for Woody. I didn't see that. The DAs are mad they didn't get the right lawyer for Woody to play on their team. That's what it sounds like. I've never seen a prosecutor overly concerned with who's the defendant or unindicted co-conspirator has as an attorney. I mean, what are you saying? You want Woody to have a better lawyer to go up against y'all to protect his rights? There we go. I'm gonna say Kayla, someone with a gallon of Hennessy lemon drops. And and right now the case may get threw out. So Fonnie Willis might be somewhere with her Grey Goose to get a lose. This is insanity, y'all. This is insanity. Okay, I had a few questions some people were asking. I think somebody said, is this legal? Absolutely not. Danny Steele, thank you again, Danny Steele, for always supporting the channel. What's your thought? She getting things together to do a mistrial? To me, it just seems like the judge is trying to patch this case together. She's trying to hold this case together for reasons I don't know. But I don't think it's enough gorilla glue in the world to hold this case together. It's just not enough. They said no matter how hard you try. What's the word that they called? This is what Weinstein called the judge. He said a yenta.
Yenta.
A woman who is a gossip or a busybody. She acts like a nosy yenta. That's what Weinstein said in his motion. I didn't say that. Oh, man. So now, this is insanity. The judge is trying to consider whether to throw off Love and Hilton or the whole case altogether. But to me, for some reason, I'm thinking the judge is trying to go forward with this case. Now, based on this new motion, see, the thing is, even though I just read the new motion and we are just finding out about the new motion, the judge already had this new motion. The judge already had this transcript. I'm talking about the current judge, Judge Whitaker. So she could have declared a mistrial on Tuesday. When did we start back? Was it Tuesday? Yeah, yesterday, yeah. And the judge didn't declare a mistrial then, and she had this information. It's just new to us. So I don't see her coming out now all of a sudden trying to throw the case out. She got to find out the hard way. Name calling, I feel like I'm at work parenting. And I wanted to, he actually, let me see, let me go back. Because I don't know if he, yeah, I don't know if he actually called them that, or he said they're gossiping like that. Let me get the quote right to make sure we get it right. It is not a fair trial when in an ex parte meeting, Glanville, Love, and Hilton gossip like Yentas. Okay, he didn't call them Yentas. He said they gossip like them. Over 13 pages of transcripts about Attorney Sharp, Milnick, and Steele. So at least we got let the record reflect that we got it right. Hello, Lady Red. Thank you for joining the chat. Somebody said she's doing it for clout. She's trying to make a name for herself. It's sickening and sad. Right. Let's not lose thought on the real reason why we're having this discussion. It's because another secret meeting was happening in the back room. So he should have called them way more than a Yenta when you got your client's life on the line. A lot of these guys are facing life in prison. And now we're finding out about another secret meeting. So me personally, I don't have a problem with the name calling. That's the least that can happen to Judge Glanville when he's playing around with people's lives. Somebody said the judge wants her own show. No, they're not letting it go. I don't think none of us letting this one go. I mean, if it's something of substance happening in the meeting, so if it's like an ex parte meeting where someone has to go out of town or they have a surgery scheduled, or maybe let's say Woody, for example, let's say he was being threatened in jail in Fulton County while he was in jail with the the defendants. So he may go to the judge with his lawyer and say, hey, can you move me to another jail where I can feel safer? That's nothing. Okay, we can move you to another jail. It's not affecting the trial. Where Woody's in jail at, whether it's in Cobb County or Fulton County, that's not an issue. But when you're pressuring Woody about stuff that has to do with the trial, you're forcing him to testify against defendants. That's a material phase of the trial that the defendants have a right to be present for. So ex parte meetings by itself is nothing wrong with that. You can have ex parte meetings, but when you start talking about the trial itself, that's when you should always bring the other side in, because you don't want to have any situations where you're accused of backroom dealing with the judge. I mean, sometimes it'll happen. I remember I was trying to subpoena a witness in this one county, and the judge was walking by, and he started talking to me to find out what's going on with the witness and the subpoenas. And I said, just to be safe, let's go grab the DA. It was nothing serious, but
It's
just
all
to be
about your
safe.
direct question regarding the prior inconsistent statement and whether or not the fact that Mr. Copeland said, I said it, but I lied, if that would be grounds to, would that still be considered a prior inconsistent statement? And Your Honor, I have three cases for the court.
Not three.
Okay.
I have Green v. State. I have a copy for the court, as well as a defense counsel. You're welcome. Green v. State, which is 317 Georgia 250, which is a 2023 case. Sconners v. State, 318 Georgia 855, which is a 2024 case, Your Honor. Sure, Sconyers, SCONYERS, v. State, you're welcome. And United States v. Odom, which is a federal Sixth Circuit, United States Court of Appeals case for the Sixth Circuit. It is an older case. It is a 1994 opinion, and it's 13 Fed 3rd 949.
Okay.
May I approach with those three cases?
Yes,
Your Honor?
thank you.
Oh, sorry, and I'll give it to you.
She done went way back to 94. They say Glanville was in traffic court yesterday, so I don't know if he retired.
I think you green already, Mr. Long.
I don't
I
know.
green already.
I don't know if he was in traffic court.
Okay, you're welcome. You're welcome.
Look at this court reporter over here with her outfit. You better work, court reporter. Come on. Got the outfit in the hair,
All right,
lady.
so Green seems to say that if you say you don't remember, that's a sufficient foundation. Is there, and that's the only one I've looked at so far, is there one that says, if you say, yeah, that was a total lie?
Yeah, so that's also in green, Your Honor.
Okay.
So if you look at page 5 of the opinion, Your Honor, about the 4th paragraph down in the facts of that case, Your Honor, it says during the course of their investigation, officers interviewed Corey Milton, who said that he knew Green had a green Camry, that Green told him that a cracker bucked, I shot him, and that it was not Baba, Hill's nickname, who shot someone. The state played this recorded statement interview for the jury at trial. However, before the interview was played, Milton testified that he did not remember an interview or Green telling him about a murder, stating, I be getting high, I don't know. After a break, Milton testified that he did remember telling law enforcement lies to try to get out of trouble and that he would say anything.
Okay.
Milton further testified that the investigators brought up his criminal record, including a federal conviction and state charges that were dismissed, and that during the conversation about Green, Milton was looking for help with his case.
Okay.
And those facts are analogous to what Mr. Copeland has said so far on the stand, that he was just trying to finesse his way to get out of trouble, that he said those things, but they were all a lie. And here our Supreme Court in Green said a witness's failure to remember making
All
a
right, so hang on. You're talking too fast for the court reporter to
Sorry.
take it down because you're reading.
Sorry.
And then where are you reading from?
Now I'm on page 7, Your Honor,
Okay.
Division 3.
Okay.
And when the court, the analysis is a witness's failure to remember making a statement may provide the foundation for offering extrinsic evidence to prove the statement was made. They cite London v. State, which is 308 Georgia 63 at 66, page 66 through 67. They further cite Bridgewater, which is 309 Georgia at Penn site 887, which cited defendants denied recollection of making a statement provided sufficient foundation for the state to present extrinsic evidence of the statement. Here, the state laid the foundation for the admission of the recorded interview when it asked Milton twice if he recalled making the statement, and Milton responded first that he could not recall making the statement, and then that he did recall but had lied.
Okay.
And so that is Green. And we also have Scaniers that discusses primarily that the state does not now have to go through every single inconsistency,
Okay.
but that we can now, the flat out denial of that statement, Your Honor, allows us to move forward in playing the entirety of the statement, Your Honor, without going into further details. That's kind of our summation of Scaniers.
All right.
And then Odom, Your Honor, is a federal case on the same point as the Green case, Your
Okay,
Honor.
thank you. Appreciate it. Counter law, counter position from any of the defense attorneys?
Your Honor, I'm gonna let someone that's better than me respond, like Max Sharp or someone. But I just want to state that the foundational element for this argument doesn't even exist, because we don't know what Mr. Copeland has testified to. I mean, everything he testified to after the 12th is void.
You mean we don't know what he is going to testify to?
Well, we
Right.
certainly don't, because we
Right. No, I mean, I don't think anybody
we're-
disagrees with that.
Okay.
But what I said was, let's go ahead and things that we think are very likely to still be an issue, given what he may testify to, let's go ahead and try to, hash out the admissibility of. So true. Yes, he may get up there. Who knows what he's going to say? But yeah, I mean, he would have to say something that would give a foundation in order for it. But assuming that he testifies generally in the same way that he did before, which was, according to y'all, and I've seen some of it, that was a complete lie, then we will face this. And so let's figure out what the...
So we're guessing at what he may say based on what he said.
Right, because I am trying to get prepared ahead of time instead of having to do all of this while we have the jury. So yes, absolutely.
Thank you.
Okay.
Now this is strange.
And if for anything, I do remember that there were at least 2 full days of testimony from the 10th to the 12th. And
Yeah.
it's the state's remembrance that the I lied started early in his testimony. So,
Okay.
But we can
Thank you.
deal with that as well.
And with regard to that, the court reporter has said that she probably, what did she say, Ms. Hurstfield? You talked to her, I didn't.
She is working on the transcripts of Mr. Copeland's testimony, and she said by either late today or tomorrow morning, she should have, I believe it's June 10th. June 11th, and then we'll be working on June 12th shortly thereafter.
And do we already have June 10th, or did he testify at all on June 10th?
He testified on June 10th,
Okay.
11th, and all of the 12th.
And did he take the stand? He took the stand at least on June 7th, right?
Took the stand. I asked
Okay.
3 questions in that.
All right. So do we already have the 10th somewhere? We'll figure that out. But anyway, it should all be forthcoming soon. Okay, Mr. Steele.
Your Honor, I don't think that the state's cases, from what I heard, I did not read them, I just heard the discussion, are what we're looking for, because those cases are, I don't remember, or I was on drugs, or I don't recall, but I found a case, it is pre the new evidence code.
Okay, so hang on just a second. So I didn't know, did y'all didn't, it's fine if y'all don't have copies of it, but you have the site to it. But looking at it, it does actually look like, in addition to saying, I don't remember, reading right from the case, he says, Milton testified that he did not remember an interview or Green telling him about a murder, stating, quote, "I be getting high, I don't know." After a break, Milton testified that he did remember telling law enforcement, quote, "lies to try to get out of trouble," unquote, and that he would, quote, "say anything," unquote. So it sounds like that is pretty close to what we've got.
Well, okay, maybe I have to study it, but I found a case. Now, my understanding of 24-6-613 is it did not change much of our former evidence code. So I'm about to give you a case from 2011, but it is obviously, if you disagree with that, then it should have no application if it doesn't carry forward.
All right, so you just said 623?
24-6-613, if I said 23, I meant prior inconsistent statement.
Okay.
That's what the state is traveling under that.
Yeah.
And then prior or impeached testimony or
Right.
testimony by contradiction. So I found this case, if you don't mind pulling up,
Okay.
or I can email it. Johnson, Johnsson versus State. Your Honor, it's 289 Georgia at 106. It's Division 3. And that is 709 Southeast 2D 768 2011. And I think that it's on point bad for Mr. Williams, but it says over objection to trial, but we just follow the law. So over objection, the trial court allowed the prosecutor to play the entire tape of an out-of-court police interview of a witness for the state. Johnson urges that the particular statements made during that interview, which were inculpatory of Johnson, were inadmissible as prior inconsistent statements because the witness had admitted making them, but testified that he lied to the police. Then it says, however, the fact that the witness admits that he or she made the prior inconsistent pre-trial statement does not render it inadmissible. We have rejected that assertion that a prior inconsistent statement is admissible only if the witness denies making the prior statement, but not if he simply disputes the truth of the earlier statement. There is no such denial requirement under, and again, it's I don't want to mislead the court, it's under the former 24-983. Then I looked at Cummings, which is cited, which is CUMMINGS versus State, which is 280 Georgia, 831. It's in Division 3. It's a 2000. Now we're way back in 2006. That is actually helpful. It does not support the situation that we have here. In that case, let's see, Division 3.
Yeah, so it looks like in that case, he just refuses to answer whatsoever.
Exactly, which is really obviously, saying I don't remember, I don't recall, I don't, I may have said something. Those things trigger a prior inconsistent statement. I thought that's what the Green case is that I have to study that the state just cited. But I wanted to bring to your attention that language that I just gave you out of Johnson, I thought right on point and bad for my position, but we just tell the truth. So I want to arm you with it. But then we always look back. We're always taught to look back on the cases cited, and that former case doesn't promote that position.
So it appears to me, and I'm just looking at Cummings right now too, but so it looks like the defendants, appellants now at, the appellate stage are saying, hey, a prior inconsistent statement is admissible only if I deny making the statement, not if I simply say it wasn't true. And the appellate court is saying, no, that's not correct. You don't have to deny it. Even without a denial, it can still come in. That does not mean the flip is true, that the other part, not simply if he disputes the truth, is not a way to get it in.
I agree.
So I mean, you can take a look at Green, but Green seems pretty on all fours. So I'm thinking unless I hear something that either overrules Green or causes me to severely question Green, Green controls. And if whether he says, I don't remember, whether he says, I never made the statement, or whether he says, yes, I made the statement, but it was a total lie, all three of those, it appears under our current state of the law, would permit then the introduction of prior inconsistent statements under 613.
Well, I'm going to read with your permission.
Sure, yeah, absolutely.
Thank you.
All right. Thank you. Thank you, Ms. Hilton. That was a helpful use of our break. All right, so with that understanding, are there other specific evidentiary issues we want to consider? Or do we want to just jump right into hashing out some of the evidence?
Your Honor, during the course, the state also looked at the redactions that we had previously
Okay.
discussed with Judge Glanville for the states as it relates to the January 11th, January 28th, February 20th, and February 21st interviews.
Okay.
We do not have any issues with the redactions as is.
Okay, and those redactions being something that the defense and you all have agreed to?
It was what was
or
hashed out during.
the state of it. Okay, so were those hashings out done prior to or after the recusal motion being filed?
It was done, 3 of them were definitely done after the recusal motion was filed.
Okay, well, the one done before the recusal motion was filed, we can go with, however, that ultimately ended up being redacted.
Yeah, I'm trying to recall if the other, I know we were in the middle of playing 2 of them during that time period. I just need to confirm when we actually discussed those 2. So January 11th and February 20th, we actually played those interviews before the jury. I believe we played those interviews on Monday, June 17th. And
Which would be part of what either needs to get redone or y'all need to make a,
yes,
come to agreement on.
and we may have started it on Friday, the 14th, whatever that Friday was before. But for the ones that we did discuss during that pendency, the state does not have any issues with those 4. As it relates to June 11th, the June 10th interview, there are some we would like to revisit. So,
All right, I'm not sure I follow you.
Okay.
So. What you say you want to revisit.
so
So I think first it would be helpful to know which ones were hashed out before the recusal motion. And then we can just say that's what we're going with because that was prior to any issue. And therefore we can stay with that. As for anything that was post recusal motion, unless the defense can come to an agreement with y'all about admissibility, we're going to have to redo all of those. So have y'all had discussions yet about, or I mean, I thought y'all wanted to figure out what was actually done and what wasn't.
and I guess maybe I misinterpreted what I thought the court wanted us to figure out whether or not there were some that we wanted to even object to. And so we're saying there wasn't any that were done that we wanted to object to for 4 of them. I don't know if the defense has any, for 4 of the interviews, we have no objection to the current state of the redactions based
Okay.
upon what occurred.
All right.
And so that's what I thought I understood.
Okay. And that was January 11th, January 28th.
February 20th and February 21st.
And so you will let me know which one or ones of those were hashed out before. And that is, status quo on that. For the other 2 or 3, whether they were before or after, y'all are good with what was decided, but I'll have to find out from the defense whether y'all are good with what was decided. And if not, what particularly you want to revisit.
Yes, Your Honor.
Okay. And then there was a 5th one.
For June 10th, there are areas we would want to.
And that has not been gone into with anybody. Yeah. Is that true?
No, we did hash out that one as well.
Oh,
I just want
you want to revisit that one?
Yes, Your Honor.
Okay. Okay. All right. Can anybody from the defense give me anything close to definitive about whether y'all are good or want to revisit the evidentiary determinations made as to any of those?
And respectfully, and I'm not trying to belabor the point, but I just need to make a record. Our stance is that our trial judge was not an impartial.
I understand.
And so we don't believe that the issues are just limited to post serving the recusal motion at this time.
Okay.
So that's, and we understand.
I am not going to be going back and revisiting evidentiary rulings made before then.
I understand. And I just need to say that.
But yes, for the record, I understand.
This is a very difficult task. I was I think we all were very involved in the negotiations and reviewing of these things. But, as we were doing it, I wasn't taking notes of what I was doing. So I'm trying to put together what exactly was discussed. And part of the problem is we don't have a transcript.
Well, I've got some of the transcripts, but not all of them. So if it would be helpful to y'all to have the transcripts of when the jury's out and y'all are going through, we don't have all of them yet, but I've got certain days. So y'all did that like on the 18th, the 20th, and the 21st, and the 24th, and the 25th, and the 26th.
Yes.
Okay. Which is why I want to use this week to the extent possible to not take 1, 2, 3, 4, 5, 6 different days to do that. Okay, so I'll see what we already have and get that out to y'all. And again, y'all, this is all rough. This isn't official, but it looks pretty clean to me.
And there were extensive emails that went back and forth from myself and other defense attorneys with Ms. Hilton mostly regarding these kind of negotiations where we agreed and didn't agree at the time. Okay. So I'm trying to check my emails and make sure I have.
So y'all have those or should have those. So.
And that would be a good starting point. I'm just making sure that what I have is accurate to what she has.
Okay.
I'm sorry I don't have a better answer for you.
Okay.
Keith Adams on behalf of Mr. Williams. Let me kind of echo what Mr. Short just said. It wasn't very involved, and I'll be candid with the court. I have several boxes, and one of those boxes contains my notes You know, it got to the point where Ms. Hilton and I were kind of back and forth in court on the day of and sending emails. I don't have those with me. I think what Mr. Shard is saying, and if he's not saying it, I'll say it, that we really need some time to kind of get all that together.
All right, y'all.
Yeah.
When I met with y'all, when was that? Friday, a week and a half ago? And said, okay, here's how we're going to move forward. And then gave y'all 10 days or so to, before we had our Tuesday, hey, we're doing motions now, and then we're going to move to evidence. Y'all should have used that 10 days to be doing this, because we literally talked at that time about we're going to need to go back through some of Mr. Copeland's evidence, and we're certainly going to have to reach what hadn't been reached before. So I know I can't reverse this all back to 10 or 11 or 12 days ago and have y'all then make better use of your time up until now, but y'all, that's what I meant when I said we're going to be doing the evidence this week. So y'all may have a really long night tonight. I do not want tomorrow to be as unproductive as today. And yes, it will help when you have transcripts. And so I, to the extent I can, will get transcripts out to you as I get them. But with regard to, like, you know, discussions y'all were already having amongst each other, it wasn't that long ago. So okay. All right, so how about another witness? If we can't work on Mr. Copeland right now, is there some other witness that we know is going to also have a lot of evidence that is going to be contentious?
Mr. Zachary, sorry, Mr. Zachary.
Your Honor, Mr. Zachary, there are other witnesses.
Okay.
We've not gone over, well, we have turned over the statements that Mr. Zachary has made.
All right.
To the police that we intend, if necessary, to use for impeachment purposes.
Okay.
There have been no motions in limine regarding any portions of those statements, as we don't know what, you know, Mr. Zachary has not yet testified. And, you know, we would hope that he be truthful and consistent, but we don't know what he's going to do.
Okay, so for a whole lot of this, I mean, y'all can't really, let's assume that
They're trying to go
he
into the
testifies.
future.
Let's assume for everybody who there might be impeachment or other evidentially challenging evidence out there, that they are going to testify in a way that is going to force y'all or permit y'all to use whatever it is. And then the other party assume, well, let me look at all of this is going to come in if I don't object. What do I think I have a legitimate objection to? And then bring that to me. And I know it'll all be hypothetical right now, but that's what motions in limine are. As to evidentiary issues we think are likely to come up at trial. And then we will go ahead and hash those out. So yes, obviously it's a contingent ruling. But if y'all as the defense have Mr. Zachary's statements and have taken a look at them and know what you think is going to be potentially objectionable, if y'all want to give me those statements, make those objections, I'll hear a response, and then we can try to get through that. That would be great.
And with the court, is the court asking for a copy of each of his statements? We can provide that.
Yeah, because I mean, I'm going to need those if I'm going to make rulings. So yes. And I know in this day and age, almost everything is a video statement. I also know that for Mr. Copeland, when y'all were litigating the evidentiary issues, you had transcripts available, and that would be immensely helpful. It is a whole lot faster because a lot of the statements aren't going to be anything anybody has an issue with, or you're going to have agreed that's not relevant, it's going out. If you can say that's on page 7 lines, whatever, I can go right to that instead of listening through 5 minutes of that before I get to page 7. So I would love transcripts to the extent we have them. And then of course, if in court, I need to, for a particular reason, watch and listen to the video that is the relevant, cogent part, I of course will. But as to, you know, a 5-hour video when there are 20 minutes that are really at issue, if we can hone in on the 20 minutes via a transcript, that would be ideal. Okay, so is anybody ready to go on Mr. Zachary?
It's love testing Fanny. It's still on that phone.
Does everybody have Mr. Zachary's statements? Okay.
I'll take the hit here.
They do keep sending you up here to be the one.
That's okay. I'll take the hit. So there are thousands and thousands of pages, and probably thousands of pages of transcripts. So we have a digital copy. I'm sure someone has the full discovery here, but we all have printed out copies of his statements. I know my copy.
Y'all are all old like me, and you like paper.
And because we have our notes on the paper too, and so
Yeah.
I didn't know that Zachary's statements were going to be on the agenda for today, so
Yeah.
I didn't bring the transcripts with all my notes.
I mean, they shouldn't have been on the agenda because Kenneth Copeland was the agenda today. But
Understand.
okay, I hear you. You're not ready, but you can be ready soon. So when you say thousands of pages, do you mean period or thousands of pages for Mr. Zachary?
Mr. Zachary, to my recollection, has at least two, I believe maybe three statements.
Okay.
And I'm estimating here, I would say a total of about 9 hours of talking.
All right. Has the state determined whether, so I know, like, for example, for Kenneth Copeland's jail calls, I think you had 11, but you said we're only interested in 6 of them. Have y'all done that type of winnowing for Mr. Zachary and the other witnesses that you're going to be getting to soon?
We have been, not entirely winnowed, as the court said, down. We have identified jail calls of particular, not witnesses, but defendants that we intended to use. And when the court says particular witnesses.
I mean, Mr. Zachary is a witness, right?
But I don't believe that we have any jail calls from Quindarius Zachary.
Oh, no, I was just using that as an example of winnowing. I'm not asking about jail calls from Mr. Zachary. I'm asking about whatever you think you might use with Mr. Zachary. If there are 3 statements, for instance, do you intend to use the entirety of all 3 statements? And if not, could you pinpoint for the defense what portions of those statements you intend to use so that if they have an objection to something you're not going to use, they don't even need to look at that because you don't intend to use it. So you can say, here's the portions we think we want to use. And then they can say, only look at those. Here are the objections we have.
I can do that. I have not broken it apart.
Okay.
Segment scientific.
Okay.
As I wasn't yet.
At him. I don't know when he's going to come in, but all right. So as a part of all of the work y'all are going to be doing before the 5th, that's going to be part of what you need to do.
And not just for him, just so that.
No, yeah, for everybody, for your next 30 witnesses, and then for your next 30 after that.
And so if, not trying to tell the court how to use the court's time, but if during.
I'm open to suggestions since what I've come up with so far isn't working.
What we can do as a prosecution team over the next, however amount of time the court wishes to allow us, is to identify with respect to each of the witnesses that are co-conspirators. I know that there are several. We can, and that it will be coming up in the next batch of 30 witnesses. So we can identify just to the court and the defense those people, and began looking at the portions of their statements, their respective statements, that we would anticipate needing to use as opposed to using the whole thing.
Okay.
And so we should be able, over whatever amount of time the court gives us from here forward today, to go through and come back today with a chunk of statements for each of those people.
Okay.
If not all of them.
Okay.
Some.
I like what I'm hearing there, that by the end of today, she have done that for all of them. Yes, I like that.
Judge,
Yes.
she said I said it, so
You did say it.
You know, there we go. But I might overshot.
You might have overshot. All right. Well, hey, if you can even do it for one, that'll give us something to work on. And I thought you said you could do that before the end of today. Okay. So anyone, are we ready on anything?
Not friends. Nope. This day is over with.
It's not anything we can go forward with, but Judge Glanville had given me, on behalf of Mr. Nichols, a continuing objection to the admission of any of these statements, in that they have absolutely nothing to do with Mr. Nichols. So I have a continuing objection to the admission of these statements.
All right.
I have a continuing objection, which has been preserved by Judge Glanville, with regard to both the alleged co-conspirators exceptions and any of the contained so-called statements that were made by Mr. Copeland or the other alleged witnesses that the state has called. Last year, we had motions pending with regard to 801 D2E issues, co-conspirator statements
Right.
issues. The court indicated that, well, it required the state to provide to the defense all of the 801 D2E statements that the state contended it would seek to admit
Okay.
during the course of the trial.
Okay.
That notice was filed on or about by the state on or about, excuse me, November 3rd
Okay.
of last
23.
year,
Okay.
obviously. Couldn't be this year yet, although it feels like it. That state's supplement to state's motion to introduce co-conspirator statements and notice of intent to introduce the same. They only noticed three statements. So anything else that they do now after a year, after 19 months, after a specific motion, after specific requests by every single defendant so that we could hash this out. A year ago, they gave us three. So I'm going to object to any other alleged co-conspirator statements that the state seeks to admit under 801 D2E.
Okay. Understood.
So I want to get that on the record.
Right.
And finally, this is prejudicial misjoinder. There's such a spillover effect as to Mr. Nichols. I had an ongoing motion to sever
Right.
that I want to reallege and reaffirm.
And Mr. Nichols is charged with count one, the gang count.
Yes, that's correct.
Okay. Do you want to, I think I invited you previously to, but if not, invite you now to provide me a proposed 105 limiting instruction, and I'll take that under consideration.
Sure.
And I'll do that I know that all 6 of the defendants here are charged in count one, the RICO count. And then other than that, there seem to be sort of 8 or so independent, or not independent, but different acts or sets of acts that some people are charged with 1 or 2, some people are, charged with another set. And yeah, I mean, the people that are not charged with Mr. Thomas's murder might want some sort of instruction that says, other than the gang count, other than the RICO count, this doesn't go to this defendant. So I'm happy to consider some instruction if y'all want to provide me something to consider.
I will provide you
Okay.
with that, whether you ultimately do that or not.
Yeah,
this is
I
what
don't know.
we've
I'll
been
hear from
arguing.
both sides. But
Yeah.
Yeah.
It's what we've been arguing about the whole time and what I've preserved going forward.
Sure.
All right. So we'll get you that
Okay.
as soon as possible.
Okay. Now, as to the first point you raised, that only 3 statements were identified in the November notice filing by the state as co-conspirator statements that the state had identified as intending to admit. But does the state have more than that now? And if so, tell me why those should come in despite not being included in the November notice.
So, Your Honor, the November notice of 2022.
2022?
We provided 2 801 D2E notices.
Okay, so is one of them November 3rd of 2023 as?
Yes.
Okay,
Yes.
and then you're saying there's another one?
Yes, that's November, that was filed on November 30th of 2022.
Okay. And give me a second, Laura.
Thank you, Judge. In the 2022 notice, we stated that the state will establish the ongoing conspiracy of the YSL Criminal Street Gang at trial, and any statements made between co-conspirators in the YSL Criminal Street Gang conspiracy that were made in furtherance of the conspiracy are admissible, and we request the court grant the state's motion to permit these admissible statements at trial. What we've seen come up, for instance, during jail recordings, there are persons who are not indicted under this indictment as a co-conspirator that make statements to either a witness or a defendant currently on trial or in the presence of a defendant currently on trial that the defense has alleged the statements are therefore inadmissible, despite the fact that they come within the context of a jail recording that arguably is admissible, that the statements of a particular party are not admissible. Instances like that, we argue, are instances that involve co-conspirator statements.
Okay, so not arguing broadly, conceptually, but arguing as to specific statements.
What notice does the defense have of specific statements that are not included in the November 3rd, 2023 notice?
Okay.
Because it's one thing to say broadly, hey, if there are co-conspirator statements, we intend to use them. It's another to say, and here are the ones we intend to use. And if the court had ordered, you need to tell the defense which of these you intend to use, then it's time to get down to specifics.
Yes, Your Honor. So in this particular notice, we did provide
Sorry, when you say in this particular notice, which notice?
the November 6th, 2023 notice.
Okay, November 6th. November 3rd?
It's just, he said it wrong.
It's
just
filed.
six.
November, okay. You provided notice of 3 different statements.
Right. 3
Right?
specific ones,
Okay.
yes.
Right?
Yes.
All right. So my question is, are there other statements besides those 3 that you believe are admissible in the trial of this case as to any witness?
There are, just one moment.
All right.
And so that we are clear, because there's a difference of opinion. So does the court mean out of all of the jail recordings, out of all of the wiretap recordings, out of any recording that we had, which of those contain arguably co-conspirator statements?
Yes.
There are many. There are many that are included in the.
All right. I have yet to find the notice that y'all are talking about.
The November 6th one? We can
Yeah,
send it to
because
the
y'all,
court.
there are a lot of filings
We can
in
send
this
it to the court.
case. But Ms. Percifield has saved it for me somewhere, but there are already a lot of things in our file also. So
We'll send it to the court and to counsel for defense.
Laura, what's it called? Where will I find it? Is emailing it to me because I need lots of assistance. Thank you, Laura.
This
And so was there an order at some point or a direction from the judge to tell the defense which statements you believed to be co-conspirator statements that led to this supplement? Yes. Okay.
I'm looking for it.
Okay. I mean, if there was, that's all I need to know. So yes. So, okay. Now tell me what other statements you believe to be co-conspirator statements and why they should come in now when you were ordered many, many months ago to tell the defense what they were.
They are included as part of the jail calls and the wiretap.
Okay, so they have them.
Yes.
They just haven't been identified as, hey, we think this is a co-conspirator statement. We intend to use it. Okay, well, sure. Well, I mean, I shouldn't say sure. Sure, you can try to, whether you're successful or not, I don't know.
I understood. So when they say they've been provided, they have not been identified in any way, shape, or form. There are thousands of jail calls involving dozens of people.
Yeah.
There are about 3,000.
I think you've said enough. I understand. Them provided in discovery, not identified as here are what we believe to be co-conspirator statements. Thank you. That was kind of what I thought when she said you have them in discovery. All right. So I would imagine that the discovery in this case is beyond voluminous. And at some point in a trial in this day and age, you know, how it's supposed to not be trial by ambush anymore. It's supposed to not be trial by ambush. And I'm not saying you're trying to ambush.
Yes,
but
she is. Yes, she is.
At least as of now, really well before now, you should have identified. I think this is a co-conspirator statement. And honestly, you should have identified out of the God knows how many rooms full of boxes of discovery, here's what we're actually going to use. So to the extent you haven't done that, I've already told you you're going to be doing that by telling us very specifically as to each witness, here's the evidence I intend to use. But that's still weeks down the road. So if you know, well, let me put it this way. Whatever co-conspirator statement you know of right now, let's stand up and let's share it with the rest of the people here so that they can then tonight look at it and say, here's why it's not. Okay? And for anything that you don't know of right now, you need to go home tonight and huddle together and figure out what else there might be. And I will consider whether I'm going to let that in or not. And then if I do, potentially, we'll have to hear as to each of the alleged co-conspirators why it is that you either have or can establish through admissible evidence that they are in fact a co-conspirator, or not in fact. That'll be for the jury to determine, but there's a preponderance from which I can determine. Okay? All right, so who do you know of right now? Okay. She said, give me 1 second. But yeah, I mean, I know it's a big courtroom and there are a lot of us, so we all need to try to remember to speak into the mics. So maybe the state can, and you're pretty loud, Miss Love, but maybe pull that mic down so it's a little closer to all of y'all.
I'm pretty loud.
And so that the court knows what I'm doing, I overheated. And so I had to wait.
By which you mean your laptop overheated.
I do mean my laptop. And I was
because I've told y'all not to overheat anymore.
So that's what's
okay.
I thought she was having a hot flood. Oh man, they know how to do it, boy. Somebody say lies.
While she's waiting for that to
Sure.
turn up, could I just briefly address a side issue?
Sure.
When we met for the status conference, I
Yes.
believe Mr. Harvey asked you if you would support us when other judges try to
I
drag
recall
us in.
that. And you know what? Immediately thereafter, that very night, a federal judge reached out to me and said, "Oh, I'd like Mr. Harvey for trial." And I said, "No, you can't have him." So
Thank you so much,
Yeah,
Your Honor.
mhm.
But one thing that wasn't clear, or maybe I misunderstood it. You talked about when we say take a 1 week break, that if someone wants to call you in for motions, perhaps they can do that. So you were referencing that week last week where we were out and why we weren't working to prepare
right,
for this.
right.
I was being called into court all over the state of Georgia,
Sure, I
just because,
imagine.
and maybe that was my fault because I wasn't clear whether you would support us if I told those judges, no, I'm in trial. Because we did have a lot of preparation
Yeah.
to do for this week,
Uh-huh.
but unfortunately, I was hauled over all over the state.
Right.
I'm
And
sure
we didn't really talk about that.
Yeah, are you going to cover us for that as well, so that we can work on this trial during those breaks?
Let's say yes.
Because, I mean, we may just have to decide that on a break by break kind of thing. Because I, for the last 19 months, have been one of those judges wanting several of you in court for cases pending before me on my other docket. I don't want to blanket say anytime we're not here working on the case, I'm still going to protect y'all, as it were. And frankly, I'm sure that all of y'all would like some time to be able to go represent your other clients in court as well.
Absolutely, Your Honor.
So, why don't we take that up kind of as we need to?
Okay.
And if we are not in court, I hope that we will get into a rhythm if this case proceeds to continuation of trial, where we can have enough done that we can say go Monday through Thursday hard and take Fridays off, or take Friday mornings for motions and Friday afternoons off or something, but like a schedule so that y'all know if you are not prepping for the main witness in the case the next morning, that you can go to court and do some of your other representation.
That would be wonderful, Your Honor.
Yeah.
At least speaking for,
But
just for
yeah,
myself.
I mean, let's raise it with me when you need to, but
Okay.
I can't give you a blanket answer. Right
Okay,
now.
thank you.
Okay.
She must be from Texas with all this y'all. And now she hide her laptop from the camera. Look at her. Or is she showing Hilton? What's she doing?
How long are you gonna need? 2 minutes, 10 minutes, 1 minute? Okay.
Looks like she hiding that password. Somebody say ain't nothing wrong with her laptop. She knocked it loose. About more
Your
time.
Honor, we're going to allow Mr. Atkins to stand up and give to the court the calls that we have identified within the wiretap that contain co-conspirator statements.
Okay.
One of the wiretaps.
One of the wiretaps.
One of the wiretaps.
And Your Honor, this wiretap is it's a 6,000 page PDF where you can open up audio links. It has the date, the time.
Okay.
90% of them have what they call reference numbers, where while they're watching the wiretap, they'll give it its own 4-digit identifier.
Okay.
Every now and then, the reference number will just say 0. I don't know why. So I think what makes the most sense for purposes of getting, I wanted for the defense to know where this specific audio is. I'm going to give, for most of these, I have the reference number, the date, the time, and sometimes I also have the PDF page on that document. So that's how I'm going to reference it for all parties to speak off the same sheet of music.
Okay. Give me a ballpark before you do that of how many there are.
Yes, Your Honor. Let me count these up.
Ballpark. 5, 20, 100.
More, they will be closer to 50 to 100.
Okay. So instead of standing there and reading them all, do you have them in writing?
I do. With what I can do is take, a lot of these have notes like next to them of things that stood out. And so what I can do is create a document that has the date, time, reference number.
I would think that would be easier for everybody than making sure they write it all down correctly. Tell me this, what witness is this a wiretap of?
So, Your Honor, there's 2 wiretaps. The specific one I was going to start with is Demekion Garlington, who is a severed co-defendant.
Right. Okay.
And I believe almost the entirety of these wiretaps will come in through Detective Viverito, Atlanta Police Department gang detective, who I think is probably ballpark 50 plus witnesses down the road.
Okay. Okay. All right. So there are going to be a series of alleged co-conspirator statements that are in the wiretap of Garlington. I think I would imagine that the state could speak to me right now about what it is that you will use to establish that Garlington is a co-conspirator. You, Mr. Atkins, will put together the list of all of the details, and you will email that to all of the defense attorneys and the court today.
Yes, Your Honor.
And we can maybe do the litigation of that, maybe that week in August. So I will need, at least the portion of the statements that is at issue as well?
Yes, Your Honor.
Okay, so that is one set of co-conspirator statements. You mentioned another wiretap of someone else.
Correct. Of Mr. Sumlin,
And
who is
is-
also, he has pled guilty, but he was one of
Okay.
the 28 indicted defendants in this.
So
case.
you've done your proffer for that one. That one will be easy if he pled guilty.
Yes, Your Honor.
Okay.
Yes, Your
All
Honor.
right, Sumlin. And you can do the same for him.
Correct.
Okay,
And
perfect.
he has less, it's hard for me to ballpark the number.
That's
for him,
fine.
but-
I just was like, if it's two, you can read them out, but if it's some huge chain, then it's easier to just give them in writing.
Yes, Your Honor.
Okay, all right. So that is two further potential co-conspirators who have statements we will need to litigate. Whom else?
Your Honor, we have an additional co-conspirator statement from Mr. Copeland, a jail call.
Okay,
That's a part of the 5,
jail calls.
about a
Okay.
portion of the 5 jail calls.
All right, hang on. Is that a surprise to anybody? Do I need to do a back and forth about whether it's fair for that to come in?
How are they gonna object to it? Ain't
Okay, that was part of the notice, so that one's good.
Go play the call.
I don't think it's a part of notice, but
They don't think that was part of the notice, but they're willing for y'all to say that's good.
but there was just a portion of that call that the defense objected to, but we can talk about that.
Okay, and, all right, but y'all have already been litigating that, so I'm gonna call that one good in terms of notice. Whom else?
We got some jail calls with Woody. And maybe Demeke and Garlington. A wiretap. And another person.
All right, question. So I'm looking at this November 2023 notice, and at this stage, when it was filed, they're talking about witness A. Y'all all know who is referred to in each of those at this point? Okay. Okay.
We filed a supplement that wasn't filed. We gave to them.
Okay.
Witness A.
All right. All right. Can you provide to this judge whatever that supplement was so that I know? Thank you.
Not to this judge.
Do y'all, deputies, do you know whether lunch is here yet for the, okay, why don't we break for lunch? Be back at, how long, practically speaking, do y'all actually need to get everybody fed and restroom breaks and back? Hour and 15? Okay, let's break until 1:15.
Quick question.
Yep.
I can't. I don't know. Hard time finding a statute on recusal that says you're not allowed to say the truth of what happened to the judge. I can't find that.
Okay.
I'll look for that. I'll look for that.
During lunch.
Also, I reference where it said that you can't use.
Okay.
matter of-
That'll be great. Thank you. All right, we're in recess. Let's say till 1:20 since we've already eaten up like 5 minutes.
And Your Honor, are we looking for, I apologize for.
All right, y'all. So we're in recess
all of them, when the court had asked me earlier, whether in all of the jail calls, all of the wiretaps, all the recordings.
Yes, at this stage of the game, we need to give notice to the defense of every potential co-conspirator statement. And if in the afternoon you can do essentially what Mr. Atkins just did, it's going to be this set of statements, and we'll give you the details of where to find it later. That's fine. But yeah, it's going to be this witness, that witness, and the other witness in these statements as to each of them. Yes, because A, they need to know at this point, and B, we need to know what we need to litigate at this point.
Okay.
So yes, thank you. All right, in recess.
All right, y'all. So we are already in recess. So I guess we can go. Grab some to eat and all that good stuff. And then we can come back. But I do want to hear those wiretaps because I know Jiggy was talking about those wiretaps for a while. Stacey and the defense not allowed to bring what happened to the judge. Nasty work. Right. I mean, in theory, they already know. But Brian still wants to tell them why Judge Glanville is not sitting up there anymore. Which I think is fair because they're going to get curious and try to look it up anyway. But the judge is trying to figure out what to tell them. So, yeah. Good luck with that, Judge, because I still want to know. All right, y'all. So I guess we're going to just take a lunch. I'll just leave it up, leave the stream open. And then I'll come back. Yeah. All right, y'all. So I'll pop back on, and then we can just pick up when the court comes back. And I'll leave the link open. Yeah, just in case they come back. Let's set up again. Let me get this time right. What is it? 1:20? I thought it was 1:15. And let's see. Let's try this one. There we go. 1:20. Oh, hello, Nikki. Thank you for stopping in and seeing what the fuss is about over here on Talk That Law. So we're going to take a lunch break with the court and then just come back when everybody else comes back. Regina, and I'm gonna answer some of the questions when I get back. But most of the time, the appeals court won't step in at this point. They don't like to double work. They don't want to step in now and then have to review it at the end of the case. So what they're saying is let's finish the trial, find out what the verdict will be. If the verdict's not guilty, good. They don't even have to worry about it. The case is over with. And if they are found guilty, then they can review the whole case all at once instead of bits and pieces right now. But yeah, but thank you for that question, Regina. But I'll be back. I'm gonna go grab some eat right quick. Y'all are funny. Not a comfort break. Not a comfort break. Oh man. What do you say? Talk about man, you know how Glanville used to be. I'm just sitting back, patiently waiting. How Woody sold out Thug. I don't know if it's been. I appreciate that, Rob. For real. Shout out to Rob for real. I don't know if it's. Are people saying Woody sold out Thug? I don't know if that's the. If they're saying that. At least not right now. But we still don't know what's on these wiretaps and jail calls. So that should be interesting. That's funny. Right. Why even started? Because now we got to see it through to the end. We got to finish it now. Let's go. He said you talked that. Nice to meet you, TTS. Even when she came in this morning, it looked like she was flying in there. Her hair looked disheveled. I don't know what she had going on when court started this morning. Let me see if I can find it. Let me see if I can find it when she came flying in this morning. Look, y'all, look.
I trust you had a productive evening.
That was this morning. The thing is, she the one that put her own self on this strict deadline. It was going on the Honorable Yvette Daniel. I saw you was writing earlier, but the chat was going so fast I can't even. I got to go back and read. Maybe she's still reading the case law. We'll blame it on that. She's trying to eat lunch and read the case law. You know what, Anthony? I can't play with y'all today. Oh, here we go.
All right, good afternoon. Hope everybody had a good lunch. So what were we able to sort out with regard to other potential co-conspirator statements?
Oh, so you ain't gonna address
Identifying those.
you ain't gonna address why you was late.
Your Honor, we have a list of potential ones.
Okay.
Sort of a broader universe. And I'd like to narrow them down before handing them over. Some of them we have reviewed and they have statements about drugs that we may not want to introduce. So there's a large volume of, for instance, calls that have certain commentary in them.
Okay. So you can identify the statements and you're saying that it may be less than the full statement and you can further narrow that, but you at least at this point have the person and their statements.
Yes.
Okay.
Yes.
Okay. Up to what? You can go ahead and continue to explain.
So, and that's the way it is with a number of the jail calls and the calls from the wiretaps that we have reviewed so
Okay.
far.
Okay.
We have, there are some that are left unreviewed, but the ones that we reviewed.
Okay. And for the ones that are left unreviewed, can you identify, here's the person and here's their universe of statements? We just can't tell you what portions yet. Do you understand what I'm asking?
I think I do, and I don't think it's can. You said if you could just clarify.
Okay, so
Talking to
why don't
Mike.
you do what you can right now, and then I'll ask you the rest of it. So as to what you have prepared, let's go ahead and share that.
So this is much in the way that Mr. Atkins was a list of.
Right.
54 calls.
Okay.
It's similar. It contains.
Lord, don't want to turn over that evidence. Just give it all to him.
You don't have to count the number. You can just go ahead and give them the notice.
Give him the whole
Is
damn.
it something that you have like a written list?
So yes, it's
Okay.
an internal list of notes.
Okay.
And calls that are identified.
Okay.
So what I can do is provide to them just the calls that are identified.
Okay, so do you want to do that in writing? Okay, so do you want, could you at least in court identify the witnesses?
She don't want to identify him. Give him the whole damn binder.
So
She don't want to do it.
So when you say the witnesses, you mean who we're going to introduce?
Oh, she don't know what
No,
witness means.
that's not what I mean. I mean, who is the alleged co-conspirator whose statement you think you're going to use? And if you have the witness you're going to use, I get it in through, that's great too. But we're looking for co-conspirator statements. So we need to know the ID of the co-conspirator.
Man, she don't know what co-conspirator mean or witness mean. She don't know nothing. Woman, give them everything.
So mainly the ones from the Garlington wiretap are the ones that are identified in the majority. That's the ones that we have the majority of. The remaining jail calls that we've identified, they are jail calls of Diamante Kendrick, Martinez Arnold, Shannon Jackson, all of whom are actual defendants who either are currently in trial or who have pled, and Marvius Nichols.
Yeah, I agree. If you got to do all this,
I'm sorry, I didn't, number one, I didn't hear that. Sorry, I just couldn't
Okay.
not
hear it.
talking in the mic. We can't hear you.
Is your mic on?
My original objection was too little, too late. In other words,
I understand.
okay.
I'm just
so-
trying to sort out what there even potentially is at this point, and then, which is harder than it should be. And then I will hear why it hasn't been shared before and why it should now be permitted regardless.
Thank you.
Thank you. Hasn't been shared. So can you say those for people again louder so Mr. Harvey can hear?
Yes, Your Honor. The jail calls, the jail calls of the persons that I have in my hand that we're reviewing are jail calls of people who are currently on trial or who were on trial and entered a plea.
Okay.
So I don't think that counts for what Mr. Harvey is talking about in terms of co-conspirator statements. In other words, for instance, I have Mr. Kendricks, Mr. Stillwell, Mr. Nichols, jail calls that we had under review by the team who was working on that. And that we've identified calls from that we intended to use.
Judge, at this point, if you don't turn it
If I may
over,
respond to that. If it's Mr. Nichols' phone calls, the kid has been in jail for a couple of years, number one. Number two, those are his statements. I'm entitled to those under the discovery statute. And if they're just looking at them now, 2 years later,
keep them
you
out.
should,
Exclude.
without any question at all, exclude those. I mean, this is,
Okay.
come on, 2
So-
years later.
I
It
agree.
is my understanding that everything that my understanding based on your representation to me earlier today in court, that everything that you intend to use as a co-conspirator statement has been provided to the defense in discovery. Is that correct?
Correct.
Okay. And so what we're doing now is y'all asked that it be identified which are going to be co-conspirator statements. So it's not that you don't have it, it's that it has yet to be identified as a potential co-conspirator
No.
statement.
He should know if he have it.
So with regard to your objection about not having it, you have it, it sounds like. Now, if it's a statement of one of the defendants on trial right now, but it is going to be used against another one of the defendants on trial right now, it is, right?
Yes.
Then it is a co-conspirator statement. So,
Right.
Mr. Nichols, Mr. Kendrick, Mr. Stillwell, you also said Mr. Arnold and Mr. Jackson. And did you say that both of those people have pled?
Mr. Arnold has pled.
Okay.
And I said Jackson, but Jackson is Stillwell. So that was
okay.
a statement.
All right. So the only person you've identified other than the three that are on trial right now is Mr. Arnold who pled.
Right. And there's also Nichols, Kendrick, Stillwell. And I have a jail call from Quindarius Zachary.
Okay.
We've identified.
That you've identified only now, not previously. So don't tell me that the three that were already identified, they don't have an issue with in terms of it. Late notice, yes. So was Zachary one of the people that had been identified in that November 2023 notice?
It says
Because the notice I have says person A, person B, so I don't know who they are.
Right. So not the jail call, the statements that he has made, but not the jail call. So the name, I believe Zachary is either A, B, or C. I have to look at our
Okay,
notes.
doesn't matter who. It's yes. he was identified as one of the people whose co-conspirator statements were you intended to introduce, but the jail call wasn't identified within there?
That is my.
Okay. Is the jail call subsequent to the time that you provided the notice?
No, the jail call date is
They say she used to be a juvenile
2015.
judge.
It's in 2015.
Okay, so is there a reason you didn't include the jail call in the notice that you provided?
She was hiding it. Uh-oh.
When we were preparing the notice,
She lying.
our,
She lying.
our understanding of the need to extract jail calls that contain this information or wiretap calls that contain this information and identify them was separate from our obligations regarding generally what co-conspirators statements.
Okay. Can somebody provide me either the order, oral or written, or the directive that the court gave to the state so that I can figure out whether that was a reasonable interpretation?
And we're going to
Okay.
get that for you. And at the time that we were under the obligation to present the co-conspirator statements, we were still, and the court was aware, we were still listening to, because there was an ongoing commentary about the jail calls and the number of them and identifying them. So we were still listening to
Okay.
them.
So at some point, presumably you completed your listening?
Right.
I mean, I know they're still ongoing, so I'm not talking about a jail call somebody did last night, but.
Even if you, even
Okay.
all of the ones.
Do you understand? I'm sorry to interrupt you, but let me back up and ask a different question.
Do you
instead.
understand me?
Did you understand that you had a continuing obligation to notify of co-conspirator statements, even if it didn't include jail calls and wiretaps?
She don't care.
Yes.
Okay. And with regard to whether there was some other understanding about jail calls and wiretaps, I'll sort that out later. Let's, at this point, are there other people who you think are co-conspirators, who you think you have co-conspirator statements for that you are potentially going to want to admit in this trial? And let me direct your attention to, because this might help you a little bit. You, a couple of days ago, provided at the court's request to the court, and I assume to opposing counsel, a kind of modified list of witnesses still to go. All right. And you have at least a broad outline of evidence you expect with those witnesses. And some of these people you have actually identified specifically as co-conspirators. So, I mean, can we go through that and at least with regard to those people, see whether, yes, in fact, there is potentially such a piece of evidence? All right. So if everybody wants to follow along and pull out your state's witness list, the first one that I notice is number 3, Antonio Sledge, who you say is a co-conspirator. And then on your evidence, you have listed a defendant interview and a jail call. Right. Could that potentially be?
Yes.
Okay.
Yes.
So we can add Sledge to the list. Then Zachary, you mentioned, so he's already on our list. Now, some of these, I just don't know, but there are a lot of them that have interview or something like that over to the side. I mean, somebody like number 7, Kenya Morton. I don't think she's a co-conspirator, but okay. And then Arnold, who's number 27, you mentioned. How about number 35, Wooney Lee, who you have labeled as a co-conspirator?
Not Wooney Lee.
Okay,
Come
and
on.
are there potentially co-conspirator statements from him?
Yes. How y'all don't know this? You see the judge tapping her pen?
So unless
She know they playing.
what we have of Winnie Lee consists of social media
Yeah.
evidence.
It don't
So
matter.
arguably, if that could be considered co-conspirators.
Oh my goodness.
Say better to say, yes, I think so, and it not be than the other way around at this point. I think it was 35, 33. Says 35. Oh, no, it says 35 on mine because I got what, today maybe? Or yesterday afternoon, an amended witness list that adds a few people.
And Your Honor, for the record, it added 2 custodian records for
Okay.
Sprint and T-Mobile.
Okay, so anyway, Winnie Lee, either number 33 or 35. How about, and you mentioned someone earlier this morning, and someone y'all already had notice of from November of 2023. So someone's, okay. I mean, that may be it in terms of, in my review over lunch, what I noticed to be pretty obvious ones. Are there other ones?
The judge, they need to exclude it. Tell them don't even worry about it. If you don't got it, leave it where it's at. It's not coming in. And you can fix all of this. Y'all saw the Alec Baldwin judge. She said, I'm going to throw the case out. Don't even worry about it. Y'all hiding evidence. And I don't know why they just want to sit next to each other. Why they got this man in the middle? Yeah. And the judge, she real impatient. And the judge, she used to be the chief over all the appeals at the district attorney's office back in the day. So she knows appeals and she knows case law. So you just can't come in there with anything. She like the Brian Steele. She just worked for the prosecutors of appeals, and Brian Steele worked for the defense of appeals. So she not a rookie. They're not gonna be able to get nothing past her. Now, do I agree with everything she's saying? No. But she's been doing this a long time, even before she became a judge. What, 7 years ago? In Virginia, I wouldn't bring a case I'm not prepared for if I was a prosecutor. But they do it all the time. They think they're prepared because they're so used to going against mostly public defenders that are overworked and underpaid. So they can get over on a lot of public defenders because they don't have time.
And Your Honor, I think I took it for granted, but all of the 6 co-defendants currently on trial, their statements, their social media, and the jail calls that they have, that we have of them,
Okay.
would be
All right.
considered co-conspirators.
All right, and I think that with regard to the 6 co-defendants on trial, it is, I mean, pretty obvious considering that there's a RICO count as well, that the state considers those people to be co-conspirators of each other. It still might be helpful to identify the statements, but with regard to deficiency of notice as to those people, I'm going to say that's okay, that's kind of Within the context of there being a RICO count against them all, that notifies the defense that at least you think they're all co-conspirators. So if you can identify the statements as well. So that leaves, I guess, so does that mean that there are no others other than the ones we've run through just now?
I want to say that that is accurate. I want to be accurate before I say that that is accurate.
So while she's making sure she's being accurate now, somebody else can tell me.
Accurate now.
So on the notice that is from November 2023, the two people who are they? Zachary and Sumlin, the people that are identified as like person A and person B? Everybody seems to know except me at this point.
Now, Thomas, here you go with this random stuff. What's you talking?
I mean, y'all know at this point. So how about somebody on the defense side tell me? And you don't even have to say who's who, just.
Right. This really shows how much Glanville was letting her
Ms.
get away with.
Weinstein, you're looking at me like, I know, but.
I'm looking at you like, this seems like a job for Matt Sharp.
Apparently it is, because here he comes.
See, they keep putting Matt Sharp on the judge because she liked Matt. So, of course, he's going to do all the talking now instead of Steele.
I'm looking at, am I correct that you're asking about this notice of the three?
Yeah, there's a I don't know what it says, witness A and witness B, or person A and person B. And then y'all said, or she said, there was a supplement that actually identified who those people were. So.
Witness A was Mr. Copeland, and in that notice, we talk about the statements that Mr. Garlington made to Mr. Copeland. Witness B was Quindarius Zachary.
Okay. All right.
And he's talking about statements that were made by
all right.
Defendant Stillwell and Defendant Kendrick.
Okay.
And
yes,
I agree with 1 and 2. 3, I'm not sure has played out in actual testimony.
Okay. Do y'all know who 3 is?
I think it says Donovan Thomas Sr. to his brother, but that wasn't co-conspirator.
There's only an A and a B that are like not identified people, right? Okay.
He sent a 3.
Okay.
But 3 is not a co-conspirator statement, correct?
Okay.
So there's only 2 co-conspirator statements, alleged co-conspirators.
Okay. All right. So with regard then to.
Exactly, Kiki. What is going on? What are we doing here?
Damone Blaylock, Your Honor, there are statements that are made, well, there's social media that we have identified. Damone Blaylock is a defendant in this case who's been severed.
Severed, okay.
He, social media from the incident listed on the indictment that he was already tried for with one of the other defendants currently on trial.
Okay. And Lee is also a severed co-defendant, right?
Lee, yes.
Okay. How about Sledge?
Sledge is a co-defendant that already pled guilty.
Okay. All right. Yes.
You might want to know Mr. Lee, he resolved this case.
Okay. But I mean, he was at one point part of this indictment, the big indictment. Okay. All right. So then really for everybody that was a part of this indictment, everybody was charged under the RICO count, right?
Yes.
Okay. So it will come as no surprise that the state thinks they are co-conspirators because the state literally alleged that in the indictment. So at this point, there is an objection that they don't have notification of what the statements are. And we are several months in. How quickly can you get to them the detail about what you think co-conspirator statements you intend to introduce?
Oof.
Go ahead.
The judge don't snap in a second. Like, why don't y'all know this?
Your Honor, not certain what amount of time the court's willing to allow us to identify anything not already identified or in the indictment. I don't know if a week exceeds what the court is willing to give. It's what we would ask to identify
If it's
within
not
the discovery already provided.
Right.
Identify specific statements that are there. We would ask for a week to identify
Right.
that.
All right.
if it's not identified by
Mr.
now,
Harvey, your objection to delayed notice. I am going to overrule that objection right now to the admission of the evidence. We, of course, still need to know what the actual evidence is. And a part of the basis for me overruling that
Is
is
what?
that it appears that the whole trial has kind of been operating on a rolling basis with regard to the evidence. And there have been orders even that, hey, every other Friday, let's talk about the evidence that's coming in for the next 2 weeks. And so if that's been the understanding, then so be it. But I want that to stop right now, which is why we are going through in what I consider to be painstaking detail, because this really should not be what the court is spending its time doing. This is what y'all ought to be doing on your own. But I want us to get on a track where the litigants know what is potentially coming in against them, less than here's the universe. And I want us to be efficient, but I don't want y'all, anybody, either side, having to try the case sort of, blind, or practically blind. So now that I hope we all are getting a better understanding of how it ought to work moving forward, I am going to give y'all, because I've given y'all a lot of other tasks as well, 1 week until next Thursday to get all of that in detail, including anything in wiretaps, including anything in jail calls to the defense.
watch.
Okay.
That week gonna come, they still not gonna be ready.
You look like you want to say something, Mr.
They're gonna put it off to the
Okay.
last minute.
All right, you're welcome. Okay. So what else can we get done today?
Just to address a matter that the court asked me about before lunch. The court had asked,
Oh, she gotta go to the podium.
when I represented that my understanding, if I'm not mistaken, was that the matter of disqualification of a judge was not competent evidence to be used in the trial. I think I said
Yes.
something akin to that.
Yeah, and you said you had some kind of law that
Yeah,
you could provide to us.
What
Yes.
what I referred to was Georgia Uniform Superior Court Rule 25.6, and my understanding of it.
Okay.
If it's different than the courts, then that's not unusual. But the last 2 lines of the rules say that if a motion to recuse It sustained the selection of another judge to hear the case shall follow the same procedure as established in Rule 25.4. Any determination of disqualification shall not be competent evidence in any other case or proceedings. So the way that I understood that, and of course that rule is, cited in other cases, for instance, not for the proposition that the disqualification is not competent evidence. It's just cited in a block cite in Evans versus Williams, 341 Georgia App 226. But that's my understanding. If my understanding is not in line with what the court's understanding is, we would have other arguments against the idea that somehow the recusal of the former trial judge is competent evidence and in some way relevant to whether or not the defendants did or did not do what they are alleged to have done.
That rule don't speak to that, though.
It's
That's
not relevant evidence as to whether the defendants did or did not do what they're alleged to have done. It cannot in any way be evidence of that.
I mean, I was as to relevance. That was
Okay.
why I was saying.
All right, so relevance will be a separate issue from whether it is, and I can already anticipate the argument because I would make this argument. What you just read says any other case or proceedings.
Right,
What
not
does
this
that mean
case.
for the case that it happens in?
Right.
So I think we probably need a little bit more research.
And that is what I sought
Okay.
to do over the lunch hour, but I did not find
Oh,
any
my
Georgia
goodness.
case law that
Okay.
elaborated on that. I didn't find any
All right, we'll have a
case law that
seat then.
elaborated on
Okay.
that. And so that was
All right.
that was where I stood.
All right, sit down.
Okay. Well, thanks for letting us know what it is you were referencing, and I'm not sure if it actually answers
Applies.
our question or not. And it might not need to, because the relevance issue may be what answers that question, because we cannot, well, and it may be that, I don't know, I will entertain whatever y'all want to submit on that. Either competency wise or relevance wise, although I think I pretty fully understand the defense argument on it, but okay, thank you. So
We might well go home. We didn't waste the day.
I know we're not quite ready on the Copeland evidence.
We didn't really waste it. We got some good stuff.
I think we have sent out some of the transcripts we've got already. So we're not ready on Zachary yet. Are we ready on any part of Zachary? How about the part y'all had notice of?
Any more secret transcripts? That's what we want to cover.
Yeah.
What is secret transcripts?
It's not even showing that I have a message, but okay. So that's a problem.
What is
Yes.
secret transcripts at? Y'all find the secret transcripts and then finding Woods go find the money.
So regarding Zachary, when we're talking about the co-conspirator statements,
Bonnie, go find that $1 million that Nathan Wade ran off with. Oh man, she need to put a stop to this. Bonnie, come put a stop to this. Withdraw this charge.
we've
These
been
charges.
talking about Mr. Quindarius Zachary in different kind of contexts here. We've spoke of him having approximately 9 hours of statements.
Right.
And we're also speaking about him in context, as I understand it, with the co-conspirator statement. One statement allegedly stated by Mr. Stillwell to Mr. Zachary, that we caught nut down bad. And then another statement allegedly made by Mr. Kendrick to Mr. Zachary saying we caught nut down bad. Is that correct? Those are the entire co-conspirator statements to Zachary that we're talking about right now.
Judge,
Yes.
She don't want to talk to him. She's at
Zachary's interviews, the entirety of those interviews and everything that he alleged that a co-conspirator told him in those interviews are statements of co-conspirators we intend to use in this trial. So he has said, and we identified that because I thought it was pretty specific as it related to the Donovan Thomas murder, what it is that 2 defendants currently on trial are alleged to have said.
Okay.
But within those interviews, he talks about other co-conspirators and acts, for instance, the shootings, the buying of the shootings of one of the incidents that are alleged as an overt act in this indictment. He talks about his role providing guns to members of YSL.
Okay,
and
so the
statements
answer
to-
is no, it's not just those 2.
Right, it's the
Okay.
whole state.
No, it's not just those 2.
Flag on the play.
It's
Well,
all-
some of
And
the stuff-
so,
My understanding is the state is saying, and I don't know if this is true or not, but the state is saying at this point, to the extent that they know, that Mr. Zachary's taking a stand. So that's what I understand him saying. And so him saying that he provided guns to people is not a co-conspirator statement if he's taking a stand. I'm saying what the state is saying is a co-conspirator statement involving Mr. Zachary. The only thing we've has been identified to us is those 2 statements,
okay.
which are clearly, in my opinion, spilling the beans. I mean, we're in the same predicament as the other. That's going to be our stance, but I don't know. I can't answer the other statements that I have not been identified specifically.
The statements that the statements that Quindarius Zachary gave to the police, I'm certain everyone is aware within those statements contains statements made by other people within YSL. When he's talking about the acts that were committed, he is talking about conversations at times that he has with other members of YSL. He may, for instance, at one point talk about what Antonio Sledge told him to do or something of that nature. Antonio Sledge's statements to him would constitute a co-conspirator statement. So to the extent that we have given to them the interviews of Quindarius Zachary and have noticed them that he is our witness, our position is that the interviews and what is within them, it is a discrete set of information that they have noticed that we are using that.
All right, so I think I hear you saying that with regard to anybody named with at least 1 count against them in this indictment, which is everybody in the indictment, that anything that they say to anybody is a co-conspirator statement, potentially, because they're co-conspirators with the other co-indictees. And anything that they relay was said to them by another either indicted person or person who has admitted in judicio to being a member of this gang is also a co-conspirator statement, and that the defense is basically on notice of that anyway?
If it is contained within an interview that we have given to them,
Okay.
yes. If it is a statement that is made to someone alleged to be YSL, yes. If it is a statement
Not just alleged to be YSL. I mean, if you're saying they've got automatic notice of this, they need to, it needs to be more than somebody's alleged to be YSL for them to, if you're saying, hey, my notice already based on this indictment and me giving these statements over is sufficient notice.
The only reason I said alleged is that the people here have not, we're on trial. So.
Right, but they're co-indictees.
Yes.
So I was talking about people other than the co-indictees.
Yes, I see what you're saying. Yes, any statement, yes. To answer the court's question earlier, then yes. To the extent that we have given them that interview, yes.
All right, and so are you
Judge, I wanna-
seeking to say, and maybe this is where Mr. Shard is asking for some clarification, that for all of those people, which is essentially everybody we talked about, that the most detail you're going to give them is you have their statements,
No.
or are you going to break it down further within the next week?
We will break it down further, but there are only, I think, the people who've pled, and Quindarius Zachary and Kenneth Copeland, who were not indicted, that
Okay.
fall up under that umbrella.
Does that answer at all your question?
Can I explain how it really doesn't, and it's kind of to move from the theoretical,
Yep.
the theoretical to the reality.
Yep.
The reality is these statements. For instance, Mr. Zachary gives a proffer. There's like 4 district attorneys and probably 4 investigators in a room with Mr. Zachary and his attorney.
Okay.
The district attorney, it's really the investigators are just peppering him. Well, tell us about the Lil Wayne bus shooting, or tell us about the shooting on, someone's house.
Mhm.
And to the extent that, now I get it if Mr. Zachary's saying he was there for a certain event, but there's discussion of a lot of it. The shooting of the convenience store on Cleveland, I'm just making this up,
Yeah,
Cleveland
sure.
Avenue. And I'm just going to use my client's name because he knows I don't mean anything by this. Well, yeah, I think Shannon did that. I think Shannon did that, and that's my understanding. And there's no real. These aren't lawyers asking the question, and there's no indication of what he's basing it on, who told him, who he's saying told him.
Right. So
and
you
everything
need
else.
to know in
Right.
more detail.
Who
Is
the
the
source
state,
is.
well, is the state planning to use, I think Shannon did that.
Right.
Is that
and-
what you want to know, so that we can then drill
Exactly.
down on, is there any basis for that coming in?
Right. I need
that
to
what
know
you
what
mean?
the statement is. If the state knows, now obviously if the statement says, Mr. Huey told me this, then I understand that
Yeah,
he's saying the
okay.
source is Mr.
Okay.
Huey. But there's just so much information that's just
Okay.
like being thrown out
Okay.
with no declarant, no identified declarant.
Sure. Okay. So first things first is you identify within the next week what parts of each statement you intend to use, because it may be that you are not going to use, I think Shannon did it. And so if that's the case, we won't worry about it any further. So identify them. And if you can also, before the end of the week, before a week's time is out, identify the source. If it's not readily apparent, do that as well, but at least get them each statement. And so we'll go from there. Okay. All right. So what else do we need to think about? Because I mean, and I hope we can actually go through more evidence, but all of what we're doing right now is productive, even though we're not hashing out the details. We're at least winnowing, narrowing, which is good.
Jail calls.
So I don't have an agenda anymore. My agenda got hijacked.
No, you got one, or you would have threw the case out.
What else can we do that's productive today?
She got an agenda for sure.
Anybody have any ideas?
You don't want to let this case go.
Mr. Steele. Okay.
I could get you brief very fast, but I argued this before the recused judge and it was denied. Former judge would not give me a certificate. I took it to the Court of Appeals of Georgia under the collateral order doctrine. I lost, and then the Supreme Court of Georgia denied cert.
Okay.
But there's a ruling on it.
Okay.
So if you don't want to rehash it.
I don't even know what you're going to ask about.
The indictment is fatally defective.
Okay.
So I could take a quick count, if you don't mind, right now, and it should apply to,
Okay.
definitely applies to Mr.
All
Williams.
right. I don't know. I mean,
Let
if
that
it
go
is something
That ain't really relevant.
right offhand, if it,
Say that for later. They're not gonna throw the indictment out. We can get some more good stuff done.
Go ahead.
Okay, well,
Go ahead.
it's a general demur. I was going to do it again at appropriate time, but since you asked.
Since we don't have anything else to do right now. Okay.
So in count 56,
You know what? Let me grab my
Indictment.
copy of the indictment.
I'm gonna pull up mine too.
Okay, count 56.
I'll get you the page.
Give me a minute.
It's page.
Okay, got it.
29.
Page 90.
Oh,
Okay, so that charges Mr. Williams, I'm just using this as an example.
Oh,
It
okay.
repeats charges Mr. Williams with participation in criminal street gang activity.
baby, I must got
And
old
it
copy.
gives a date range. And it says the essential elements need to be there while occupying a position of organizer, supervisor, or other position of management or leader of the criminal street gang. YSL did engage in directly or indirectly or conspire to engage in any one of the following acts of criminal street gang activity. And that lists murder, aggravated assault, deadly weapon, armed robbery, hijacking, and motor vehicle.
Selling
Sorry, I
marijuana.
apologize, Ms. Winfrey. Okay. Participation in criminal street gang activity for that said accused in the county of Fulton and state of Georgia on and between the 12th day of May 2018 and the 8th day of May 2022 while occupying a position of organizer, supervisor, or other position of management or leadership of the criminal street gang YSL, did engage in directly or indirectly or conspire to engage in any one of the following acts of criminal street gang activity of YSL, to wit, murder, aggravated assault with a deadly weapon, armed robbery, hijacking a motor vehicle, sale of marijuana, possession of marijuana with intent to distribute,
Theft by
theft
receiving.
by receiving a firearm and possession of a weapon by a convicted felon contrary to the law.
Okay.
State good order, peace, dignity thereof. They're going to repeat, but Your Honor, my belief is that the grand jury, by and through the Fulton County District Attorney's Office, did not allege a material element. There are
Okay.
4 material elements in violation of criminal street gang activity. And there's going to be a jury instruction that the court, one day is going to give to the jurors. There is a jury instruction on this crime. I'm trying to get you the pattern jury charge that gives the essential elements. And that would be
And the elements are pretty much check boxes that the jury have to go through one by one and find them all beyond a reasonable doubt for each defendant. And what still is saying the grand jury, when they
pattern jury instruction
I'll let them finish talking.
2.02.25. And there's also case law that one of the essential elements is that the crime was committed to further the interests of the gang. That is omitted in count numbers 56 and 57 for Mr. Williams. There are other people here charged, Your Honor, that has the same issue,
Okay.
but they're different count numbers. And the way I understand the law is that the fact that the statute does not give the mens rea every crime has to have the mens rea attached to it, and that when the legislature or Congress does not include the mens rea, the courts say that the omission from a criminal statute of any mention of criminal intent should not be read to dispense with that essential element. This rule of construction reflects the basic foundational principle that wrongdoing must be conscious to be criminal. And here, and that was, I'm sorry, under MORISSETT versus United States. That's 342 US 246 at 252 1952. It's also explained in Elonis, ELONIS versus United States, 575 US 723 at 734. It's a 2015 case in Division 2.
I'm sorry, 575 US.
723
Okay,
at 734. It's a 2015 case.
okay.
It's in Division 2B.
But the
And that
indictment,
specifically says that the fact that the statute does not specify any required essential element, including mental state, does not mean that one does not exist. And here, what happened is there was a challenge years ago under Rodriguez from this courthouse, Georgia Supreme Court, said in order to save, or that it is a constitutional statute because it's not a denial of freedom of association, because you don't have the right to commit a crime in furtherance of the gang. That became an essential element. That changed our jury pattern instruction.
Yeah.
And our grand jury did not, in our case, did not allege that.
Okay.
So I know that there's a lot of argument about, well, this is a gang case, and then 418 kicks at 24-4-418 kicks in. But I believe that the charges for the gang is not appropriate. I
And
wrote,
did you say, I'm sorry, did you say that, what did you say the Court of Appeals did?
it didn't take it up.
They didn't take it up,
I
okay.
didn't get under Dukes, DUKES. I don't have, Judge Glanville denied a certificate.
Oh, okay.
They never.
I thought you sought, but you did not secure a certificate. So then you took that up under the collateral order rule and.
Did not, they said it's not a collateral order. I
Okay,
needed a
all right. So they
certificate.
gave you an opinion on the merits of, is this a collateral order thing you can take up?
And then
Okay,
and then they dismissed the appeal. So there's no
right,
rule of the case.
okay.
they were indicted like 2.5
That is,
years ago.
A couple of counts for Mr. Williams.
So I
We
guess
got
he's
6.
just putting this on the record, I guess.
Then the conspiracy, which we're talking about. Okay, I'm sorry.
So you said that with regard to counts 56 and 57, it is not alleged.
I promise that.
Okay.
in those two
And
counts.
are there other counts that are alleged against your client, Mr. Williams, where that is an issue?
Yes, there's an
Okay.
essential element in count 1,
Okay.
which is the RICO count. And I compared it, I just did it because, it's such a well-known case, to the Donald Trump indictment out of the same grand jury courthouse.
Uh-huh.
Nowhere in count 1 will you see that any of these individuals have been charged with joining the conspiracy knowingly and willfully. It is not in there. And that's RICO conspiracy count starts, I think, at page 12, but hold on.
All right. And so you're saying nowhere in, I'll read it. It's pages 1 through 68 of the indictment. But no, I'm sorry, 12 through 68. You're saying nowhere in that 50-something pages does it allege any of this was to further the interest of the gang?
No, I'm saying that it's a different.
No, that's not what you're saying, or no, it's not in there.
I'm doing a different issue in
Okay.
count 1.
Okay.
RICO conspiracy.
All right.
The grand jurors charged that Mr. Williams and the others who were here, also the others who were not here,
Mhm.
unlawfully conspired to acquire and maintain directly and indirectly an interest in and control of U.S. currency and other personal property through a pattern of racketeering activity
Mhm.
in violation of OCGA 16-14-4A, as well as 4B, as well as B. But what happened there is, I went through it hard. There is no allegation by the grand jury that Mr. Williams or anybody knowingly and willfully joined the conspiracy. And under Cotman, which is COTMAN versus State, which is 342 Georgia Appeal, 569, it's in Division 2.
Okay.
The 2017 case. That is a teacher from the APS trial. It was also a RICO conspiracy case.
Mhm.
The Court of Appeals of Georgia held that in order to commit a conspiracy under the RICO statute in Georgia requires proof of the material element that the accused knowingly and willfully joined the RICO conspiracy. That is also in MacArthur, which is McArthur versus Beach, which is BEECH. Haven, which is HAVEN Baptist, BAPTIST Church of Athens. Your Honor, it's 368 Georgia Appeal, 525, it's in Division 3. 890 Southeast 2D, 427, that's a 2023 case. Cotman specifically wrote that under Georgia law, a person may be found guilty of the crime of RICO conspiracy if that person knowingly and willfully joined the conspiracy, which itself contained a common plan or purpose to commit two or more predicate acts. There's also Wiley, which is WYLIE versus Denton, DENTON, which is 323 Georgia Appeal, 161, it's in Division 1. It's a 2013 case where our second highest court wrote the material requirements needed for a conspiracy under the Georgia RICO statute is for the person to knowingly and willfully join said conspiracy. There's another case called Z, like in the Honorable Lawrence Zimmerman -space, SPACE, Inc. versus Dan Tanners, DANTANNA CNN Center, LLC, and that's at 349. Georgia Appeal 248. It's a 2019 case. And what I used also was, I just looked at Donald Trump's indictment. I was interested in it.
Mhm.
He is not only the former president, but the other alleged co-conspirators. They are charged several times with knowingly and intentionally joining this conspiracy. And it's not here for Mr. Williams. And mens rea is a material element of the crime and must be alleged in the indictment. That's in Eubanks, EUBANKS versus State, which is 317 Georgia, 563. It's in Division 4. It's a 2023 case.
Get that man some more water.
So, you know, as you're going through this, if you're going to reconsider it, I will bring it up later, obviously, because I believe at a directed verdict motion, that would be relevant as well. But, you know, I don't know what it's like ever to be a judge. And I certainly don't know what it's like to come into a case like you're coming in. So if this helps, this is ripe under State versus Heath, HEATH. Once the jury is sworn, a general demurrer can be made orally or in writing. I actually put this in writing.
Okay.
But I waited till the jury was sworn, and I did that,
Okay.
I mean, intentionally, because jeopardy attached. So.
Sure. Yeah, and if it is already in writing, I'd love to have that. And I assume this got argued at one point before if the
Yes.
prior judge made a ruling. So if there's a written response from the state, point me to where I can find that as well. If there's not, point me to where, like what date it's argued.
I have the order,
Okay.
and I filed that in a motion that I gave to this honorable court.
Okay.
I'll get the motion, I attached it, but I didn't give you my brief. So if the court's permission, and of course, the state has it already, but I'll resend it.
Is it filed in the case somewhere or?
Went to the Court of Appeals.
Okay, that brief.
whole-
Yeah, sure.
the whole briefing.
I'll take it all.
Okay.
And
there's-
then I'll assume the state filed some sort of a response, maybe not this team right here, but, and it may have been that more about that was about collateral order or not, but I'll take it and read it for whatever it's
No,
worth.
the state argued, and then they wrote the proposed order, which was signed by Judge Glanville. So,
Okay.
and it's a long order, it's
Yep.
12 pages.
I'll take all of that.
Okay. So I thought that would be, if you grant it, it would be helpful because it would knock out all this work.
Yeah, it would. That is
So,
true.
so he argued this
Thank you.
before
Thank
already.
you.
I'll get you that brief.
I was
All right,
wondering why
appreciate it.
he
Your
waited.
Honor, I'd also point the court's attention to the transcript dated December 11th, 2023. It was filed on that date
Okay.
of at least one of the hearings where we addressed Defendant Williams' general demurrer claims.
Okay. Is it a transcript from December 11th or was it filed on December 11th?
It was filed on December 11th. It was held on November 20th, 2023.
Okay, thank you.
And it was specifically as to Defendant Williams' plea and bar / motion.
Great, thank you, appreciate that. All right, Mr. Harvey, you look like you also were maybe gonna stand up and come up with something we could do. Oh, and you know what? Hang on, sorry. If I don't do things when I think about them, sometimes they escape my mind. So I understand that for Mr. Williams, that is count 1, count 56, and count 57 you're alleging are fatally defective. And you mentioned that may be true about other defendants as well. Are there other defendants who either have already made or intend to sometime before this goes to a jury make a similar argument with regard to counts that you have against you?
They got the Harvey
Oh,
rule.
right. Yes, the Harvey rule. Thank you. Okay, but if you are all joining in, can you tell me, is this essentially true about every one of the gang counts that they're missing? Okay. All right. Then I can sort out for myself which ones go to which person. All right. Now, Mr. Harvey.
Okay, there you go.
And this is more of an afterthought. At least I'm still having thoughts, whether they're before or after. I want to make an oral motion at this time to prohibit the state or anybody else from talking to witnesses while they're on the witness stand.
Huh?
Judge Glanville would give an instruction which was incorrect to witnesses. Don't talk to anybody but the parties in this case while they were on the witness stand. The only one that is the only people that are accepted from the no talking rule once a witness is on the witness stand is a criminal defendant and the defense lawyer, because that's a Sixth Amendment impediment. The case, as I remember it, is Perry versus Leak, Perry versus Leeke. It is a United States Supreme Court case, which indicates that other than the defendant, witnesses or parties are generally prohibited from talking to witnesses once on the witness stand. So I would like an instruction. I can write this out. I can ask for an instruction.
That'd be great. I know you don't have to write out the motion. I mean, it's fine. I'll entertain it orally. And I mean, that's generally my understanding as well, but it's been a minute since I've practiced. It's been a minute since anybody raised that issue. Is there some kind of an exception for I mean, I know if you're on the stand and then we take a lunch break or a restroom break or something, that's one thing. Is there anything about overnight that is different?
Only for the defendant
Okay,
and the defendant's counsel. That was the whole basis of Perry versus Leak.
all right.
The state said in Perry versus Leak, hey, you can't talk to your client while he's on the witness stand. And the Supreme Court said that yes, because there were Sixth Amendment implications, that a defendant and a defense lawyer could, but generally other witnesses could not.
Okay.
So you're
Hazy
close.
memory.
Yeah.
All right. Does the state have a response?
They don't want the state talking to Woody.
I believe that the rule that Mr. Harvey is referring to essentially is the rule of sequestration, and as it relates to other witnesses and about talking about the witness on the stand's testimony. The reason I was looking feverishly is that Ms. Hilton and I had actually discussed this, and I had sent her a case,
Okay.
not from within Georgia, but it literally spoke directly to it. So I was at
Okay.
least looking for that.
All right.
Because I don't think that under the rule of sequestration that attorneys, I think that Judge Glanville had it right. Attorneys are not prohibited from speaking to witnesses, but I want to make sure that we get the law.
Let's
to the court.
make sure we get it right. So
So quit speaking to witnesses
I'll
until we figure it
submit
out.
whatever you want to submit on that as well. All right. Thank you all. We're gonna take a recess right now. If there's not anything we can do immediately.
We're done for the day.
And we will be back at 3 on a Rule 22 matter. Y'all got that notice, right? That there was a new Rule 22 filed?
Is this it? I think that's
All
Kayla's.
right.
I think Kayla filed a Rule 22 because she wants access to the court. And the deputies were keeping her from the court. So we should be back in 10. What about maybe 18 minutes? Okay, so yeah, for Kayla. So we get to see what Kayla's Rule 22 motion is. But from my understanding, when we went to the lunch break, I had a chance to go over to Kayla's channel for a quick second and listen in. And I just sat in the background and I sat in the chat behind the scenes and hid in the bushes. And apparently, Kayla, I think she said that they didn't see her hugging. It was only the defendants in the courtroom at the time when, she hugged. It was nobody there. I think she even said she the one that told the prosecutor that she did it, like as a joke. So it wasn't like court was in session and she was just going around hugging the defendants. Oh, and it's just so I don't think, if there's nobody in the courtroom and you see somebody you know how we do. We could see somebody we don't know in the grocery store and we might speak to them. Hit them with the how you doing, even though you don't know them. So of course, if you see somebody you know and nobody's there, maybe just a deputy, she might have just spoke to him real quick. So I don't see nothing wrong with that. So I didn't see nothing wrong with Kayla. But now the issue is, now that she outed the mole, she told on the deputy, and the deputy supposedly was harassing her all day when she was in court on yesterday. I wonder, what they're gonna do with this Rule 22. And let's see what an actual Rule 22 say, because I'll be hearing about it a lot. But their rules are different in Georgia versus here in Texas. So let's see if we can pull it up. All right, if y'all think I'm gonna read all this. Let's make it bigger. We're gonna kind of skim through it. Open courtrooms are indispensable. So this is a rule that governs the use of electronic devices, including mobile phones, computers, and stuff as such. Such use is generally allowed by lawyers, employees of lawyers, and self-represented parties. But to ensure decorum and avoid distraction, such use is generally prohibited by jurors, witnesses, parties, spectators, including representatives of the news media. Such persons may, however, use their devices by stepping outside the courtroom, and nothing in this rule prevents a judge from permitting parties and spectators to use their devices for non-reported purposes, as the judge may allow in his or her discretion. A court must use reasonable means to advise courtroom visitors of the provisions of this rule and must make the form in the Exhibit A available in its clerk office and website. Okay, so we got the form. What's the form? Okay, so basically it's a request to use a recording device. So I'm assuming that Kayla wants to stream her YouTube channel while she's in court, or does she just want to use her cell phone at all? Because they haven't been letting her use her phone while she's in court. Pursuant to Rule 22, okay. And I think Kayla said that she may appear on camera today in court with respect to this Rule 22. Let's go with okay, so we have definitions. We know what a recording device is. Jurors shall turn the power off, so jurors can't have anything. Witnesses can't have anything. Parties and spectators may use recording devices to record proceedings as authored by the court. So the court has to give permission to everybody else. Let's see about attorneys. Unless otherwise ordered by the court, attorneys representing parties in the proceeding and self-represented parties may make audio recording of the proceedings in an uninterrupted manner. So I think Kayla's argument is she can have her phone because she is an attorney. Even though she's not a quote unquote attorney in that proceeding, see, they didn't clarify in rule number 2 right here. In number 1, it says you have to be an attorney in the proceeding. It says, unless otherwise ordered by the court, attorneys representing parties in a proceeding or self-represented parties. But number 2, it don't say attorneys representing parties in the proceeding. It just say attorneys. Use of recording devices for non-recording purpose. Attorneys and their employees, such as paralegals and investigators, may use recording devices in the courtroom. And I believe Kayla was saying that the bailiff had a problem with her using her phone. And that's why she told him that he was the mole. She said, "You're not going to bully her." She said, "You're not going to bully me, bailiff." She said, "Matter of fact, I'm going to let y'all know." Law Malcolm said, "You got a lot of time." Well, I actually had court today, but I was able to do it on a Zoom link. So when we took our lunch break here, I went to an actual courtroom through Zoom, Law Malcolm. So that really helped out a lot. We jumped on there, and I made it back in time. We were actually waiting on the judge. That's why I left during the lunch break today. Yesterday, I stayed on during the lunch break, and we summed up the case. She said, "Thanks. She needs to be able to check her mail for work." He said, Kayla don't got no cases in Texas she working on right now. She want to be a part of this trial so bad. But Jiggy, you don't give a no slack. But it would be good for like the YouTube community because a lot of us don't live in Georgia. So if she's there and she's able to, you know, give us feedback because she's in the courtroom getting firsthand, and we still waiting on the court to come back. If she's there to give us firsthand knowledge while we on live, I mean, I don't see a problem with it. So you can't bully our gangster. And remember, Jiggy, she really wasn't even attached to this case. She was just brought in to help. So, I mean, she didn't know that Woody was going to be called to testify the exact time his regular lawyer had to, you know, had a vacation scheduled. I mean, there's no way she could have planned that. I mean, it just the way the cards fell. Well, I don't know if she's asking to record. I'm thinking she's asking to be a normal lawyer in the courtroom. She basically saying, as an attorney in every other courtroom in the building, I can have my phone even when I'm not working on a case right then. I can check my emails. I can correspond with other courts while I'm sitting there. And she's basically saying this deputy is not allowing her to even be on her phone. I don't even think she was trying to like take a video. He wasn't even letting her be on her phone. But I guess the Rule 22 would allow her to be on her phone and potentially record. Breaking it down, B says, no, we do not need Kayla. No, I'm just playing. She said, you know who I'm talking about with the Rule 22. She already doing too much. Boy, y'all don't give her no slack. What? I'm trying to figure out why did like when was the shift? Like why so many people don't. I mean, she has a big following. A lot of people like her. But I'm trying to figure out like why a lot of people like turned against her. Like, what she do wrong? I mean, it wasn't, in my opinion, her fault that the judge had a secret meeting and got her like caught up in all of this. Politically, she just needs to sat down. Because she needs to stop. She is not being professional. So, okay, so how will we find out? If she's not in the courtroom, I understand. I think it's like another reporter or two in the courtroom. Right, that's exactly what she's saying, Jiggy. I feel like her motion is basically saying, put some respect on my license to practice inside this courtroom and treat me like a real attorney. Yeah, I agree. Because sometimes they try to play you if you let them. But my thing is, if this bailiff know that he was doing stuff he had no business doing, like he leaked the meeting, and he was letting Kayla take all the blame. So she's been taking all the blame for this Deputy Brown, for him revealing this secret ex parte meeting. He didn't come out and say it was me. He let Kayla take the heat. He let Kayla almost go to jail for 20 days. And then he had the nerve, the gall, to go up to her in court and harass her about her phone. Like, dude, are you serious? And she said, oh, I got a trick for you. She said on her live, she said, thank you for the content before she left court yesterday. And she, pretty much exposed them. She said, I sat quiet for you while I got in trouble and was almost put in jail. I had to hire lawyers. and then you're gonna mess with me about my phone. I'm gonna tell everybody you was the real mole. But she said she gonna get her Rule 22 signed. But I wonder, I don't know the rules and if they can oppose it. Like, who can oppose the Rule 22? Let me see. Because I wonder if the state would oppose her. I don't even know if they have standing to oppose her, or it's just the judge's decision. Because judges usually control the courtroom. Well, I don't think she's trying to expose. She actually said last night on her live, it was brought to my attention here while we were here. People was coming in the chat saying that she actually said who the deputy was, Deputy Brown. And I think that was going on while we were on live. And I think I was able to catch a few minutes of a clip. And I don't think he actually was setting her up, but I think he let her take the fall for it. While he knew the whole time it was him that actually leaked the meeting, according to Kayla. So this same deputy who leaked the secret ex parte meeting happened to be a deputy in the courthouse when Kayla was there on yesterday, and he was harassing Kayla, apparently. And I guess she said, you know what, I've been protecting you this whole time. And then you have the nerve to harass me about my phone? Are you serious? So I think that's what kind of pushed her to tell it was him. He the leak. I was gonna say the sneaky link. No, he the leak. I don't know what he looked like. Somebody said they were trying to get a picture of him, but I mean, I don't know him from what they call. I don't know him from Adam, so it wouldn't really matter to me what he looked like. But his main problem is going to be if he was, back there telling deputies turn off your body cameras, which is weird. He told them turn off your body cameras so we can have a secret meeting, and then come out and tell the defense lawyers about the secret meeting. Like, what? This is some crazy stuff. So y'all saying everybody else can have the Rule 22, but not her? Is that what y'all saying in the chat? Oh, okay. You say it gotta be him. He was the only officer in court every day, and we seen him the most in the others. Okay. Y'all, boy, y'all don't play. I'm trying to keep it even. Yeah. But see down here, we ain't got all of this. I mean, we expected to have our phones because that's how we communicate. When I had court today on Zoom, judge want to reset for 2 weeks. What day of the week works for you? You don't pull out a paper calendar no more. You pull out your phone. And most attorneys use software now where our calendars are linked with our legal assistants, paralegals, and other attorneys. So everybody's calendar can be in sync. And it also links with your clients. And it tells your clients, sends them text messages like you got court in 3 days, you got court in 2 days, you got court tomorrow. So there should be no reason you missing court. And you sure better not miss it if I'm on your bond. In Texas, we have what's called attorney's bonds, where we don't have to go through bail's bondsmen. Attorneys can bond you out. But that's a double-edged sword because, you know, you bond out somebody that you really don't know like that, and they go missing, and you have to pay that whole bond to the court, the full amount. Regina said, get your Rule 22 and have 2 seats. That's funny. I don't see nothing wrong with it, though. Let's see. Let's see if we see Kayla. Let's go.
All right, where's Ms. Bumpus?
Oh, here we go.
That's who filed the Rule 22.
Where's Ms. Bumpus? Shout out to Kayla.
Good afternoon. All right, so you filed a Rule 22 at what, 11:10 or so? That's fine. The night before last. So, and you had said
Come on here,
that
Kayla.
you wanted to start recording for yesterday. And honestly, I didn't even know you had filed it until we were finished with the court yesterday afternoon at 4 something, because it came in so late. And normally the Rule 22s go to our public information office, but I know about it now. And so I have provided notice to all of the parties, and I will listen now to or ask if there is objection
She got her
from
dress
any
on.
of the parties or witnesses or victims to the Rule 22 filed by Ms. Bumpus.
Hilton, look at your friend.
So
No, I don't think she would a lawyer no more.
I am not real. So what are you looking to do?
Your Honor, I just want to be able to record what's going on in the courtroom.
All right. And you had already, I guess, yesterday live streamed from somebody else's
Yes,
live stream. Miss, what is that person's name?
Miss Sylvia.
Miss Sylvia.
Yeah,
So-
she's sitting in the courtroom.
Okay.
So why you can't keep? I guess you're gonna ask why you
All
can't keep
right.
doing
So
that.
there are an inordinate number of separate Rule 22s in this case anyway. I'm not really sure why everybody is not using the pooled
Same one.
media that is already, I mean, it's like 8 or 10 media organizations are using one pool, and then there's Miss Sylvia who has a separate one, and then lots of people who have the ability to take still photography and audio, and it just
Give it
yeah,
up.
it's
Well, you
like
give
8
it
or
to
9
her.
different things. But I am not sure that yet another person doing essentially the same thing
Wow.
adds to the public's access to this proceeding. There is 24/7 coverage of this.
Okay, Miss
a
Love.
pooled camera
Miss Love.
and Miss Sylvia's separate video recording that you can access anyway, apparently.
Right.
So, I mean, if you want to be heard as to how that either increases the public's access or helps with the dignity of the court or the administration of justice or the truth-finding function of this proceeding, I'd willing to listen to what you have to say.
Your Honor, I'll be brief. I just would like to say that at any point, these other people who are part of this pool, they have logos and they can pull what I am streaming on my personal YouTube and do copyright issues. They have their own logo on there. And also, I don't always want everything that they are streaming. I don't need the full court hearing all the time. There are specific parts that I need to reference and informing the public of what's going on. And that's my point of being here. And I'm just trying to do everything right so that I can, pass the smell test.
Okay, so with regard to, I mean, obviously you can let the public know anything you want to, and you can video, blog, vlog, all you want to, any kind of opinion that you want to about the case. And you can obviously also sit here and watch all of the proceedings. Are you saying that you can't use somebody else's, like the news media coverage?
It has their logo on it. At any time they can say it's copyrighted and take it from me.
Okay.
From my page.
Have you asked anybody other than, is Miss Sylvia okay with you using her? Because honestly, it's a little bit disruptive to have essentially phones in court. I mean, it ought to be that unless you are somebody who has a Rule 22 already in effect, or you are an attorney
on the case,
in the case, you shouldn't have your phone out or on or anything. And it's kind of chaotic in this entire part of the courtroom. And I find it to be distracting. I find there to be security concerns with having to constantly figure out, okay, who is authorized to have their phone out, who is not. And so what I would like is, until there's some point when you find out that you're not able to use somebody else's, what they've already taped. I mean, I'm kind of saying, why don't you and Miss Sylvia be the second pool? Okay. Would that work?
We'll try it out.
Okay, so let's do that. Y'all are now the second pool.
You will revisit it if I have an issue.
Sure.
Thank you, Judge.
All right. Thanks.
Come on, Kayla. Come on here.
Anything else we can do today? Or did I give everybody enough work that y'all can just go home and do your work? And y'all gave me plenty of work to do also. All right. So we are adjourned for the day. How about we see each other at 9 in the morning?
Come on here, Kayla.
Which doesn't mean when we get the jury back. If we get the jury back, I won't go back to 8:45. But let's see each other at 9 in the morning, and let's be ready to actually work on some actual evidence. Okay. All right. What is your expectation? Are we going to be able to, so y'all are getting some of the transcripts of Mr. Copeland's testimony so far. What all have we already shared? No? We don't have any of his testimony? I thought we had at least the 11th. When are we getting that? By the end of the day?
Kayla said she just want to pass the
That
smell.
was a really good question, Mr. Sharp.
The smell test.
I thought we were going to be doing Mr. Copeland's evidence tomorrow, but maybe not.
Did we ever get an answer, Judge, as to whether or not we have the transcript from the 10th? I know that Ms. Weaver indicated, excuse my seat, Ms. Weaver indicated that she was working on the one for the 11th. She might have it by the end of today is what I heard earlier. But you asked whether we actually had the 10th, and I didn't hear the answer to that.
So the thing is now, because the judge said, how about the mainstream media be pool number one and Kayla and Miss Sylvia be pool number two? So now is Miss Sylvia like a pool all by herself? Look at him. What he looking at? You boy, you better not be looking at no Kayla.
The answer to that is no, we do not yet have the 10th. We had portions of the 10th, but they were the other portions of the 10th. So hopefully by tonight, the court reporter will have both the 10th and the 11th. Y'all should have. Now, this isn't his testimony. This is y'all going through evidence, but y'all should have a rough of the 18th, the 21st, and the 24th already. And then the rest of it will be forthcoming. So
y'all are funny.
I don't know if we can work on Mr. Copeland tomorrow or not. I don't know what can we work on tomorrow?
He said, who the hell is Miss?
No point getting together as much as y'all are all delightful. No point getting together if we can't get work done. The 18th, the 21st, and the 24th.
Y'all funny.
No, so yes, that.
Yep.
So he testified on the 10th,
Oh
the
man,
11th,
y'all
and the
funny.
12th, and wow. Okay, he testified the 10th through the
Y'all
17th,
funny.
and then y'all took up matters about the evidence
I'm not
surrounding
even gonna
him
pull up what
the
comment I'm laughing
18th
at.
through the 26th.
I'm not gonna pull up what comment I'm laughing at. Y'all are funny.
All right. I think tomorrow might be more productively spent with everybody working on the things they need to work on. Tomorrow is Thursday, so let's get back together on Friday at 8:45.
Oh.
Okay. See everybody then.
Oh my God. Y'all are funny. I guess they disabled the link. I dropped the link, y'all. Anybody want to come up that has a camera and a mic, and y'all got something to say? Y'all better leave Kayla alone. She had already said on her live stream today, she said that she may have to appear in court, but she's not. What was the word? She's not dressed. she's not dressed like she would normally dress if she had the opportunity. Y'all are funny. Y'all are funny. I don't know what. Yeah, I don't know if she didn't know that she was gonna get called up or y'all are funny. Some of y'all comments just send me every time. I'm trying to get this swipe in my face. Oh my God. Y'all come and see me. Anybody want to come up? So we have had an eventful day after all. So we started out this morning with a secret transcript that we found out about with a judge, according to the defense, is calling them agitators. And they didn't like it. The defense got upset this morning and they went off. They said, how dare you, Glanville, call us agitators when we are representing our clients to the best of our ability? Why are you calling us agitators? Somebody say, Mr. Brown stopped that rule 20 years. Somebody stopped it. Because if it's already 100 people, 101 ain't gonna make no difference. But I believe the issue was when Kayla represented to the court that she had streamed the day before from Miss Sylvia's channel, then in theory the judge would be like, well, if you already streamed from Miss Sylvia's channel, why not stream from Miss Sylvia's channel going forward in the future? So it goes to show you, I mean, how did the judge even know that Kayla streamed from Miss Sylvia's channel the day before? Somebody done told her. Man, it don't matter if she knew her motion would be heard today. Attorney should just like attorney telling in the court. Yeah, I've had some judges. One lawyer showed up to this one judge courtroom without a tie, and the judge lost it. And I remember I had a situation. I had a polo shirt on at the airport on Zoom. But the judge, it was a last minute hearing, so they didn't care. But Brooklyn, NYC, it's saying that you are not connected. I see you are trying to come up, but it's not giving me a device. So maybe you're trying to hook up something. He says she's showing off her body. Yaddy. Well, at least those what's it called? At least the defendants, they've been in jail 2-3 years. They got to look at what they call some eye candy. They say, we haven't seen a woman in so long. So I know they're going to be talking about that, the boys, when they get back to the jailhouse. I know. They're going to be talking about that at the jailhouse when they get back. Y'all seen Kayla in court? Yeah, y'all are funny. She said, "Oh, political Mel said that was the intent." She set that up real good, huh? I don't know. What y'all noticed, Miss Love was kind of agreeing. Love was, leaning her head. Love will oppose anything. Love, golly, Love, let that woman have her damn Rule 22. Oh my God, y'all are funny. I gotta start reading y'all comments. Y'all finna have me up here laughing. What's going on with 305?
Talk that law, what it is, what it ain't, what it is.
Hey, so what's going on?
No, let me chin check a couple of these haters on Miss Gangster Kayla Bumpus. Let me chin check a few of them. Just 1 minute to talk that law. First of all, Kayla Bumpus is an independent black lawyer, and not many can say that is in this chat. If you can say that, come on up in the chat and talk your talk. Don't come behind the scene and say it. Come on up on the chat. You ain't even got to put your face up there. Just come on up and let us hear you. Now back to the day. They got that out the way. Back to the day. I think the whole thing is a bunch of BS. The trial is gonna go on. They got Woody in. The lady's gonna exclude the information that they previously had after the recusal of gangster, thug Glanville. So that's how I'm feeling today. It's pretty much in Woody hands. After Woody, they got nothing else.
Yeah, I agree. I don't think they have nothing important, so they would have had them already. You don't go through 75 or 100 witnesses and then bring somebody important. You would do that at the beginning.
No, talk that law. Everything being exposed right now is clearly that Judge Krause gave Glanville a pass. Whitaker sees it, but she's not going to speak on it, and she's going to try to shut anybody else up that going to speak on it. But Brian Steele is doing a wonderful job by just putting that law on it, on the record. He good at putting it on everything on the record. We know that. But
right.
I missed a little bit of it today, but I do know that that the judge has pretty much, been neutral. I'm with her. I feel her. I'm following. I said it Nash up on everything he said last night. I feel what he's saying. I think that Miss Love got a pass yesterday. You know what I'm saying? Because she could have just tore her on up, but she set on down real quick to let her know that you're not being truthful. You're a liar. You're lying, and I'm up on you. And so you notice that they switched sides, but they kept the babysitter in the middle.
Oh yeah, they're gonna keep him there.
She trying to get out the face of the judge. She avoiding that. You know what I'm saying? That's why she stacked the files up in front of her. The whole trial. Have you ever seen anything in front of her beside a computer?
So what you think?
She's hiding her faces, all them faces and stuff, all them smirks and stuff that she's doing, because the judge is watching her. He's watching her every reaction. She's watching her every reaction. Think about it now. They switched sides now.
Yeah,
Miss Hilton.
That was intentional, that switch.
Oh yeah. It wasn't because Brian still pointed at her, because Brian still knows he'll cross the line if he do that. You understand what I'm saying? Everything that he ever worked for will be out the door. So he's not gonna do that, duh. You know what I'm saying? That little statement about she made. I wish he put his hands on me. He better not hit me. Man, that man is not gonna hit you. You just see that's the kind of stuff.
Wait
you know what I'm
saying?
saying?
What statement? She released a statement?
No, she said it. She looked at Miss Hilton and the babysitter and said that he better not put his hand on me. You didn't see that?
No, I didn't see that.
Oh man, talk that law. You missed that. Yeah, that was right in the course of when he said, and this lawyer. Yeah, she turned. Yeah.
So she modeled it to Hilton.
Yeah, and the babysitter. Have you ever been in a courtroom with that babysitter?
Wait, say that again?
Have you ever been in a courtroom with that babysitter?
Have I ever been in a courtroom
with the babysitter? Have you ever had one of those, any of those lawyers from the DA side ever been up against you?
Oh yeah, more definitely. But normally it may be a team of two at the most. You rarely get a team of three unless it's like a super big case, 3 or more.
Do you mind if I ask which ones it was?
Well, you see, I don't practice in Georgia. I practice in Texas.
Oh, okay. Oh, you up there with them, where my boy was from, Mo 3 sector.
Oh yeah. Scared to
That's
go
why I love that man
outside.
I love him like he was my own son.
That's why you was asking me questions about Atlanta yesterday, because okay, now it makes sense.
Yeah.
Okay, I got you. Okay,
Yeah,
okay.
man. I'm old school, man. I just be, you know what I'm saying? I never seen nothing like this. I'm in Florida. You know what I'm saying? And I'm, you know, like I said, I don't like to talk about, I'm not happy about where I've been and what I've done. I'm just knowing that by me being in the system for nearly most of my life, I have never seen nothing like that before.
Right.
You know what I'm saying? Come on, man. I never seen it. You know, I seen people with murder cases get 3 years. I seen them get 15 years and get bonds. You know what I'm saying? And you know, and then the treatment in that jail, man, that ain't the only jail. It's a lot of jails like that. It's a lot of jails.
It's a lot of
that
jails.
Ain't the only jail. That ain't the only jail. That's the only one they speaking on right now. It's a lot of jails. If you come to Dade County Jail and take a walk through there, you know what I'm saying? The only thing that's keeping that place up together is because all of the money from the drugs that they get, they keep it going. They can build on it. You know what I'm saying? You talking about a lot of steel. You know, concrete and steel. See, you ain't talking about something they just throw it up prefab. You know what I'm saying? You know, but it is what it is. You know, but hey, man, wonderful job today, man. You know, I wish I could have got back in early, but tell the haters, don't be hating on gangster Kayla, because Kayla earned her award yesterday. You understand what I'm saying? She stood on business.
Somebody just popped in the chat that I guess you said come up here.
Somebody
Miss. I think her name was Miss something Mail. Pinkerton something Mail.
Hold on, wait a minute, because I came up here just for you, Mr. 305. You're not going to sit here and talk about us as a whole in the chat, talking about that we cannot compare to Kayla. First off,
no, I didn't say that.
Hold on, wait a minute.
Go ahead, sir.
You said if we could get up here and we can challenge what you said, challenge it. We don't have to go in a courtroom and try and get a Rule 22 to stream this case. At any point, it looks like she's thirsty to go in that courtroom to try and stream this trial. She said she did not care about this trial. I'm not saying nothing's wrong with Kayla because I actually like her as a person. But overall speaking, it looks like she's thirsty to insert herself into this situation. Not saying that she's not a part of it. The part that she is a part of, okay, stay in that situation and be done with it. She got up there very unprofessional today with her attitude, trying to direct energy at love, not necessarily showing anything that was professional in any sense. And I don't know how you even think that that's cute as a Black woman that's supposed to be representing a brand. I don't care if love triggered her by her words or whatever she said. It's still a way that you conduct yourself. The eye rolling, the looking directly at her, that was very unprofessional. And you, as saying that that's okay, you're only saying that that's okay because that's the women that you're used to. Professional women, we don't do that. We don't conduct ourselves that way. We don't act that way. If Miss Love would have said that about me, what I would have done with Miss Love was complete a bar complaint against her. I wouldn't have got up there with an attitude trying to be snarky and use comments that she made in the transcript that was offensive to you. That's not professional and that's not cute. So I don't know what you're referring to. We can't compare to her. I know.
No. Let me comment on. I agree with you, ma'am. I agree with 100% what you just said. But that was not my point. You know what I'm saying? And me as a man, I comment on her, but I don't look at her like that. You understand what I'm saying? When I look at her, the people that she's dealing with, because all of them old enough to be my kids. You understand what I'm saying? So I mean, I get what you're saying, and I back you on that. I stand behind you on that. But what I was speaking on, they was some of that stuff like the dress code and all that stuff. When I'm looking at that person, I'm not looking at that person because of how she dressed. You understand what I'm saying? Now, if Kayla wrong, I'll be the first one to fire up, because that's my opinion. Like, you entitled to your opinion. And I just told you, as a man, you right. But you right for your opinion for what you thought I was talking about. But that wasn't the case. But maybe I misworded it, ma'am, and I'm sorry that I hope I didn't offend you. Sound like I didn't.
You can't offend me. I'm listening at no
And
point.
I appreciate I didn't. But you know what I'm saying? In all due respect to talk that law, and you coming up, you know what I'm saying? Hey man, I salute you for even coming up and speak your piece. And like I say, I'm a man, I stand behind you. But like I say, I appreciate women, black women, just like Kayla. You understand what I'm saying? Because just like, I don't know what Kayla went through with them people. We behind the scenes. We might find out next week what really happened. You know what I'm saying? So, maybe I need to slow it down on how I speak a little bit. So, and that I do.
I wouldn't say that, but if I may, say this, and this is what I would tell you. First off, I want you to look at the type of person that you're speaking on. I get that you're saying that she's a black woman. She's very professional in some of the things that she does. I can say that about some parts of her, but her interception into this case has been what I would say the most unprofessional I've ever seen anybody in this type of field act. Not saying that I'm a part of the criminal justice system. No, I dibble and dabble, but I'm not a lawyer. Don't give legal advice. But directly, the way she had acted today, if you see anything that was correct or like I would say becoming of someone in that field, like I've never seen, especially not necessarily saying that she's in the media. I would expect a content creator to get up there and act like that, not a lawyer who has a bar card who's saying that they're professional, and that's not how they conduct themselves. That's not how they act. And to get on national TV and conduct yourself today the way that you did with the eye rolling, the body language, the bumping, like, not gonna lie, Bumpus looks nice. Give her props. She does. But come on now, let's be for real.
Well, I didn't see her roll her eyes. She rolled her eyes.
Hey, Simply, you know what I learned? You know what I learned? Miss, what you say your name is Simply Talk? Miss Simply Talk, let me say something though. I learned from being in the street most of my life, most of my life. And one thing I learned is not to, point the finger, because when you point the finger, you got 4 on point back. You not directing this to you, but I try not to do that. Like I say, I don't look at her like that. You know how many times I've been judged? I mean, in my life, 60 years old. Man, look here. I could tell you some story, but we're not going to go there.
I will say that. Let me say this real quick. Do you have something going on in the background? It sounds like it's an echo. You have like a TV or something?
Me?
Yeah, it sounded like it was coming from your side.
Hold on, let me see. Give me 1 second.
That ain't me.
Yeah, it's not you.
Yeah, I'm in the woods. I'm out in the woods talking to you.
No, it's definitely not you, because I muted your mic and it was still going.
Yeah.
Wait 1 second.
Okay.
Maybe so, because as a professional, I am in. Can you hear me now with no echo?
Oh, yeah, good.
Okay, sorry. I had a meeting running on my back screen.
Yeah, so that's one thing I learned, Miss Simply, that I don't point the finger. You know what I'm saying? Because I'm like this here. With all I've been through, ma'am, I don't try to judge nobody, but I speak on something. Sometimes I be wrong. Just like the way I came out today. Maybe I shouldn't. I'm sitting there contemplating on what you said and thinking like, dang, I could have said it a different way. You know what I'm saying? So, I need to check that. That's one of my thoughts of the day that I need to take care of. But I'm gonna say this here. I always believe in trusting in not just, I don't really trust in love. I trust in that God up above, because had it not been for him, I wouldn't even be here today. You feel what I'm just being straight up with you. With all that mess that I've been through, I can't judge nobody. I don't have a place to judge nobody. So when I see it, I just say, thank you, God. Thank you, Lord, because it's something for me to see, something for me to learn from. You know what I'm saying? So that's how, people care about dogs these days and cats and snakes and animals. You know what I'm saying? But what about the person that we see every day?
We see
every day.
Okay, were you trying to say something, Talk That Law?
No, I was just saying, I understand what you're saying, but I don't think it was as deep as he's going into it. I don't think you were coming at him like that.
No, I wasn't. Like, this is just a dialogue. And
right.
No. I was just making sure she understand me. So if she ever see me up here talking, it wouldn't be that she wouldn't perceive me as being one of them guys, one of them dudes. You understand what I'm saying? That's all. You know what I'm saying?
So listen, I don't perceive anybody for being that way. And one thing that I do want to say in regards to like looking at the chat, I typically try not to pay the chat any attention. But what I will say is this. And I'm not going to direct this to anybody. So if you guys feel any type of way about it, I apologize in advance, but I'm going to say my piece regarding this. Talk That Law's channel, we are coming up here. We're having an open dialogue. I'm not disrespecting Mr. 305. I'm not disrespecting Talk That Law. So if you guys feel some type of way about the content that he is having regarding the YSL trial, we respect you guys enough to say, okay, you know, we understand what y'all saying, but if y'all don't like this part of the segment, y'all can come back at a later time. Like you said, you don't have to announce it or try and be rude or try and be disrespectful to the host by saying this is not the original content that he has. I feel like at that point that becomes disrespectful, and I feel like sometimes y'all are looking for attention at some point, and he's not going to direct that type of energy to you guys, so I will. And I'm just saying, as a respect factor to him, everybody's opinion is valid and open. 305 is not being disrespectful to me. I'm not being disrespectful to him. I'm just telling and stating an opinion that I feel. So, I mean, respect it or check it. Either way it goes, Talk That Law has a great channel. He's opening up dialogue for everybody to come in, be professional, state their opinions, and go on about their day.
Yeah,
That's all.
I agree that everybody should have a voice, and we're not going to all agree. And, you know, I think everybody should, as long as we're respectful, I have no problem with anybody coming up and giving their opinion. And it may be contrary to my opinion or opinion of Tasha or the opinion of 305. But hey, it's not no serious beef. I mean, we're just chilling.
It ain't no beef at all. But with me, I appreciate you, Miss Todd. I sure appreciate y'all. Hey, as much as you know what I'm saying, that back in the day, I probably would have had a shootout with you on this thing. But right now, I got understanding. I got peace.
Mr. 305, I'm a Duval County girl, and I'm always ready.
Okay.
So I stand on business. I'm just joking. Joking. But listen,
you ever been to the landing? Huh? You ever been to the landing?
The landing? The landing is no longer.
No. I know it ain't there. Have you ever been there?
Disagree.
Yes.
Huh?
Yeah.
Yes.
I worked for Hooters for 32 years.
Oh, okay.
Yeah, right there in Jackson from day one when it first opened, ma'am.
Mm-hmm.
Yeah, day one. I worked at Southside Hooters, San Jose Hooters.
I see why your opinion is the way it is.
Yeah, I'm from here. I'm born and raised in Dade County.
All right. Okay.
I'm right here where you at. I'm just not in the city. I live way out in Union County near Bradford County.
You say you in the woods right now?
Yeah, I just told you. Heard me say that.
Okay. I was trying to figure out, like, so, like, it's like woods, like the real woods, or like woods kind of like in the country type of living?
The country type of living.
Oh, okay, I got you. I'm like, I thought you like hiking or something. Like, okay.
Yeah, the country type of living.
Yeah, I got you. Yeah, I know exactly what you mean. That's some good living right there. Oh, okay.
All right, now.
Come on here, grass cut.
Want to come down to 305?
Right.
Look, nice Taylor lawn.
Yeah, nice lawn.
We ain't doing no locations. We ain't doing no locations.
I can't do that right now. My yard man ain't came yet, so
no.
She said,
we ain't doing no locations.
Where he at?
Where he at?
He went.
Talk that like he with Rico, wherever Rico is right now.
That's where he at. Grass growing like crazy. I don't know what's going on.
Hey man, hey, but I'm gonna let y'all go, man. Hey, Miss, hey, it was a pleasure and an honor, Miss Simply, to hear you come up and get your point across. And like I say, I respect that.
Yesterday, and I want to know the answer to it, and you did not come back up. So can you please?
Oh no, I probably had to. I'm running late right now. I got to take my boys to practice.
Okay, one question before you go. Capital offenses. You said you were charged with a capital offense. What was one of the capital offenses you was charged with? Not trying to get
right there on Gulfville Boulevard.
Oh.
The old hotel across the street from the Waffle House on I-95. Before they tore it down, I was the last case there. Okay. January 7th, 1991. They walked me across from the Memorial Building. Look it up.
All right, I got you. Thank you so much.
To the old jail. Not the new jail. I opened up the new jail March the 7th of 1991. No, 1990. Excuse me. Yeah, March the 7th, 1991. Excuse me. Yeah, they opened up.
Oh, yeah.
Yeah. They gave us hamburgers, McDonald's, and everything for 3 days. So I know about Hilltop, I know about Gulfbrook, I know about 45th, I know about Sherwood, I know about the East Side, I know about Jacks Beach, Mandarin. I've been there. I'm I'm just old, man. I had to get out the way, and thank God I did.
All right. Well, thank you.
All right, now you take care of yourself.
All right, have a good one, 3 or 5. Until next time.
Talk that long. Talk that long. Don't you ever put on that blue jacket like the lead attorney now.
Oh my
Man,
God, y'all, bro,
we're gonna fall out now. Cause he ain't changed yet. I was waiting on him yesterday.
That's a nice jacket though. He has.
Don't
Man,
do
look
something
here.
like that. He got goons that'll come for you.
I'm
That's a nice.
talking about the lead. I'm talking about the lead attorney, man. He got that jacket on every time.
He said he changed him out.
He changed him out. Yeah, I think he changed him out.
He had multiple. He said he had
Really,
signature.
really, Miss Simply, really.
I don't know. I'm telling you. Somebody asked that question because I thought it was a good question. But he said
he be sitting up there smiling like looking at the dentist. You know what I'm saying? With that blue jacket on, like he just smiling like he ear to ear, like he looking at the dentist.
Well,
he making plenty of money, so I know he got.
I know. I want you to get up. Hey, I want for you the same thing he getting, Mr. Talk that long.
Oh yeah, hey, right. We growing one subscriber at a time, unless we lose a few today.
Yes, sir.
Hey, I received that though. Thank you.
I help you game mode. Talk that long. We're not concerned with negative energy. We don't address peasants at all.
Okay, let me get my boy to practice because he supposed to get selected today. Y'all take care now.
All right, good luck with that. Thank you.
All right.
Yeah, and I like to let everybody have a voice. And I know some people ain't gonna always agree, but we just chilling. We already talked about the law earlier today. Now we're just having a little dialogue.
It be a few weird ones that hop from chat to chat that come and start disturbance, but you don't have to. I just seen a lot of it, and I didn't want it to spill into you. So people's personal opinions of me and my views, or anybody else and their views, I just feel like at any point, if you want to address me, I'll give you my information so you can address me directly. You don't have to address me in the chat or have anybody. They don't even have to defend me. It is what it is. We having a positive dialogue with Talk That Law about what we've seen in court today. So let's change the subject. Talk That Law. What you think about today?
Well, it's hard. I mean, the only reason we're talking about it because it happened while in the courtroom, and that's what we were covering. But yeah, I think everybody good. Coco. I actually was looking for you earlier, Coco. We were trying to see if we can get a hold of somebody. Talk the law. I seen the live from yesterday. Was still from yesterday. Congratulations on the numbers. Oh, okay, yeah, thank you. We had a whole lot of people sign up, subscribe, and all that good stuff yesterday. But now they're gonna take off.
They gonna take off? You think so?
They're gonna.
I think it's only one.
I can't really keep up with stuff like stuff like that. I think
it's only one weird one. Only one weird one.
We have a lot of different. I mean, I have a lot of people that come in the chat and talk to us all day long about the trial. But I'm not gonna block nobody unless it's like completely disrespectful or so like a racist comment, something like that. Then yeah, of course, I put them in like time off for a while. They coming for me. It's my opinion. It's weird. But I think that from this morning, I guess we can move to this morning. What you think about the secret transcript that was revealed? Like, what, a second transcript?
I was kind of like excited to read it. I think I was more excited than I was shocked that something extra had happened. The part that I did not like was Shard's kind of exaggeration.
Of what? What he exaggerated on?
I think his feelings. I'm not saying that he exaggerated on like the transcripts and the things that was said. I think that he just exaggerated when he stood up to like express his feelings. He was very like,
he was kind of doing the most.
Like to cry, like it hurt him. And I know that it probably was like hurtful to read some of the things, but I don't think it was. He was up all night scratching the skin off his head.
This worked. this worked for me. So if I was in that courthouse, I wouldn't give it a second thought. You know, we can get into it. I'll talk about the judge like a dog, and then come to court the next day like nothing happened. It's a new day. We getting ready to get started and go to war the second day. But I'm not going to take it home and you know, worry myself and stress because Glanville no good. I ain't gonna say it because of Glanville. We all know Glanville ain't no good. So I don't put nothing past him. So when you start off with that, you won't expect anything different. Start off expecting him to be no good, and then he won't be able to let you down. So,
but do you think that because Glanville didn't really say much in that transcript? It was more love and her embellishing the truth. He just kind of like co-signed what she was saying.
Yeah, he kept on going along with her. Now I get it. I don't think it was when I first said Weinstein. I'm like, oh, this is gonna be good. But when I actually read it, I didn't really just get the explosiveness of what we got from transcript number 1, secret transcript number 1. It was still kind of good because the judge was mentioning outside agitators, and the defense attorneys think that he was talking about them.
Mm-hmm.
He's calling them agitators because they're not going along with the status quo. They're not going along with the corruption that is always expected in Fulton County. So, I mean, Judge Glanville, the only thing that gets me with him, he's a pushover. He let love push him all around that courtroom, and he don't push back. I mean, at one point, he did tell her, what do you want me to do? What can I do about Melnick's being Woody's attorney? I can't kick Melnick from being Woody's attorney. I can't stop him from being Woody's attorney. He's like, what do you want me to do? And Love said, I'm gonna go home. That's my homework. That's what she said.
Yeah.
She said, I'm gonna go do my homework, and we're gonna find a way to get rid of that boy. We're gonna find a way to make sure Woody don't have a lawyer because he don't have a lawyer we want him to have.
So that was one of the questions that I wanted to ask you when I came up here, right? So in the situation where technically Brian still stood up after everything was completed, and he was like that he wanted Melnick to come up and proffer some of the things that he was stating in regards to responses to Love's I guess misrepresentations. What was he stating? Like, what was he meaning by that? Because I didn't understand his purpose of having him come up.
You talking about Melnick?
Yeah. So when he said that he stood up, when they figured out they didn't have much to do, he was like, I would like, you know, the Honorable Jonathan Melnick to come up and proffer. And then he said like a lot of stuff, and she kept asking him questions like, I don't know what the relevancy would be of him coming to say it. And then she ended off with saying that he could proffer what Melnick's responses would be.
Well, yeah, because what we know so far is the transcript that we have today is a rough draft. And what he's trying to do is bring Melnick in to verify whether the transcript is accurate or not. He said Melnick can say that happened, that didn't happen, or I said this, or I didn't say that. Because they made a lot of assertions that Melnick was trying to prevent Woody from speaking to the prosecutors alone, which he should have. He's his lawyer. But Melnick could come in and say, I was not blocking the door. My client was free to speak to anybody he wanted to speak to. It was just the state embellished the truth, or they flat out lied. So I think Jonathan Melnick could have been a good distraction, a good content for YouTube. Is he necessary? No. But since he's there, why not? As we see, there was nothing else to do today. We got out of court early. We had more time. So, of course, we could have took 5, 10, 15 minutes to play with Melnick to get his take on whether Love was telling the truth or not in her second secret transcript meeting. Oh, now wait on the third transcript. Anybody got the third transcript?
So you basically would have wanted to hear if Love was making some type of errors or not.
Right, because it goes directly to whether she should stay on the case or not.
But didn't she say she was gonna rule on those today? Like, what happened with that?
I'm trying to see, did she rule on?
No, she did not rule on the mistrial. She didn't rule on neither one of the mistrial. She denied Brian Steele's on, but she didn't do Harvey's, or she hasn't done Yak.
Yeah. Yeah, I think she just came in and really worked on the evidence itself. And because I think what happened was the lawyers came back with the outrage, and it kind of like went from there about the secret transcript number 2, and they just kind of started talking about that. And then once that happened, then they started moving to evidence, going over what evidence should come in, what evidence should go out. And then when that happened, they needed more time, so the judge said, "Okay, I'm gonna go in the back for an hour and a half, and I'm gonna read some cases, and y'all can do what y'all need to do." And
So she hasn't made the ruling as of yet for.
yeah, I don't remember seeing a ruling, so I don't think so. Yeah, so I think those are still outstanding. But I mean, if she's doing all of this, it's hard for me to believe that she will be doing all this work, reading all these cases, deciding what should go in, what should stay out, if she had intentions on throwing this trial out, because it'll be work for nothing. So it's in my mind, she's planning on going forward with this trial. So we can assume that those mistrial motions are denied.
So you think that she's gonna deny it?
Oh yeah. Oh yeah.
But why though? Like in the stance of some of the things that's happening, do you think that she may revisit it if something else happens? In the sense,
I think she's trying to push forward. I don't think so.
I feel like she's trying to make a name for herself, and I don't like it.
Yeah, that's probably what she's trying to do. But I mean, we know her name now. We know Whitaker because we've been talking about it. But eventually, we're gonna forget. I mean, you can think of a lot of famous trials, starting with the O.J. Simpson trial. We don't know who the judge's name was.
I can't tell you. I know the attorney's name.
Yeah, who was the judge for? What's another famous trial? I think Johnny Depp, Amber Heard, they were on TV for a long time.
I think Aaron Hernandez case. I don't remember the judge for that one.
Yeah, the judge for that one. Who else?
But I mean,
even this recent one, Alec Baldwin. We don't even know. I don't even know that judge's name.
I don't know the Karen Reed judge name.
Oh, Karen Wright.
I can't tell your name at all.
Somebody said, okay, they said they coming through with some names.
Listen, right?
For which trial? Which trial is this judge?
One thing that I do want to say right now, because he's in here, talk that law slick. Tell him to bring those super chats on up, have them start to rolling in.
Where he at?
He here. He commented. So I want to make sure that he fully supports you in everything that you do.
Oh yes. Slick always supporting. Actually, when he first joined the chat way back when, I don't think we agreed on anything, pretty much. But I wasn't going to. I was like, okay, it's good to have different opinions.
I know I like people that give me different opinions. I don't like people that think the same thing I do. It kind of like a me too. Like that's why people don't understand why I like LaVonda. LaVonda is who she is. She a little strong in what she say, but I mean everybody entitled to
right. She different, right? You just gotta know everybody is different. They got their own personalities, and what may come off offensive to some people, they may not realize that's just how that person is. They don't even mean no offense. They may not even realize that it's coming off as offensive. They just on here just talking like they would talk to their family after barbecue.
Right.
So that's why
she gives.
Right. That's talking to family. Like how you call yourself that's what we do with family and stuff. So I'm not offended. And that's why I don't really just do the whole Moss thing, because Moss may not be as lenient as me, and they may block 1,000 of y'all because they don't agree. So, but I'm real laid back. I don't let too much bother me. Let me see. We were here when you got 500 subs. He said we were here. Thank you, Politicking with Mel. Yeah, I remember. Yeah. Less than that, way less than 500. and then it just one at a time. And now it may be 30, 40, 50 a day. You just never know. So I do appreciate every one of y'all. I'm not gonna silence your voice.
All right, so now I got a question for you.
Yeah, go ahead.
With the Rule 22 that Kayla was looking for, right? I ain't gonna lie, Kayla looked nice when she came out today. I wasn't expecting that, but
yeah, and I think she had said, because I caught a little bit of her live before the lunch break was over, just a little bit, and she had said why she wasn't able to put on her work attire, but because she didn't know she was going to be called up. I don't know what the case is. I got to go back and listen to it, but yeah, I don't think she was trying to do it to disrespect the court. I don't think that at all.
Now, I don't think that she did it intentionally. She said she overslept and she didn't know that she was going to be called for the hearing.
Oh, okay. I got you.
Did you catch T yesterday when she said that the deputy was the one who spilled the beans, was the Mo?
Yeah, I heard that at the end, before we got off live, people were coming here saying it, and I was able to catch a few minutes of the clip. Wait, which part you said, Simone? Wait, who you just say?
Who? Me?
Yeah, repeat what you said.
I said when Kayla was on live last night with the lady, and she said that the deputy was the Mo.
Oh yeah, Deputy Brown.
Uh-huh.
At first, I was thinking they were talking about the other Brown, the lawyer.
Yeah, Brown. I thought that's who she was talking about.
I was like, I know not.
If she said that, I was gonna be done with this case for a lifetime because I just knew he was gonna be fired.
Yeah, for sure. I was like, wait, what's going on? But once she exposed him, and we gotta remember that particular deputy, from my understanding, is the deputy of the current judge, Judge Whitaker.
Correct.
And so, I mean, think about it. We already know, okay, Kayla's filed a Rule 22. Don't think for a second. I wouldn't put it past Deputy Brown. I mean, if he's leaking meetings, I don't put nothing past him. He probably went to that judge, his friend, who he's in charge of protecting. He probably told her, hey, this girl coming in, she had me all on her YouTube last night. He said, don't give her no Rule 22. I can see that, happening. Now, do we know that as fact? No. But the judge even mentioned, she had said, Kayla, how did you stream it last night?
I know, and that's what I was trying to figure out. Like, who would have told her unless the state told her? Like, who would have told her?
The state told her, maybe even the deputy told her, like, hey, she had my name on her channel last night, saying I was this mode. So I'm thinking that probably went into the judge's decision to not sign the Rule 22. But at the same time, the judge said, just do it. Huh?
If he was the mole, would it be an issue? Like,
I don't think so. But I mean, at the same time, it's like she said that she's not going to sign a separate Rule 22 specifically for Kayla. She said, just go get in the jury pool with Miss Sylvia. So, I mean, so she still get what she wants. And then she even left the door open because Kayla was smart enough to ask her. She said, hey, if it doesn't work out, or if something else comes up, will you revisit the matter? Basically, will the judge reconsider? And the judge said yes. Shout out to Don Cato. I haven't seen you in a while. Thank you for stopping in. I know you got a lot going on out there in California. So thank you for popping in the chat. Hope all is well, Mr. Don. But yeah. If he is the mole, I mean, that's bad. I mean, because you work in the courthouse, there's a lot of sensitive stuff going on in there. And the last thing the court needs to worry about is a deputy going back and telling secrets.
But that's what I'm saying. Do you think that with Glanville learning that, would he be in any potential risk because of that reason?
I mean, it just depends. I'm sure. Now, if Judge Glanville get on the phone and call the local sheriff, of that county, who's the direct boss, or maybe not direct, but the head boss of that bailiff, then I'm sure that can be some problems. Glanville get on the phone and say, hey, you got an employee down here at the courthouse that's working security, and he's going around doing this, doing that. I mean, I'm sure the sheriff won't be happy. That's almost like having a cop working for you, and they have access to secret information. They can call ahead and tell somebody, hey, just to let you know, the police are going to be doing a drug bust at your house tomorrow at 2 a.m. I mean, it's not a good look.
I mean, I don't think it is either, but it's just like at some point, somebody got to be held accountable for the stuff that they're doing. And like he was trying to hammer her, and still he need to hammer him. Like,
but they probably all in it together though. If they all corrupt, when people say, I'm gonna go get your manager. The manager hired them. The manager know they all in it together.
I be telling people, go ahead. Go ahead.
Go get them. Go get them. Imagine getting upset with a judge, even though it's not the same, because Glanville is not really their boss. But imagine you don't like the judge. I'm gonna go tell the chief judge on you, and you go talk to Glanville, not knowing what we know now. And come to find out, he the worst of them all.
Right.
He's the worst of them all.
It's weird to me that she trying to defend him without trying. That's the only thing that's weird about this judge. I feel like that she is trying to defend him without trying to publicly defend him.
Yeah,
like,
she went out. Yeah, I agree. She went out of her way and said the chief judge is a good woman going on.
Yeah,
the chief judge ain't worth a damn. Stop it.
He ain't, and it's the point. Like, it's like, when are we gonna stop trying to sugarcoat what happened? This is bad. It's not good. It's nothing that can change what happened. But it's like it should have never happened in the first place, and they trying to defend it.
Well, this would be a good perhaps defense for the deputy from Champagne Dreams. She said, could it be that Steele asked the deputy where everyone was at, and the deputy said they're in a meeting? That's why Steele asked Kayla about it.
Could be. Now that's a good.
Yeah, that would be a good thing. The cop innocently said, "Oh yeah, they're in a meeting, but they should be coming out soon." And then Steele could have went to Kayla and said, "Hey, what meeting?"
Mm-hmm.
And that's when it really exploded.
Because I would have asked, "What meeting was you in?"
Yeah, what meeting are you in? What meeting are you having? While we sitting out here for 2.5 hours waiting for court to start, and they back there having a meeting. What meeting? And I think that could be possible. So maybe the cop, he could be innocent in a sense that he didn't really expose any type of
well, that's what Kayla said.
Details.
Remember, didn't give any legal logic to what happened in the meeting. She exposed that, but he did alert them that it was a meeting.
So maybe he's like an innocent party. He told the truth. They were in the meeting. That's what held up the court. So he wasn't trying to divulge, even though they did say he was the one that ordered everyone to turn off their body cameras. So I mean, now I don't know if that's standard procedure or not, but as far as maybe it was an innocent deal. He's not a mole. That's why he's still there, and that's why he can go to Judge Whitaker and say, "Hey, Judge Whitaker, she tried to make it seem like I did something I didn't do. Please don't give her a Rule 22. She's going to be here every day. She's going to harass me. And if she's harassing me, I won't be able to do my job as security for, your courthouse."
But you think he'll be that devious? I don't know. Yeah, people.
Well, you watched her live, didn't you?
Yeah, I did. When she said yeah. The stuff about her with her phone and stuff like that. And I feel like I know that they're giving her a hard time because of it. But it's like, that's why I'm trying to figure out, like, why would she? And it's not nothing disrespectful to her, but I'm like, it's like, why would you want to be in there with that? Because you're putting yourself at jeopardy, because they could say you did anything, like make reference to you doing anything, and that's bad. Like, so it's like, why would you want to subject yourself to be around it? And I mean, the way she was defending Love and Hilton before she realized what they said about her, she didn't say anything bad about them, and I'll say that. but it's like they were dogging her out. And not so much Hilton, Love. And it's like, you know, she was being respectful to them, but I was, you know.
Yeah. I mean, I don't think that if Kayla has the time and she can shed more public insight, then, you know, why not? If she's not connected to the case, I don't believe she's no longer Woody's attorney.
No, she's not. She
so-
wasn't. Anyway, she was his stand-in,
So if she want to sit in there all day, if she have a time to sit in there, I mean, I don't really see nothing wrong with it personally, but I know a lot of people are saying, you know, if all of that is going on towards her, if they being mean to her, or they won't let her have a phone, they yelling at her to cause attention, they kicking her out, they lying on her, saying that she's showing her phone to other people, and that's not true, then, you know, some people would wonder, you know, do you want to just remove yourself from that situation? Or in Kayla's, you know, argument may be, I'm not going to let them win. I'm a respected lawyer. I practiced in this courtroom. I was a prosecutor for, you know, 7 years or however long many years. I deserve to be here. So,
and that's why I understand like her perspective in that sense. But it's like, I don't know, at some point, I know that and that's why I brought attention to today, because typically she holds herself with a level of like respect where she doesn't like, she won't bash them or she won't get smart or snippy with them. I feel like she let like social media egg her on to the fact of getting angry enough to conduct herself the way she conducted herself in court today. Like, even when she had the attitude towards the judge and the things that were happening, she still didn't behave.
I'm gonna have to go. I gotta go back and watch that because I didn't really sense. I'm gonna go back and see because I didn't really sense her being upset with or having an attitude with the judge.
Not the judge. It was towards Love, but it was just like the judge is sitting on the bench, like she can see your attitude, she can see your behavior, and then when she flipped her neck and looked over at Love, like, I dare you to say something. That was all black girl energy.
Let me go back and see because I don't even know if her and Love made eye contact, but let's see.
Love turned her head, but she definitely looked over there at her.
All right, let's see. I'm
all right, pull it up. I'm gonna do it, Miss Lamonda. Pull it up.
All right, and I'm gonna mute the mics for the echo for the video. Okay, let me see. Maybe that button there. All right, there we go. Wait. Can y'all hear it, or is it? Oh, you can't hear it. Okay. Hold on. Okay.
It's muted.
So y'all gonna wait till the whole thing go and then say something?
No, I mean we thought you was not listening to it with the sound.
Oh no, it still has sound for me. My bad, y'all. Let's go. Thank y'all. So we're trying to see if Kayla. I don't think she had an attitude, but you know, I think she just.
Where's Ms. Bumpus? That's who filed the Rule 22. Good afternoon. All right, so you filed.
You know what, Nurse Shells?
A Rule 22 at what 11:10 or so. That's fine. The night before last. So, and you had said that you wanted to start recording for yesterday. And honestly, I didn't even know you had filed it until we were finished with the court yesterday afternoon at 4 something, because it came in so late. And normally the Rule 22s go to our public information office, but I know about it now. And so I have provided notice to all of the parties, and I will listen now to or ask if there is objection from any of the parties or witnesses or victims to the Rule 22 filed by Ms. Bumpus.
Ms. Hilton looked away.
All right. So I am not real. So what are you looking to do?
Your Honor, I just want to be able to record what's going on in the courtroom.
All right. And you had already, I guess, yesterday live streamed from somebody else's
Yes.
live stream. What is that person's name?
Miss Sylvia.
Miss Sylvia?
Yeah, she's sitting in the courtroom.
Okay. All right. So there are an inordinate number of separate Rule 22s in this case anyway. I'm not really sure why everybody is not using the pooled media that is already, I mean, it's like 8 or 10 media organizations are using one pool, and then there's Miss Sylvia who has a separate one, and then lots of people who have the ability to take still photography and audio, and it's just a lot. It's like 8 or 9 different things. But I am not sure that yet another person doing essentially the same thing adds to the public's access to this proceeding. There is 24/7 coverage of this, a pooled camera, and Miss Sylvia's separate video recording that you can access anyway, apparently. So, I mean, if you want to be heard as to how that either increases the public's access or helps with the dignity of the court or the administration of justice or the truth-finding function of this proceeding, I'm willing to listen to what you have to say.
Your Honor, I'll be brief. I just would like to say that at any point, these other people who are part of this pool, they have logos and they can pull what I am streaming on my personal YouTube and do copyright issues. They have their own logo on there. And also, I don't always want everything that they are streaming. I don't need the full court hearing all the time. There are specific parts that I need to reference and informing the public of what's going on. And that's my point of being here. And I'm just trying to do everything right so that I can, pass the smell test.
Okay, so with regard to, I mean, obviously you can let the public know anything you want to, and you can.
Hold up.
So go back. The face.
Yeah.
Look at the face again.
All right, I'm going back. And actually, yeah, the smell test is what Love said about her earlier today. Let's go.
At any point, these other people who are part of this pool, they have logos and they can pull what I am streaming on my personal YouTube and do copyright issues. They have their own logo on there. And also, I don't always want everything that they are streaming. I don't need the full court hearing all the time. There are specific parts that I need to reference and informing the public of what's going on. And that's my point of being here. And I'm just trying to do everything right so that I can, pass the smell test.
Okay, so with regard to, I mean, obviously you can let the public know anything.
I did see a little attitude in there.
It was a lot of attitude. That was a lot.
I mean, obviously
you body language?
Yeah.
can let the public know anything you want to, and you can video blog, vlog,
Come on.
all you want to, any kind of opinion that you want to about the case. And you can obviously also sit here and watch all of the proceedings. Are you saying that you can't use somebody else's, like the news media coverage?
It has their logo on it. At any time, they can say it's copywritten and take it from me. Or
Okay.
From my page.
Have you asked anybody other than, is Miss Sylvia okay with you using her? Because honestly, it's a little bit disruptive to have essentially phones in court. I mean, it ought to be that unless you are somebody who has a Rule 22 already in effect, or you are an attorney in the case, you shouldn't have your phone out or on or anything. And
yeah, she's speaking to Brown. She's talking about the situation where she was put out the courtroom yesterday by Deputy Brown. So the judge, I think
correct, right?
The judge talked to Brown. Because how she know about this?
Phone out or on or anything. And it's kind of chaotic in this entire part of the courtroom. And I find it to be distracting. I find there to be security concerns with having to constantly figure out, okay, who is authorized to have their phone out, who is not. And so what I would like is, until there's some point when you find out that you're not able to use somebody else's, what they've already taped. I mean, I'm kind of saying, why don't you and Miss Sylvia be the second pool? Okay. Would that work?
We'll try it out.
Okay. So let's do that. Y'all are now the second pool.
You will revisit it if I have an issue.
Sure.
Thank you, Judge.
All right. Thanks.
So you see that attitude.
And then somebody had said, why did Kayla use the term, the smell test? And we went over the secret transcript that was released today. And guess who used that word? Who's talking? Miss Love is talking. And Miss Love went down here. And she said, so Miss Bumpus is going to be here. Miss Bumpus hugging Mr. Kendrick and Mr. Williams is going to be here representing the interests of Woody, who is supposed to testify against Mr. Kendrick and Mr. Williams. That is where we are. That doesn't pass a smell test. And I think Kayla sent shots back at her today by saying, I just want to make sure, Judge, that I passed the smell test. And looked directly over to Lawyer Love. So you was right on that one. It's a little toot in there. But my thing is it justified?
Listen, I ain't gonna lie to you. We all know black girl too. And I caught that immediately. Like I'm on a meeting, I'm screaming. I'm like, oh my God, she is not doing this. Cause I'm thinking the lady gonna say something, but she didn't catch it. But I did tell Slick he needs to send you some money. So
thank you so much for telling Slick to send me some good money, some hamburger money. I don't know what kind of hamburger you can buy nowadays. They used to be 99 cents.
You can't. You gotta put with it, but you can buy some.
Yeah, I can buy some, right? Thank you so much, Slick, for your kind contribution. Not only today, but yesterday when you sent 3 back to back.
Yeah.
He said, talk that law. My baby mama on me about sending money. Told her I don't care. Well, let me tell you this. I don't want to take the hamburger away from
He took it away from my son.
I don't want to take it from the baby now.
It's okay.
You say that again?
He took the money away from my son, but it's okay.
Wait, from your son?
Yeah. That's I am the baby mama for the child support.
I know you playing. You playing. I'm not going to take you serious. No, you're not.
I'm serious.
Nah.
I know shade at him.
I know some people in the chat be, Ken. I think yesterday somebody's brother and sister, we found out. I think it was no brother and sister in the chat. Nurse Shell, she don't have a brother on here.
No. I'm telling you, Slick is my son's father.
Oh wow, it's a small world. Well, thank both of y'all.
Don't tell me you love me, Slick. I'm done.
Well, she say me and Slick. So what is Nurse Shells to Slick?
What is who to Slick?
Nurse Shells.
She answered your question before.
She said that is my brother. So what you talking about?
I didn't know who you was talking in reference.
I
only have one. Me and Slick only have one child. I only have one.
So you don't know who his sister is?
Who?
His sister.
His sister? You talking about? You know how you have that sister that y'all friends, but y'all not really sisters or kin.
Oh, that's what I'm talking about. Okay. You think it's sisters? I got you. I got you. She said that back in the day they try to play. This is my play sister, play brother.
That's what.
But they so long as there ain't too much playing going on. Oh, that's what he used to say. Not talking about y'all though. Not talking about y'all. Just talking. He said sweater related to everybody. So okay, so today has been crazy. When I said it was time for court today, it was time for court. Golly, who would have known we would have got all of this good stuff today? From a second secret transcript all the way to the end to when Miss Kayla went in to get a Rule 22 and actually talked to the DA in their face. She told DA Love, I see you. I'm going to come in your house. I'm in your courtroom at your podium. And she's saying, I see you. I got you. You talking about a smell test? I'm going to give you a smell test, all right? I'm going to give you a smell test. Y'all ain't saying nothing in the chat. This is funny. And at lunchtime, I'm thinking I got to shut down the stream and go to court because I actually had court today. But then it worked out because the court coordinator sent me the Zoom link. So I was able to jump on Zoom. Because it wasn't nothing serious. It's just like a reset status on a case. Judge said, where we are with this case? The judge actually did more talking for me than I had to do. And my client called me after the Zoom. Was like, golly, he really led into the state. I'm like, yeah, he really did. She probably like, why I even had to hire you? The judge got my back. No, you still need me. If you watching, you don't try nothing. Oh, thank you for popping back on. I thought you were done for the day. You know how you do. When you done, I had a let me see. Now my great grandmother. When she was talking on the phone, she didn't say bye.
She don't say bye. She just hang up.
She hang up.
Nah, I
hang up.
I put my laptop the wrong way and it exits you out, but
yeah, some people don't believe in saying bye because bye means, some people think it's more permanent. I don't even know what the reasoning was. I gotta ask my family.
Woody say bye mean that y'all trying to get rid of him. That's what he think that means.
Oh, okay. So she just hang up.
You done had Glanville stop in your chat.
Shout out to Judge Glanville. He said, y'all need to stop picking on my lady, Miss Love. Well, thank you for stopping in, Judge Glanville. You need to come up one day.
I'm scared. I don't know. We might be held in contempt. I can't go to jail for 20 days.
Hey, we ain't in their jurisdiction. You ain't in Fulton County.
I'm in Florida, but sometimes I go to Clayton County. And I don't want I don't want to have to go to jail.
Come on. When you say bye to someone, that means you'll never see them. Okay, some people have that belief, yeah. Yeah, they
You ain't gonna never see him again.
and that, that might have been the old meaning, and a lot of times we really translate words to have new meanings.
We
Hey, what's
do.
going on, Tall Glass? So we switch it up, but yeah, I found it so funny back in the day when she done talking, just hang up.
Listen, they, old people, you can't really mess with them too much. When they do something, you can't say nothing.
Oh
they,
yeah,
They
That
handle
is-
business. I don't know. Have you seen the other judge that's handling the defendants that are severed? Have you watched any of
yeah.
his?
Well, I don't know if he's going to be the permanent judge. Maybe he was like, I don't know if he was a visiting judge or.
They say they brought him out of retirement. He retired, and they asked him to come in to hold those meetings or the plea deal agreement. So I don't know.
Yeah, and he's really old school. I don't think you get more old school than that.
He reminds me of what you're talking about.
One lawyer tried to talk to him to explain why he needed more time, and the judge said, "No disrespect to the Four Tops, which was a music group." He said, "But it's the same old song." And he said it didn't sound good then. It don't sound good now, and that's crazy that he quoted that group, the Four Tops, because the other day the last member of the Four Tops, it was four of them, passed away. Yeah. And I said, golly, that's crazy how stuff works. He quoted them, introduced them to a whole new generation, because I didn't know who the Four Tops was. And the next thing you know, the last member of the group passed away. And he was telling the lawyer, like, did you tell me anything? Because the lawyer went up there and tried to argue why he needed more time. And the judge said, what did you tell me now that's different than what's in your motion?
I seen that, and he kept reiterating his motion. He said, "I done read that.
I didn't read it. It's the same old song."
Yeah. He was funny to me though. Like, I'm not gonna lie, he was really funny to me, and he just did not play the radio with them.
Yeah, he reminded me of my grandfather. He ain't not gonna play with you. He's gonna tell you one time, and it's crazy because my grandfather was never like a big he was no disciplinarian as far as what we know today. For the young generation, they call them whoopings. Just respect thing. I ain't gonna go back and forth with you. Just tell you one time, and one of the other lawyers tried to make an excuse. He was like, "Hey, I want to still talk to Miss Hilton. Maybe we can work out a plea deal for one of the." And he was like, "If y'all haven't worked out a plea deal in 2-3 years, y'all not gonna work out one now."
But it was one of the plea deals, though. Who is getting life as a plea deal? Like, come on, you giving me life?
Right. She said, Miss Mandy reacts. She said the Four Tops, now that was talent. I gotta go and listen to some of their stuff.
It was talent, Miss Mandy.
We hear stuff like, we may know the 5 Heartbeats because of the movies, or maybe the Temptations or something like that. But the Four Tops, they may do a movie now.
They might do. They might do. Unfortunately, so much.
I'm gonna ask you if you don't mind sparing my eardrum. Because I don't know who texts you, but every time they text you, it comes like a big.
I did not know that it was coming through my speaker. I'm so sorry.
No, you're all right. It's like a big bing. And I was like, oh man, because I got this thing.
Work. I apologize. Give me one second.
No, you're good. I know you gotta work. I'm glad you. Hold on, somebody just sent me an email. Let me see what it say. We might have some more action. Okay, Brian still filed a motion that I am not going to read. But we're just going to skim through it to see if it's something good.
That looked like a motion to dismiss.
Renew plea and bar motion to dismiss. Also, this is what he just argued. I think he said the indictment is defective. The indictment is not correct. November 27, Glanville entered an order denying this plea. Okay, Mr. William Thomas requested a certificate of immediate review. That was denied. They filed a notice of appeal. The appeals court dismissed it. Mr. Williams filed this renewed motion. Okay. Thank you, Tia, for sending this to me. So, okay, this is pretty much a technical motion. It's basically saying that when the grand jury convened to file charges against, recommend charges against Young Thug and the co-defendants, they didn't have the language right. The indictments, the wording is off. So he's basically saying it should be dismissed because, see, like this, with count one, it fails to allege the proper mens rea, the mental state. Hence, an essential element of the count of the indictment has not been played by the grand jury, and thus this plea and bar motion to dismiss general demurrer is good. So yeah, this is pretty much a technical motion, and he wants this new judge to reconsider. And he said he was going to file his all of his filings that he filed with Glanville and he filed with the appeals court. So here's a lot of that. Yeah. So this is legal technical stuff. But thank you again, Tia, for sending it to me. And she said, yes, he did compare it to the Trump case. I think this is the first time that we heard the Trump case referenced in this trial, if I'm not mistaken. Hold on, let me see what else we got. We got something else? Hold on, y'all. We might have something else. Or is this the same? Hold on, this might be the same. What the judge say? The same old song. Where did
It kicked me off. I'm just so.
All right, there we go. Did Nelson pop in here and say, are you going to talk about court today?
We have been talking about court, Nelson. Come up.
Nelson, we almost at hour number 8. Hour number 8. And he said, are you going to talk about court? You want to come up, Nelson, so we can fill you in? You got a camera and a mic?
Have it on the camera and the mic.
Right. It'd be something. Already, Nelson. Shit, please give the program laugh like we've been talking. All right. Yeah. People pop in. What's going on? What happened?
Look, are you gonna
What's
talk?
going on here?
Can you tell me what happened?
Right.
Yeah, and at no point are we saying anything about you, Nelson. We're just poking fun at the situation.
Oh yeah, yeah. Thank you for clarifying that. Because some people not used to me.
I know that's why
they come over for the first time and think, oh, he's talking about me. No.
He's
This
talking
ain't
about
that.
chat. No, he's not. We're
Thank you
just
for that.
having open dialogue.
Yeah.
Federal 6. Federal 6 got a hack. We got dreams. Oh, I mean, I don't know, y'all. I think that still. Do you think that still kind of know that she's gonna rule that the case is gonna continue and they're gonna deny the motion for mistrial? So that's why he's prepping himself for if in case they get a conviction for the appeal process.
No, he just probably just trying to get another bite at the apple with a new judge. So basically, it's just a legal definition or a legal term that challenges the validity of the indictment. That's all that is. You have general demurrers and sometimes you have special demurrers. So
So what is he asking?
He wants the case to be thrown out completely.
The whole case or just the counts?
Well, his client only has, I believe his client is only charged with the game portion of the indictment. So he's only speaking for Jeffrey Williams. So if that's thrown out against Jeffrey Williams, then it won't be a case for him. But he also did say the same language is used in the others.
The case will continue for everybody else's, basically.
I don't think it's going to be an issue. She's not going to take this up. Yeah. Any avenues to throw this case out is not going to happen. So. And this is to distinguish. Somebody may say, what's the special? In Georgia, a special demurrer is a pretrial motion that challenges the form of the indictment. But the only difference with this one is you got to file it within 10 days of the defendant's arraignment in Georgia. So, yeah. Yeah, I think you got that one wrong, though. I don't think it's a murder charge for him. It's just basically gang activity, and what they are alleging gang activity consists of, murder, armed robbery, and the whole nine. But they're not charging him with murder or alleging that he had anything to do with the murder that is in the indictment, which is Donovan Thomas. Federal 6, what you mean? What did Federal 6? What was your first question, Federal 6? I don't know, unless you just been talking with some of the people in the chat. Well, he's not really writing these documents. This is a document that he's already wrote. This is stuff he's already filed with Glanville in the appeals court. So it's not like he's starting from scratch. I mean, I think a lot of those dates was 2023.
So do you think that we're going to be productive tomorrow?
Okay, so the only thing he typed up today, and they probably typed this up while in court, was just these 2 pages. And the rest of this stuff was already filed here, November 2023, here, November 27, 2023. So all you got to do is just pretty much copy and paste and put it together. January 7, 2024. So that's how they're able to do it so fast. What was the question you asked?
Do you think that we're going to be productive tomorrow?
I mean, yeah, so far so good.
Oh, no, she says no court tomorrow.
Oh, it's no court.
Why? What happened, y'all? Did we miss something? I thought she said 8:45 tomorrow.
I thought she said 9 o'clock.
No, she changed it. Remember, she said they came back at the end and said something else. So she might have changed it to Friday.
Oh, okay. Let me see.
I didn't see that. So
there's been so much going on. It's hard to keep up with all this stuff.
right. prosecutor have homework to do. Oh.
Did I lose y'all? They doing something with these connections. I don't know what's going on with it.
No, we still here. They said the prosecutor has homework to do, so that is the reason for the no court.
Okay. Let me see. I'm gonna share my screen.
All right, I'm gonna mute myself.
And the 24th already, and then the rest of it will be forthcoming. So I don't know if we can work on Mr. Copeland tomorrow or not. I don't know what can we work on tomorrow? No point getting together, as much as y'all are all delightful. No point getting together if we can't get work done. The 18th, the 21st, and the 24th. No, so yes, that. So he testified on the 10th, the 11th, and the 12th, and wow, okay. He testified the 10th through the 17th.
India.
And then y'all took up matters about the evidence surrounding him the 18th through the 26th. All right. I think tomorrow might be more productively spent with everybody working on the things they need to work on. Tomorrow is Thursday, so let's get back together on Friday at 8:45. Okay. See everybody then.
Okay, so no court.
Yeah, no court. Y'all saw she tried to do 8:45 today, but she couldn't make it. I mean, she came in there running to get in that seat. Let's see.
She was late today?
Yeah, she was about 3 minutes, 3 or 4 minutes. Let's see. She came flying. She would try her best to be on time because she had talked so much noise.
She was late on lunch.
Yeah, she was. Yeah, she was. Look.
I trust you had evening last night.
But I mean, I get it. Sometimes stuff go on behind the scenes when you get to court that can cause you not to come out on time.
Does she have a long walk from her chambers to the courtroom?
Oh, I'm not sure. That's why we need people like Kayla with the inside info that can tell us.
I was about to say, because I know that she's in Glanville, the courtroom that Glanville was in, because they say it's the bigger courtroom.
Okay. Yeah, from my understanding, they're not even in her.
You hated the gray dress, India? Hey, India. India said she hated that gray dress.
Okay, they said she might be far. That's not her normal role. Okay.
What did you hate about it, India? Because I kind of didn't mind the dress. Like I liked the dress. The dress showed as what they still call her yesterday, rump kiss.
Yeah, he had messed her name all the way up. Yeah. So no court tomorrow. We'll come back Friday. Let me check mine. Okay, that worked out good. And thank y'all to the new people that subscribe to the channel. Definitely thank y'all. I see y'all popping up. I see y'all. I see y'all. Yeah, and it was some reason I gotta go in and see. I think she told us that something I don't know if she woke up later. She couldn't. She didn't know she was gonna go to court or be called in to go to the front. That's why she didn't have time to actually get dressed. You know. You know what, India? I'm not gonna. India, did you have any comments today? Are you good hanging out in the chat before we get out of here?
India said she had on the Forever 21 dress. Hey, that Forever 21 dress, that $12 dress looked nice, India. We can't lie now.
They can say what they want to say.
That dress looked. That dress was dressing.
Tasha say they can say what they want to say, but she said that dress was dressing.
Talk that long now. Let's be for real. That was
she actually got herself in shape, in good shape. So yeah.
Now you gonna lie like that?
What? What's wrong with her?
You is under exaggerating the truth. Now tell the truth. Say it one more time for the record.
She keep herself in shape.
Yes, but how did she do that?
Oh, now I don't know. Now
She looked good, but definitely that doctor was great.
You funny. How you know? You don't know.
We do know. We do know. Like we knew the attitude, so we do know. But she looked good. I gotta give her props. You know, she looks great. We can't talk about Rumpus like that.
Down here, I heard somebody ask a girl before, was it Mama, Mexico, or Miami?
Most time Miami. Or you forgot.
Hey, it could be Mama.
Yeah, I mean, yeah. I don't know. My mom was fortunate, so I don't know how they feel.
And we're not talking. And let me make this clear: we're not talking about
Miss Bumpkins. We are not talking about Kayla.
Talking in general. Oh, Regina say DR.
Yeah, now the DR is one of them. I don't know if you ever been taught that law, but if you ever go, I promise you won't want to come back.
But I have seen some documentaries. Isn't that like it's not like safe? I don't know if that's.
I mean, that's what they say. They say because they be taking people organs and stuff.
Oh wow!
When they put them to sleep, like you have to be careful.
Well, good. Okay, sheesh.
Yeah, because once they close you back up, I mean, how you gonna know what's missing?
Right, that's a good point. Because you hear about people sometimes passing away, and you be like, "What? What happened? What went wrong?"
But in Miami, in Miami, they have a lot of students that practice, that they be in them clinics. Them ladies be going to them clinics. They don't be informative. But Mookie said something very important. He said, "Talk that law. Do the thighs match."
Let me bring up India. I'm not finna. Y'all be saying anything.
Mookie say, "Does the thighs match?"
India.
Can you hear me?
Welcome. I'm not gonna blame
y'all. So, today was unproductive. I just think it's I don't know, maybe I'm being judgmental, but honestly 100 days in, why doesn't the state have their case more together? I'm just confused.
Yeah, I'm gonna run from that one. I'm not getting in that Kiki. They swear, boy, I done have so many questions today. They bring up every other YouTuber channel and try to get my take on it.
They did today. Who channel? Sorry, India. Answer India's question.
Go ahead. Sorry, India. I just want to clear that up because sometimes they'll clip only part of the video, and then when you respond, they'll leave this part out. So I want to keep it close together. But go ahead.
Don't even get into the mess. People so messy.
Yeah, go ahead. Thank you for coming up. She's talking about people so messy. She came in with the heat.
Don't do India like that. She came in professional.
She did. India, what was that not India?
Well, I
don't do that. Don't be going back to look. You going back to look.
Well, I had just finished watching it because I'm behind. So I had to catch up. So I had just seen it, and I really hated it.
Yeah, but she did say for whatever reason she couldn't make it. I don't know what the situation was. And sometimes you might get a call, hey, you got to be in court.
You should have a cardigan, a black cardigan, black blazer, always ready to go.
Yeah,
but
that could be
that's
fair.
Neither here nor there.
And attorney, even as males, we should always keep like a tie or something in the car just in case. You never know when somebody pop off.
Exactly. But about the case, it's just shocking. I understand the case is a lot, but the prosecution brought this case. How do they not have certain things sorted out already?
Yeah. I mean, we've seen it. They have got so much of a break from Glanville that now when it's actually time to do your job, they can't do it.
It's going on year number 3 almost. Like, this is crazy. You don't know which statements? Like, how do you not know which statements? Everything they said, how can you say everything they said is a co-conspirator? Like, I don't know. That just seems so wrong.
Yeah. I mean, they are unprepared, and this judge is holding them to task. I mean, she's not going to let them slide with anything. In fact, I believe she wanted them to be prepared today. She said y'all had 10 days since she first took over the case and introduced herself, and they still not ready. So I don't even know. At this point, it's really just a circus. So, I mean.
And I don't know how, like, the prosecution, like, the DA's office works, because I know it's, like, a bunch of lawyers. But on cases like these, typically, would this be, like, their only case they're working on right now? Like, this indictment?
Well, everything is different. It's not a one size, fits all rule. But I would imagine if they're in court all day and they never intended to take this big of a break, I don't see why they would have any other cases they will be working on, because had trial continued, they'll be in court every day, all day. So this might be the only case.
That's why I'm confused as to why they're not ready. Like, I understand, it's not even really the defense. But they were actually, in other court with other clients, etc. But the prosecution, it seems like this is their main focus. So what were they doing all break?
Yeah, and that's a good point. They still filing motions late.
It's been almost a month. It's been over a month. Like, I'm confused.
Yeah, but this judge, she's not going to play that at all. So
I think she started giving them a pass, though. She should have just got directly on them today, because she's still kind of giving them a week to get, like, stuff that they should have had months ago done.
Because this has been going on since, 2021 or 2020? Well, 2022, I guess, technically. But we're past halfway through 2024 at this point. Like, what's the holdup? Like, you don't work as you go. Like, you indicted all these people and you don't have a few statements. Like, what's going on? Like, they don't even have anything to start with.
Yeah. And I don't know, maybe the judge, she's trying to save what she could. She's trying to salvage the case. So I guess if she stopped the prosecutors from bringing in evidence, then they may not be able to salvage the case. So she's still trying to give them enough leeway to, save the taxpayers as much money as they can to get this trial over with. But the thing is, she's still trying to push for plea deals.
Which doesn't make any sense, right?
Yeah, it don't make sense to me.
The DA ain't doing it.
They can't agree on what temperature to set the thermostat on.
They were still trying to give the other guys, from what I heard, at least some of them, like the pleas they were given were life sentences. So it's like, or like a lot of years. So it's like, that's not a good faith plea bargain.
Them guys not taking that.
They didn't take it. They all turned it down. But I'm saying that was just maybe like a week or two ago. They're not giving these guys a plea. Like, they're not even going to offer them nothing at this point.
They might, though. You never know. It depends on how things one with
how this case go, right? If they getting beat down in this case, then that may be a good incentive for the prosecutors not to waste all that money and embarrass themselves a second time.
Now I'm gonna task you.
Not give me homework like love.
No, did you see when Simone today stopped Love from talking right after lunch? When the judge was asking her a direct question when Sharp was up there, and she stopped her. And when she stopped her, she made her shut up because she was finna continue to talk, and she told her let her finish.
I didn't see that.
She like literally shut the mic off and told her no.
Wow.
I gotta go back and look.
I wish I had the timestamp. I do have. I recorded it, but I screen recorded it, but I don't have. You know, when you rewind it back, you don't get the exact timestamp.
But I honestly think they'll get it. It's going to end up being a mistrial before they would ever give them a plea. Because they're not going to take a plea unless it's literally, like, I don't even see the defense taking a plea unless it's time served and they get out immediately.
Yeah, that's the only way I think, because there's no sense in taking like 20-year probation plea or something like that, because that will give the state an opportunity to get you on the back end. And if I had a DA like Love, she'll sit around and make sure you get in trouble. So she can be waiting to revoke your agreement. Once they don't need you anymore after the trial is over with, then you're no use to them on probation anymore. You get in trouble again, then they can go and say, hey, judge, you should revoke his probation and send him to prison.
Well, that's what happened with Umfum, right?
Young Thug's brother?
Uh-huh.
Yeah. He went to, So I don't put nothing past the state.
Lying Love. No, man.
Yeah. I don't trust nothing.
I take my chance with 12 before
I
just can't believe.
I'll be there by 6.
I just can't believe the flat out lies she tells. Like, there's been so many times, like, where she just flat out lies. Like, it's not even like I'm not sure, I don't know, let me check. It's like she'll literally just tell a lie. Like, that's why I'm happy she got called out. Because, come on now.
And I believe she was upset when the judge reminded her of her duty to be truthful.
Upset wasn't the word. She was furious.
Yeah, she was. Yeah.
Let me see. I wonder if you have that clip when y'all see when Brian still pointed at her.
Yes, this morning.
Still cracked me up. Yeah, that was my favorite.
Listen, they was not playing with her today. I don't know what it was that she did to them, but whatever was in that transcript that they interpreted, they did not play with her today. I don't care what nobody say.
Yeah, like her still in love. That's beef for real. Like they beefing. Like
He's never gonna talk to her again.
Yeah, it's beef. I don't talk to Miss Love. In case you didn't know that.
And it's crazy. He would rather talk to Fanny than her. Like that threw me.
And the shady judge, she know how to throw some shade. She said, "Well, who can you talk to over there?"
Right.
I want to see Fanny in action because her temperament on a stand, she came off similar to Love.
That's what her protege. She definitely is her.
Hold on, I'm gonna find that timestamp real quick when the judge was.
Hold on. Let me see if I can. I got it, but I don't. I know it was back, but the times may be different. Let me see.
Let's see. For
It was only 1 minute, but it was right after lunch when Shard stood up. So go. Let me see if I can find it. I'm sitting up here.
Y'all see Love with her slime green nails?
Yes, and her outfit is cute. Okay, I got you muted so I can go back. Let me see if I can find it. Where's lunch? You got the banner up according to recess. Okay, so here's your banner. So
yeah.
Where's lunch? Lunch is on. All right, you still streaming, so the time might be off by a little millisecond, but I'm gonna get it. All right, sure, it's gonna come up. I think I found it. Hold on. Okay, so go back to 3 hours and like.
What up?
Go back to like 3 hours and like 2. I think this is it. Okay, go back to what is this? 3 hours and 14 minutes. And
Okay,
then,
let me
and
see
then start playing from there. On your, if you go back on, well, you can't go back on your stream, but
yeah, but I actually have the yeah, the judge wasn't playing with her.
I like the judge. I mean, she's trying, I guess. Because some of this stuff is just unacceptable. Like, I think she's kind of caught off guard. Like, that is, I know people knew it was a mess, but I don't think she thought it was as bad as it is.
Yeah.
Because we are like 100 days, and it's not like it just started. We're 100 days, and not much has been accomplished.
yeah, I don't
Yeah,
think
the DA just so unprepared. They're not ready for this.
I don't think anybody could have came in this thinking that this thing was as bad as it was.
Yeah, it's horrible. Yep, unprofessional and unprepared, Kiki. So where's the transcript? Like, did they upload it? Like, is it
It's in Steele's motion. It's in Steele's motion. I'm not Steele. It's in Weinstein's amended motion.
Oh, I gotta read it.
It's a like document. Like I think Exhibit A. So if you go down to the bottom, you'll see it. But if you look at Talk That Law page, he read through it on I think break.
Okay, so I found some of the links that we were looking for. I'm gonna try to when the judge was getting on Love. And I'm gonna just play directly from the stream itself. It might be easier. And this is when the judge called out, like, who wrote this motion? Who told a line of motion? And I believe, was it you, Tasha, that said that you think Fonnie wrote the motion instead of Love? That's why Love didn't know what was in the motion.
Yeah, you know it.
Let me play this piece right here.
Reciprocal discovery obligations and to exclude evidence intentionally withheld and not timely disclosed. And I had via email asked specifically as to the authorship of this particular motion, and to have whomever authored this motion be present in court. The response I got back was Ms. Love saying, "I will be present." Does that mean, Ms. Love, that you are the author of this motion?
Yes, Judge.
Okay. So I have some problems with some of the representations made in this motion. Specifically on page 3, the citation to U.S. versus Young, and then to U.S. versus Waddell, and then the statement, quote, "A defendant has a duty," underlined, "to disclose prior to trial."
Did we freeze?
That discovery and reciprocal discovery obligations of the defense applies to evidence that's going to be used solely as impeachment.
I didn't say solely as impeachment. I said as both impeachment and as substantive evidence.
Which implies that the use of it as impeachment evidence triggers the reciprocal discovery obligation.
No, unless I wrote it inartfully. What I was saying.
Well, you wrote it inartfully.
I did then.
Well, she said she wrote it what? And I don't know, y'all. I don't know if it's StreamYard or what, the software that's glitching. I gotta get that looked into. She said she wrote it what, in honestly, or I don't know what she said.
As impeachment evidence triggers the reciprocal discovery obligation.
No, unless I wrote it inartfully. What I was saying.
Well, you wrote it inartfully.
I did. Then,
oh, inartfully.
Because what I was saying
okay.
was that it has to be both. That is the representation that.
All right.
I made, and then when I amended it,
I didn't see an amendment.
I have a copy for the court.
Did you fix that?
What I did was.
Thank you.
Sort of elaborate on it, or yes, I guess you could say it was fixed.
Oh, the judge,
So
the judge
you
don't like
concede
that.
then that if evidence is going to be used solely as impeachment evidence, that there's no triggering of a reciprocal discovery obligation?
Yes, that's
okay.
Yes, I was not saying that. I was saying.
Good to know.
My apologies to the court for that inartful wording.
Okay.
And what I said in the amendment, Your Honor, was.
Did you email the amendment to my chambers?
I did.
Okay.
Yesterday, I believe.
Yesterday. Okay.
Yes, it
Well, that
was.
may be why I hadn't seen it, although I've been looking at y'all's stuff nonstop. Okay. It's in front of me now. So.
So what our position is, Your Honor, as I state on page 3 of the amendment, is outlining what Georgia's statutory requirements are. Of course, the court is aware of what OCGA 1716 4C1 requires. And then I go down to subsection C on that same page where I cite Aggie versus the state 311 Georgia 340 at 343, and go on to say Georgia's discovery law does not explicitly apply 1716 4C to evidence used simply for the purpose of impeachment.
Okay.
And then I say it unquestionably applies to that second intended purpose, use as substantive evidence. And then in section D, Your Honor, I cite to relevant similar federal laws, pointing out that federal law requires the defense to provide the government with materials that are within the defendant's possession, custody, or control.
It maybe be impeachment evidence.
We already know the legal.
This can be
Y'all, the stream is so unstable, we may lose the stream. I don't know. Hold on, y'all. Let me go back. We may lose the stream. It's trying to kick us off. Have we been on too long?
Does it kick you off after a certain time like it did yesterday, or did you hang up on us?
I think it did. It acts weird sometimes. I think it's StreamYard. Let me see. I want to see when she. Okay, all right. So we got that done. Let me go to the second timestamp when Brian Steele. That's 6:20:50. 6:20:50. When Brian Steele got on Love and pointed at her like he was a crazy person. What if the Love would have slapped his hand, y'all? What y'all?
And says it's hard to
I
hear.
thought she was going to.
Hard to decipher on an Apple iPhone. That did not happen.
How he gonna go?
It is offensive.
Look at him.
The legal analysis is wrong. There is no distinction in Georgia on substantive or impeachment. What you were told is wrong. And this lawyer knows it because she sat here in court and I did the same thing without being tempered.
All right.
Look how she looked. Look how she looking.
Thank you for
like yeah,
clarifying.
look at look. What that look
and
mean,
I did
y'all?
the same thing without.
Did that look mean? Y'all better get him.
Lawyer knows it because she sat here in court and I did the same thing without being tempered.
All right.
That's 4 times.
Thank you for clarifying that.
Did we go too far?
Yeah. Fine.
Here is Georgia on substance is wrong. There is no distinction in Georgia on substantive or impeachment. What you were told is wrong. And this lawyer knows it because she sat here in court and I did the same thing without being tempered.
Look at her face.
All right.
That's 4 times.
Look how she looking.
Thank you for clarifying that.
Briefly respond.
And then I think they're going to ask Love. They're going to ask Love. Did he do it 4 times, or is he? Is that true or not?
Love. Do you? I would like for you to take your.
Say that this distinction. No, we have a duty. Constitutes case in chief. From there, we made the assertion, the state's position that in a reasonable interpretation, in our position, a reasonable interpretation, and as we've
the judge laughing. Hold on, we gotta go back. See, the judge knows she lied.
Case in chief in the witness list.
There is no distinction here in court. That's 4 times.
All that
look how
represents what you have asserted in your motion and amended motion.
The judge,
Your Honor, that's just it. I have been clear in my amended motion, and
which
to the
I
extent
just
that it wasn't.
got a copy of.
Yes.
Okay.
And also I just want to say that
no Georgia law.
Right. Georgia law does not define. It does not define case in chief. It does not break it down.
We all know what a case in chief is. Don't we? I think we all know what a case in chief is. Is there any support for your assertion that reciprocal discovery is required based on the concept of substantive evidence?
Yeah. Your Honor, what I have said and what I maintain is that, one, there is an absence, and I'll point the court to 3 different cases, Harris versus the state, 314, Georgia, 238 as one. And these are just instances.
238? What did you say?
Yes.
Okay. What are the other 2 and what are they gonna? represent?
307 Georgia 171, which is the 2019 Green case that Mr. Steele cited for the court, and 146 Georgia App 423, which is Phillips versus the state. And
we're just gonna get to the good part.
Constitutes case in chief. From there, we made the assertion, the state's position, that if the defense intends, because there's nothing in Georgia law that analyzes it at this level, if the defense intends to introduce evidence as both impeachment and substantive evidence, then they have a duty to disclose it. And that is the origin of the state. That is the basis for our position.
And have you heard Mr. Steele argue 2 or 3 times before that that's not at all what Georgia law means?
Here we go.
We've not made this argument before. So
I don't mean in writing. Y'all have not had any discussion whatsoever in front of Judge Glanville about.
As I have said in my motion, Your Honor, what we have argued, the state has said, Your Honor, they have a duty to disclose this. This is stuff that we are entitled. And Mr. Steele has said no, in citing the Georgia statute.
Okay, so
I have never.
So y'all see what happened. The judge said, have y'all argued this already a couple of times in front of Glanville? And it started off, Adrian Love started off saying no. And now she's saying, okay, we did argue it in front of Glanville. And I think the judge got upset. Let's go back a second.
That's not at all what Georgia law means?
Our position.
And have you heard Mr. Steele argue 2 or 3 times before that that's not at all what Georgia law means?
We've not made this argument before. So
I don't mean in writing. Y'all have not had any discussion whatsoever in front of Judge Glanville about.
As I have said in my motion, Your Honor, what we have argued, the state has said, Your Honor, they have a duty to disclose this. This is stuff that we are entitled. And Mr. Steele has said no, in citing the Georgia statute.
So you argued
he said we do not. I have never asserted, I've never made this distinction. I've never said that case in chief means if it's being presented as impeachment as substantive evidence. I've never made that. I've never made that argument in a written or oral filing.
Okay. All right. Well, I would like for you to take your duty of candor to the court with a little bit more seriousness in the future, Ms. Love.
Respectfully, I take it very seriously.
Okay, so
oh man, that's wild. So yeah, the judge is really not feeling Love. I mean, she's accusing Love of lying in person, and orally, and in writing. If Love even wrote that motion.
I think she wrote it.
Oh, you think she wrote it?
Yeah, I do.
And she just lied about the case law. She didn't expect a former appeals prosecutor to read it.
Yeah, she's been doing this the whole time, and Glanville has been letting her get away with it for the most part. Like he lets her get away with it unless there's no other way, like for him not to. Like unless like they flat out prove her wrong, and then even then he still doesn't correct her. He just moves on.
Right, like even today when what did he say? He was trying to figure out. He wanted Miss Love, lawyer Love, to explain to him what he can do about removing Woody's lawyer, and she said, "What she said? I gotta go do my homework." This is the secret meeting from the second secret meeting, which was actually the first secret meeting. The court.
What are you asking me to do?
The court. What are you asking me to do? What are you asking me to do? Said it twice. And what do you think I can do? Miss Love. That is the exercise. That is a homework for tonight.
Not that's their homework.
The homework for tonight. She said, I just want to I want to put you on game. I want you to know what's going on. So when I find out what you can do, then I'm gonna come back to you. I wanted to let the court know that is what we're looking into right now, because there is a remedy, because I have faith in our law. Yeah, right. I love this thing. And I know there's a remedy, because this can never have been the first time this happened. It has been addressed. I just have to find it.
Oh, they real.
She went to search. She
They
went to
real
search
chummy.
hard for it.
But she said, but I didn't want to go looking for something and not let the court know. Basically, I wanted to know you got my back first. So you're not caught off guard Monday morning or Saturday night or Saturday afternoon. What are you talking to this man for on the weekend?
Yeah, they real chummy. Like they real. What's tea? What is the tea?
Now y'all know y'all know people already been saying they was messing around. So now y'all alluding to the fact.
Thank you for allowing audience with the court. I just want to make certain that we did everything properly and had it on record.
Oh, they definitely had these type of talks off record for sure. Oh, for sure. Because this is too friendly. It doesn't even seem like a professional conversation.
Yeah. Because I'm trying to figure out why what would be so pressing?
Anybody who thought maybe still was putting 20 on 10, this proves that this is given we work on the same team. This is something it seems like she could have been talking to Hilton or somebody about, not the judge.
Right. And I'm trying to figure out what is such an emergency that you have to contact the judge Saturday afternoon or Saturday at nighttime. Because y'all don't want Woody to have his own lawyer that he hired. Y'all have to wake up the judge for that.
You own something.
Y'all gotta wake up the judge for that.
They wanted him to testify.
What they want to see down here.
They wanted him to testify because they don't have no case without him. They didn't even know, they didn't know where they would go without him. That's why they were so desperate.
Wow. This is crazy.
Oh, this is some nasty work. I don't like it.
Yeah. There's no reason, because this motion or this secret hearing with the judge and the prosecutors is basically they trying to tell the judge, hey, judge, kick off Melnick. Melnick, he's in cahoots with the defense attorneys. And we can't even bring in Kayla because Kayla in cahoots with them because she was hugging them on her private time. So kick them both off. Woody don't really need a lawyer. But I'm trying to figure out why
they didn't want him to have a lawyer.
They didn't want him to have a lawyer so they can get him to testify to win their case. But I'm still going back to, I get that's something you can bring up normal business hours. It's not like the court's on fire or somebody's getting ready to die and you need the court to act right away in the middle of the night.
And that's what I'm saying. It's giving friends. It's giving we're on the same team.
Yes.
And
then the way he asked, what do you want me to do?
Yeah, how can I help you? How can I serve you? What can I do to help you out? That is not something a judge should be talking to any lawyer about. I don't like how the judge downplayed it, because he downplayed it like he was they were mischaracterizing it. And no, because this is salacious, if you ask me.
But not only that, the thing is, Miss Love, I found it interesting when I read it earlier. DA Love is concerned. She's basically saying her concern is Mr. Melnick, is Woody's lawyer insertion of himself. Woody's lawyer representing his client is a concern for DA Love. And the court is like, okay, that's between a lawyer and a client. They can hire who they want to hire. And the court is pretty much saying, what are you asking me to do? He said it twice. What are you asking me to do? And what do you think that I can do? Give me some ideas. Help me out. Give me some options. And Love said, that's the exercise. That's the homework for tonight. And my thing is the homework for tonight. So for who? Her, Glanville, both of them?
Both of them. It sounded like they was in cahoots, like they was working on a group project. That's
together.
What it sounds like. Yeah, you find what you can find, I'll find what I can find, and I'll text you later. That's what it's giving.
Because I can understand, she said, I don't want to catch you off guard Monday morning, but it was weird that she said, or Saturday afternoon or Saturday night.
I think the whole thing is weird because she already stated in court what she thought about Melnick. So I don't understand why she felt the need or why she thought the judge would be caught off guard.
It was weird to you, but it wasn't weird to them because they've been doing this. This ain't the first case they done did this song.
Can't be.
Definitely not. And they definitely been having these talks off the record.
Do you think that talk in law that this is gonna prompt more people in like Fulton County that has had these sets of individuals to question their case and how it was handled and to try and get things unsealed that were sealed?
Yeah.
Kayla did say people was already kind of starting to do that.
I mean, I think they should take a look into anything that these prosecutors handle. And I know a lot of people want to make the distinction between Love and Hilton, but it's almost like a corrupt police officer training a rookie.
Right. Yes.
And, I mean, you didn't rubbed off on a rookie. You just showed him all the bad ways.
You done told them all the ropes, everything to do. DDA, CDA, all of y'all the same.
Yeah.
All of them the same.
I mean, so, Fonnie Willis can call them what she wants to. All of this, these titles, DDA, DDA, all this and that. But they still no good, no damn good from the top to the bottom. And I think they all need to be reviewed, all of their cases that could potentially have secret ex parte meetings, especially if they were tried in Glanville's court. If they were tried in Judge Whitaker's court, the court we in now, okay, I may be less worried. But in Glanville's court, definitely take a look, because obviously the judge and the DAs are texting or calling each other or seeing each other in person in the middle of a night. I mean, why would she tell Glanville, I don't want to catch you off guard or bother you with this on Saturday night?
Right.
Maybe over a glass of wine, allegedly. Who knows? I don't know. I don't know what I don't know. And somebody had said earlier today that they think that Hilton, she was referencing Judge Glanville, and they think that she slipped up and was about to call him uncle. Did y'all hear that?
I heard that, but I just thought like she kind of, I don't know. I thought maybe she misspoke, or like I kind of like misheard it, because she don't always talk the clearest, but I did kind of hear that.
Oh, okay, you heard about it. I was going to say, now, if it comes to find out they related, this man better not be her uncle, or I'm going to be done.
I didn't hear that now, y'all. I didn't hear that.
Yeah, it was said that she was referring to Judge Glanville, and instead of saying judge, it sounded like she was starting off saying uncle. Which is weird. That's weird. She said, "Can you play it?" Let me see if I can find it, because
I don't remember the timestamp, but I did hear it, and then I'm like, no, I'm reaching.
Okay. Let me see if I can find it. Oh, I think I found it. I found it that fast. I got lucky. I don't even know how that happened.
You had that stored.
I ain't have it stored. This is straight off the internet. Let me see. I don't even know how that happened. But I don't know. I don't think Hilton spoke that many times today. So when she was at the podium. So let's go back a few seconds. Yes.
Are there other specific evidentiary issues we want to consider? Or do we want to just jump right into hashing out some of the evidence?
Your Honor, during the course, the state also looked at the redactions that we had previously discussed with Judge Glanville for the statements that we had. Your Honor, during the course, the state also looked at the redactions that we had previously discussed with Judge Glanville for the stations that we had previously discussed with Judge Glanville.
What y'all think?
Yeah, she almost said that.
Somebody said maybe she was calling him by his first name.
Yeah, because it sounded like maybe she was saying like or like she was kind of caught between two words.
Oh, okay, I got you.
His first name is Ural, though.
Somebody said the whole word came out uncle. Let's see if we can slow it down.
I thought she was saying
just for the just because. Let's see. We got a little time.
For the states, as it relates to the January 11th, February.
Hold on. I don't know the timestamp. Let me go back. Hold on.
January 28th, February 20th for the states that we had previously discussed with.
Okay, here we go. 232-34. Okay.
Of course, the state also looked at the redaction.
It's wrong. It's been a long day, y'all. Work with me.
That we had previously discussed with Judge Glanville for the
what y'all
state.
think? I don't know, y'all.
Judge Glanville had previously discussed with Judge Glanville for the states as states.
Yeah. I mean, it sounds like it could have been it just depends on how you look at it.
That we had previously discussed with Judge Glanville.
Okay. I don't know. Somebody said Uncle Judge, Uncle, yep, Uncle. Who's that Uncle? That's his nickname. Somebody said I said it when it happened. Uncle Judge, Uncle, that whole Uncle thing.
Maybe
everybody's saying Uncle.
Maybe she was accidentally saying it.
I don't know. They better not be playing uncles and aunts. That's what y'all do in Georgia.
Won't do that down south. Don't.
Oh, okay. Don't give me the line.
Yeah, like that.
Don't give me the line. Allegedly.
Woo. Probably said that you had an uncle that's their friend, but
y'all do the cousins over there. Cousins make dozens. That's what y'all kissing cousins. What y'all call it?
Yeah, that's what they call it.
Oh, that law like you ain't finna play with us southerners like that.
Oh man, I'm in the South, so I'm in Texas too. So I can't talk too much about y'all. But we don't play that around my parts.
Hilton ain't from down there though. Hilton's from Philly.
Oh, okay. As long as they don't try to teach you the ways, love.
They done already taught her.
They taught her allegedly.
She in on it all, and it's sad that she's messing up her relationship. And her
Tina said she heard Uncle. Keep it going on. We tried to see what we heard. We had to slow it down.
Uncle George.
Regina, what did you hear? Yeah, I actually did. We took lunch. I actually took lunch today when I paused the chat because I had court. Yeah. It's really not that bad. When I first started, I mean, because you're sitting down, it's not like you're walking. You know, if you're walking, then okay, yeah, you might have to use the back of your body move. But you just sitting still, you good. Yeah, don't get me wrong, when it's live over with, I might be, once I stand up, oh man, I gotta go out and drinking all this water.
They telling you to stand up. Now
Yeah.
They trying to get you to go to the bathroom for yourself.
No, I'm good. No, it wasn't. Now, yesterday was. Yeah, we did some streams.
Yeah, yesterday was what, like 12 hours?
Yeah, this is just about.
You said for 12 hours yesterday?
I think it was right at 11 and it hung up.
Yeah, we had a lot going on.
Oh God.
We had a stream, a 9-hour stream, a 9.5 hour. Yeah, we put in some hours to grow.
Talk that lot. That's a job.
It's a job. People don't understand. But I'm glad because I got a good team when it comes to my cases, and I got a lot of like this week just really opened up, so it was timed perfectly. And I was supposed to actually be in trial, have a intoxication manslaughter trial, but the judge keeps skipping us. And I told the judge, I said, now, Judge, my client had been in jail for 2 years. And we need to
been on here commentating.
And we need to really get this trial over with.
It's because you've been on here commentating that they skipping you.
You think so?
Yeah.
Yeah. She ready to get it over with. The family ready. And like, whatever happens, happen. We just need to go to trial.
So is this your first time? I know your channel's new, but like, is this your first time following like an online trial?
I mean, actually live, yes. I did a little bit with the Trump, and with that, it wasn't live because New York don't want cameras in the courtroom or don't allow cameras in the courtroom, so I really couldn't just do much. But this is like the first trial that I actually got a chance to just, actually watch live on YouTube, and I didn't know how it was going to be, but it actually is pretty good. Watching it as it go, and especially having like y'all in the chat, y'all may have a few questions that pop up. Somebody said the whole uncle slipped out. I'm not saying that's what she meant, but that's what she said. They used to say back in the day, say what you mean and mean what you say.
I think the judge got them kind of nervous, so they slipping over their words.
Yep, because Glanville, they could do whatever.
Love sound like BBL Brown up there today.
Yeah.
Regina said uncle. Regina said Uncle Judge in arms. Regina said get them cash apps in. Yeah, and Regina, the cash apps they nice, and I do thank people for contributing. But trust me when I tell you, ain't no cash apps coming in that's worth me sitting here $10, $11 a day. I'm losing money.
I don't know.
I'm
losing.
Some of these,
That's because you're growing. That's because you're growing. But some of these streamers, I don't know.
Right. Some of the like if you've been here for a while, like these bigger channels, then they can retire.
Emily, yeah, because I don't know. I think YouTube might have retired her. I'm not sure, but I think her chat was one of like the first trials that I watched in real time on here, like in real time.
Oh, okay.
Because she did the Murdaugh trial.
You talking about the one that got like almost 1 million subscribers or 1 million?
Well, I don't know if y'all know, but like most of these like LawTube people got big like recently. They got big during Get the Heard. But most of them are pretty new.
Oh, okay, I got you. Yeah, and a lot of them are probably retired or this is all they do.
Now, yeah.
I actually still got to go to court. And not only that, I do not only criminal defense, but personal injury. So I got a lot of vehicle accident cases that we have to work.
That's what you need to do.
So you rich.
You said what now?
So you rich?
I'm rich, and I need some more. And rich can be, everybody level of rich is different.
Rich is a mindset.
Yeah, people might see you and say, "Oh, you got a lie, you got a big house, a real big house," and then you go, a few blocks down, and it might be even a bigger house, and so on and so forth.
Yeah, that's true.
So I mean, I'm not complaining, but there's always room. There's always room for improvement. But what I really wanted to focus on this summer is growing my the channel for sure. And at first it was like, okay, I'm gonna educate the people, but then the chat was like, they were pushing it. We're gonna grow this channel, and next thing you know, it would just start taking off, and what really just blew it up significantly is when Kayla came over. I think we kind of really blew up each other's names and channels, YouTube channels. Because when she came, a lot of people wanted to see her very first, I won't even say interview because I wasn't questioning her. I didn't want her to get in trouble. But our first discussion. And then once that happened, a lot of people signed up. And then, she was out there. Everybody, Kayla Bumpus, and next thing you know, she started her channel
You
and
should have
blew
questioned her.
way past this. Our numbers, but I'm
Because
not worried
people are
about.
messy.
You should have questioned her. You should have drilled her into the filth. You hear me?
The attorney and me wouldn't even do that. But not only that, she had her own team of 5 or 6 attorneys at the time she came here. So
Because it was when everything first happened.
right. So this is, and next thing you know, I ain't really know nothing about the YouTube and all of that and the monetizing. You gotta wait till you have 1,000 people, and then you gotta have like 4,000
Strike them
watch
for using your
hours.
content.
Yeah, it's a whole lot of stuff behind the scenes when it comes to YouTube, and then you gotta make sure you got the privacy concern, because you got the crazy people out there that don't agree with you, might send you crazy comments, crazy emails. So it's a lot to balance, but they ain't ran me off yet. Reese up there, love. Oh, what's going on, The Haven? Thank you for popping in. Oh, her student loans were forgiven. What area are you in?
They need to forgive mine.
Listen, what area you in? I need the help.
Everybody trying to figure out, right, what student loans forgiven? What you talking about?
The only people I know is people that had certain, like they work in certain fields. Those are the only people I know.
Yeah, those people did get it quicker than everybody else.
I know this lawyer who I used to intern for when I was out of high school or get my associates first, and I recently seen him, and he did his 10 years as an attorney, and all of his stuff was forgiven because he worked for the government. But so I guess it's a balancing. You work for the government, so you are getting lower pay, but at the same time, it's still equalizing out because your loans are being wiped out. Versus a regular attorney who may be making twice the salary, but at the same time, the student loans are not being wiped out. So I guess it's 6 in one hand and half a dozen in the other. So somebody said she was channel hopping, and yeah, but the thing is, on YouTube, you want to pretty much build your base of people who will support you. You don't want to just get a whole lot of people that just want to come for one thing only, and then they go away, or they won't come back to support you, or they not, they're not really riding with you. I mean, it wouldn't make sense for me to get 20,000 subscribers and only 200 of them is gonna come back and rock with me. So it's really important to build a base, and I'm not saying that's going on with any other YouTube channel, but
it is.
But that's why I don't mind, working day by day, taking it day by day.
Yeah, it's best to grow organically.
Yeah, and you have some people out that may try to skip the line, and they may try to pay to get fake bots and people, but that definitely is not going to work out in the long run, and it might actually even be against YouTube policies.
It is. They'll delete your channel.
Yeah, so I mean that's not even worth it, and the bots ain't gonna sit there on live with you and watch your stuff and interact with you. So it might be easy for YouTube to detect something like that. We done turned this into a YouTube educational channel. Anybody trying to start a channel? I mean, I only been here a few months. Yeah. Let me see. Oh, you got that pain and injury money. One thing about it, but the criminal defense money comes in faster because people go to jail, they're trying to get out, they're gonna pay for you right away. The personal injury money you have to wait for because your client have to treat, they gotta go to chiro, the doctor. That'll take a while before that case settles. But when it does settle, you get a third. sometimes more than that, depending on if you have to file a lawsuit or not. So if we have to file a lawsuit, we get more than a third. So it can go from 33 1/3% all the way up to 40% because more work and more overhead, more cost, like to file a lawsuit, and then you got to get it served, the process server, and all of that stuff. They're running around trying to locate the person. And I think Kayla's been fixing to open up a firm in Houston. I think she just took the MPRE. It's another test that lawyers have to take besides the bar exam. But other than that, she should be working in Houston in no time. I think she go back and forth.
I don't know.
Well, I could say this for certain. When I went out of town a couple of weeks ago, I know for a fact that had to be Kayla on the same plane as me, because the plane was getting ready to take off, and I seen like some braids. It was like one of the last people that came on, and safe to say I was coming to Houston. Oh, okay. Somebody said she moves back and forth. I just haven't had a chance to call her. Maybe I do that.
Talk that long. You see Law Malcolm saying that you won't talk about that dress?
He did talk about it.
He said you won't give your opinion on how that dress look.
Yeah, I mean, she already addressed why she didn't have a chance to put on like her normal lawyer clothes, but it was just in and out. I don't know what else you want me to say. What else you want me to say, Law Malcolm?
Right.
You're so politically correct.
The woman, y'all forget.
They trying to attack the man and you talk that loud.
Yeah, nah, I'm not gonna do that.
They being messy.
That'll be inappropriate for me to, this girl got a whole man, and they know. And they don't even know if I'm on the damn market.
I know
So
exactly.
right. So
I can see your hands.
People just be talking. Somebody said I'm writing an $85,000 check now to an attorney/client. Okay, yeah. So yeah, the money comes in. So if you rack up, a decent amount of PI cases and you get a third of each, and the attorneys get paid first, we get our cut off the top. They send the checks to us. We get our money, then we dish out the remainder. Oh, somebody said on Makeup Man, that's a man named TJ. Y'all funny. Look at
You ain't her
man.
Instagram friend? You didn't follow her on Instagram?
No, I don't really do Instagram like that. I need to start getting active on there because when something else happens, let's say another big trial or something, and I want to talk to some of the people after the fact, and they see me without an Instagram and it's not active on, 1 or 2 followers, they're not gonna take me serious. So I really need to start. Yeah, I'm a troll. Yeah, so I really need to start building up my social media platforms. So when something else happens, I can actually talk to some of the people to bring them on. I found your channel through Kayla. I subscribe. Shout out to Kayla. See, he said the Haven. How is that possible? Well, y'all gotta remember.
I think that was the first time I seen you, and then I came over here and supported
on her first live.
No, I seen you on somebody's channel, and I was like, "Oh, who's that?" And then I found your channel, and then.
Oh, okay.
Yeah.
Oh, thank you. Okay, because I never really just know how like the algorithm works and how people get like routed over here. Because I know there's so many channels on YouTube that it's really hard to focus on just one. Regina say, "Get out that boy business, Law Malcolm." Y'all be talking crazy. What did he say? Oh, India had the googly eye. She said, "Oh, who that?" Boy, get that slick, boy. They be saying anything.
Law Malcolm is like, he's messy. He don't even got a picture. Ignore him.
I was reading from Slick. when he said your name. He's just joking around, of course.
Slick, don't try me. Don't try me, Slick.
Well, we lose watch hours after. Okay, hold on. She say, well, we lose watch hours after 365 days. Got to stay consistent and keep uploading. Oh, so you got to have the watch hours. That makes sense. The 4,000 watch hours every year.
Oh, Jesus.
And that makes sense because, I mean, if you're consistent and you already have enough subscribers, you should get that 4,000 easy. I mean,
especially if you live stream.
Yeah, if you live stream, people are gonna be popping in. We might have hundreds of hours of watch hours just from today alone. Because I've been live for 9 hours. Yeah. But it worked out though, because soon as the judge took a lunch break, I had to be at court at 11 o'clock Texas time. And I just switched the camera over to Zoom and hit the link. And we just went on from there. And it took about 5 minutes. But this judge is one of the few judges that still have the Zoom link. Some of them require attendance in person. They say they want to see your face. They want to see you and your client.
I think all of our family law cases here are on Zoom now.
Are they still on Zoom?
Unless they request to begin.
Yeah, I mean, it's so convenient. When COVID came, it really opened up another avenue. But some judges are, old school. They want you there. But if there's an avenue to keep less people there, you get out faster. I mean, it's so easy just clicking on lawyer. Okay, who's your case? Where y'all at with the case? All right, bye. Come back in such and such date.
Zoom has made people lazy though. They don't really get dressed. I know I don't. I'm dressed professionally from my chest up. I got on a blazer and that's it. I might have some shorts on and sitting at my desk. So it's convenient. But
yeah, that makes sense if you're not law stream. But if you gotta stand up or something happens, you definitely want to stand up with no pants on.
Stand up?
Huh?
You have to stand up on Zoom?
No, you don't have to stand up, but I'm just saying if something was to happen and you still gotta remember the human nature element. Like in your mind, you might stand up or do something or reach for something and not even realizing, like, oh, I'm alive. So, it's always best to
I trained myself to when
I'm trained to sit down.
I'm sitting down.
Don Cato said, question is, are you placing ads in your live stream? Sometimes, like today, I did not. I might go back at the end and turn it on. But sometimes I'll turn it off because people will stay longer and the subscribers will, they stay on longer and they may say, oh, okay, I actually like this person. At first, when I clicked on, he was talking about my homegirl in Georgia, but I actually like him. The ad didn't run them off. They stayed. And next thing you know, you may have 30, 40, 50 subscribers. And it's better than, you missed out on a couple of dollars from ad money, but, it's worth it. So it's all pros and cons. But I didn't even know, Don Cato, you have a channel. I didn't know that until I don't know how, but I had seen your channel in the YouTube suggestion box. Don't you cover like court cases, Don Cato? Let me go see. And I thought it was court cases from Texas, or is that train? That may be train wreck.
So are you going to be following more cases or just this one?
Yeah, I plan on it. What other cases, coming up that may sound good?
I don't know. That's what I was asking. I'm not sure. Because I've watched, like, the past year has been crazy. I wasn't really into Depp v. Heard, but I watched Murdaugh. I watched Darrell Brooks. You know who Darrell Brooks is?
Oh yeah, yeah. He represented himself say yeah. Or as he
Awful.
say pro per.
It was
Yeah.
awful.
Yeah,
So
but I
now-
mean in his case he was, you know, he was pretty much done no matter what.
yeah.
It looks like Kayla is gonna be going live at 7 p.m. tonight, y'all.
Georgia time?
Mm,
Oh, okay.
nah, Florida time. Florida. Well, yeah, Georgia time.
Because she's in Georgia. Yeah, because I know she go back and forth between Georgia and Houston.
So
Thank you so much, Slick. He said y'all go support Simply Time. Oh, so you have a channel.
Yeah, he's trying to be petty.
Wait a minute, what's your channel?
He's trying to be petty.
Hold on.
I have not started yet.
Oh, you have not started yet?
I do have a channel. I go live sometimes. It's really small, so don't.
What you mean? We got to start somewhere?
Don't. But yes, it's just my name. My channel is my name.
Okay, I might. Let me see if I can find it right quick. Okay. Oh, if you don't mind me looking it up.
Look it up.
Oh, okay, okay.
I'm not gonna say nothing to you.
Oh, okay.
I'm petty now. I talk trash. I talk a lot of trash.
Oh, this is nice. So you got your page built up. Okay, this is nice.
So I'm just starting now. It's gonna be just for fun.
So you already got a banner.
Too.
I don't even have a banner.
It's so easy to make. It's so many tutorials.
Right. Yeah, I can make it. I just haven't had to.
It's got to.
Oh, but it's nice. Okay, so yeah, if y'all want to, please go follow Simply Tide. You want me to? Can I drop the link to your channel? Let me see if I can do that.
You can drop the link to my channel. Just know, y'all, I am petty. You argue with me, I'm going to argue back. I'm just joking, y'all. I'm just joking.
Let me put the link right here. I'm gonna put it right here. See if that works. I don't know. Does it let y'all copy and paste the link? I don't know how to.
You can't put it. YouTube don't let you. Well, I don't know. You might be able to because it's your channel, but other people can't copy links in the chat. YouTube like filters it out.
No, he can. Yeah, he can. I see the link.
Oh, so okay.
No, unless you are a mod or it's your channel, you can't post links.
Oh, okay. Yeah, well, it must be working because they. Yeah, they're subbing now.
Look at the people. Hi, thank you guys. It's not a requirement. I don't go live all the time. I have a full-time job, y'all. So, but I do messy Mondays on Mondays.
I heard they take your rent for dropping links.
Yeah, some people do. He's being petty. Don't pay him no mind.
And the whole time you just sat here and didn't say a word all this time.
This is not my channel. This is yours. I came up here to support you. I'm authentic with it.
Yeah, but it's still, I didn't know that you were having you had a whole channel that you was hiding out on. Yeah. Oh, thank y'all. Mr. Don Kettle said he subscribed. Didn't tell nobody nothing. I'm gonna have to go in and watch some of this, Mr.
No, don't do it. I have fun. Nah, I have fun. I make enemies in these. I've made some enemies in these YouTube streets, and I don't know how.
Oh, you do a lot of YouTube shorts.
Yeah, I've done some shorts, not a lot.
Okay, okay.
I can do editing for shorts, though. I've done some of those. I'm just testing the waters out. Like, you want to see what you can do and what you can't do. I really only got into YouTube because my son wants to do it. So I set him up a channel. And I'm like, in order for me to do it for him, I have to learn how to do it myself. So, you know, you get out there and test the waters.
Right.
Oh, now Don did give you a tip. He said you have to maintain 100 AdSense to keep monetization.
Nurse Shell said she had to get permission. Oh, that's what it was. That's why she didn't tell us about it. He said, thank you, everyone. We appreciate it. Yeah. Thank you, Slick, for even mentioning it. I wouldn't have known. He say maintain $100 AdSense
What's
to keep
funny?
on. Yeah, so normally what I do, once the video over, I might turn it on. So anybody that watch it that's not watching it live, then it'll roll the ads. So that way you can still keep that minimum balance right there to keep the AdSense account. So I just want to leave it off completely like the whole time. All right, let me see something. I don't even know how to get to Mr. Don's channel, but I do remember seeing it for
You
sure.
can't click on them?
No, it won't let me click on.
You have to click on him in YouTube. You can't do it in StreamYard.
Oh, okay.
You
That's
go to
what the
him on
issue
YouTube,
is.
like just pull up your YouTube page and click on his comment. Then you can pull up his thing. Cause I just
Okay, let me see. So I go to YouTube. See, I never did it on here. Okay.
hit them 3 dots and it's just why it's not
Oh, yeah, it look way different over here on YouTube. Oh, look at him with the 1.84 thousand subscribers. Shout out to Mr. Don Cato. And he's covering a lot of he do a lot of political. Oh yeah, this is good. See, I don't even know y'all be having channels, and I don't even know how it just happened like that.
We coming over here to show our love to you.
So, well, thank y'all so much. I definitely appreciate it. Don't go unnoticed. Y'all name, I'll be seeing y'all in the chat, and the names are like, okay. Like Mr. Don Cato, I can tell when a name don't pop up for a while. And I remember when you switched your name, I'm like, what in the world? And you like, it's me. I'm like, who is this person trying to come up and don't want to turn on their camera?
I didn't want to turn it on, but I turned it on for you.
Right, because I didn't know. You're right. Because, a lot of times you might have like I don't know what you call them people. A bot.
Yeah.
Yeah, you let them up and they may show something that's not supposed to be showed and get your whole channel took down.
I seen that happen in real time.
Oh, you seen it? Okay, see.
Literally, it happened to somebody. Their channel was immediately like gone.
Immediately, right?
Whole channel deleted. Like
they don't play that, and that's why I always tell people come up with a camera and a mic. Obviously, you need the mic to talk, but the camera, I need to see you to make sure you're a real person and not on some funny business. Let me see. We're going to thank you, Breezy Barbie, for popping in. I seen you earlier. I think I seen you twice earlier. Thank you for still sticking in there. Yeah, we still here. So when I switched my name to Kimberly Griswold, Lady Red. Yeah. But yeah, I'll be seeing in India came in one day and read for us. And that was a long day too. I don't know how we was gonna make it through, but she was kind enough to come up. And when nobody else hit that link, excuse me, it's a long day. Tasha gonna hit that link when she can.
I try to most times,
Yeah, when you can. Yeah, I got you. So y'all go support simply. Thank you again, Slick, for the kindness. I did not know. Oh yeah, so it looked way different on YouTube than when you're on StreamYard. Somebody had a question. Let me see if I can answer it. Now, y'all, I'm not the YouTube expert yet.
Somebody had a question on YouTube.
Yes, no, somebody was asking about the YouTube, like the process or.
Oh, I don't know
He
that.
said, I just do uploads. I'm affiliated with Sobriety and Mental Health Awareness channel with Misunderstood. Okay, shout out to Mr. Don. What did she say? Now, somebody had asked for you. Okay, here we go, Lady Red. Can you set how often it does ads? Yeah, you can do it manually, or you can let YouTube do it automatically. And then even when YouTube does it automatically, you can do it like on a balanced approach where YouTube figures out how many ads they should show, or aggressive when it's like ads back to back to back.
Oh, now that's you just
that's annoying. I hate when people do that.
Yeah, you have some channels. Yeah, it's like ads every 2-3 minutes, and I'm like, okay, well, how you expect somebody to actually get through a video when they gotta watch, ads, that many ads? And now everybody to each their own. I'm not hating on no other channels. Is that what y'all do? That's what y'all do.
Right.
All you gotta do.
Going?
Right? Come on. Spill the tea.
It's hangout time. Just say, y'all. I got a friend's birthday.
Yeah, you look nice.
Yeah.
I'm sorry.
I know you're good. You're good. Oh yeah, she ready to go. See, that's how you know you got a little change in your pocket, when you can go out through the week. That's how they say the business owners, the employees, the bosses, they party through the week, and everybody else go out on the weekends when they get their checks. So if you want to know somebody that got a little change, just a little bit in their pocket, catch them outside in a weekday. Slick said you ain't going nowhere, so go ahead and unravel it. Go ahead and undo that braid.
We're no longer together. I'm finna have fun.
He say, sit it down right now.
Sit it down right now.
Are y'all still like in the same area though, right?
Nah, Slick in Atlanta. I'm in Florida.
Oh, that's down the road. How far is that?
5 hours. He got a long drive. I'd be home and sleep by the time he get here. Slick be in trucks.
I'm not even gonna post that comment. Wild spirit. I'm not gonna. Don't give me the lie, Slick. I can't call it. Yeah. Well, I do appreciate y'all popping up and hanging out. Let's see, who is this?
I know we can't curse on your channel.
Go ahead.
I will not. But
yeah.
Talk that law got the love connection.
We didn't turn this into what's those channels?
Pop the balloon.
Yeah, Pop the Balloon and
20v1.
Listen, you done had you had some nudity on your channel.
I had some what?
A leg shown. You seen that leg that was shown.
Don't really say no. I know. I'm gonna say I know you lying. So what? I didn't take that long of a lunch break. I was still watching the chat. Yeah. Well, I think the time has been well spent. So I do want to thank y'all for coming on. And thank you again, India. India said I was minding my business and you pulled me up out the chat. but I definitely appreciate it.
No, I like it up here. I don't go up on everybody's channel.
Oh, thank you so much for being a willing participant. Some people don't want to come up. They want me to talk to myself.
Yeah, panels are more fun.
But they say you can identify.
All right, y'all. I know y'all finna wrap it up.
Oh yeah. You have fun and be safe out there.
Y'all have a good night.
All right, you too. All right. Thank you, Tasha. Okay. Well, thank you so much, India, and hopefully we can get you back one of these days. You know, we're gonna be here
on Friday.
On Friday, right? Yeah, and I plan on being here. Yeah, God willing, and the creek don't rise. and I can still get my boat across the water. We'll still be here. But thank you, India, so much for coming on and supporting. And all of y'all, if y'all don't mind liking the video, subscribing. Thank y'all to the new people that subscribe. We're just having some fun. We're having some fun. And we got the day off tomorrow. Do y'all even take days off? I know some of y'all be on YouTube, whether I'm on YouTube or not. Y'all gonna be here no matter what. I just hope y'all don't I'm gonna leave this video up, and I know people finna go and say, oh, they were talking about this and talking about that. Yeah, we just having some fun. Ain't nobody talking about nobody in that type of way. Misbehaving, thank you so much. That's kind of you for the super sticker. That's really nice. Good thing I didn't click the off button. I would have saw it. I don't even know how that'll work. Do it. But thank you so much, Misbehaving. And I didn't see 313 on here today. I guess I'll wait till I see her again, but I do want to acknowledge that she did send me a cash out before I logged out, I think on yesterday, but I didn't even realize it was her because the name didn't correlate. The cash out name was different than her YouTube name. And I didn't even know. I had two other cash ups, but I didn't know who that third person was because they didn't have no name. But it was 313, the best side. So shout out to her. But thank you so much, Misbehaving, for supporting the channel with the super sticker. I guess I can go get me some to eat now. Did you hear about Sonia Massey? Yeah, we actually did a video about it. 313 is the guy. No, 313 is not. 313 came up before. Actually, 313 has been up a couple of different times. You must be thinking about 305. Yeah, yeah, it's on. I have to go back and check because I know it was some issues because the video was shown, and I don't know if it was against YouTube. I don't know if it has to be protected or 18 plus or something they wanted done. Oh, absolutely not. Lady Red, if you don't let me get the day off tomorrow, can we do it on Friday, please, Lady Red? Tomorrow, if you have time, can we look back at the Woody first took the stand and Melnick speaking? I can understand a few things from this chapter 17. Ma'am. Maybe we can get some time, maybe a break on Friday, maybe a lunch break or something. We can go in and if you have specific time, if you can go in and look at the timestamps, that'll make it like so much easier. If you want to email it to me, email that to me. It's a long day. Then I can actually take a look at it, and then we can, skim through it when we get a break in there. I'm not even trying to look at this chair this office tomorrow. I'm not studying it. I don't even want to walk past it. But all right, let me get out of here. Let me give y'all my legal disclaimer. Golly, I can't even get my words out so long. Oh my God. Yeah, no problem. No legal advice intended. So don't come tell nobody, oh, he gave me legal advice. You know what I'm telling you? A damn lie. No legal advice intended. I'm a lawyer, but I'm not your lawyer. I'm just here to talk that law. All right, thank y'all so much for all of the support, the new subscribers, the likes, the kind words, the another super sticker. Thank you so much, Go Roro. You can take off tomorrow. You know what? I'm gonna reverse it. You said I can't take off tomorrow. I'm gonna send it back. I will send it back so I can take off tomorrow. What's up? Talk the law, I'm back. You back, Rob, but I'm gone. Yeah. See, I was just gonna get off, but I am gonna get off. But thank y'all so much. Thank you, Go Roro. I will send it. She said, hey, you can't take off tomorrow. I didn't pay you for tomorrow. I didn't pay your salary. Where are you going? Anywhere but YouTube. Let him have a day. Yes, so I can come back renewed and refreshed and ready to go. Yeah, but thank y'all. I stay on just a few minutes longer since you you were kind enough to send it. Rob, when will you be back on? Hopefully Friday. We're shooting for Friday at 8:45 Georgia time, but 7:45 my time. So when court starts 7:45 my time, then I have to get up extra early in the morning. But I had already, made a commitment. I want to push this YouTube, especially while this trial is going on. It's a good trial to cover. We see a lot of stuff of what shouldn't happen in a trial. Breezy said, I know that's right. Lady Reese is 7:45, Kansas City, Missouri. Yeah, I know when said I got 20 for March 2025. Let's go. He said I gotta go catch Tide. All right, y'all. Let me get out of here. But I'll see y'all on the next one. Thank y'all again for the support. And we'll be back hopefully on Friday. Let's go.